initiate chaos theory guarantees that we'll play like lightning shots, sounding like thunder. For every time in the face that it hits us, we're faster. Well, they should know by now. They see the world keeps trying to shake us. It only wakes us. The pendulum swings. The pendulum swings. It's in a beautiful darkness. Only another. It's full steam ahead. Full steam ahead. All above the Petty Express. Misdirected from the start. It's a runaway train. I come a freight train. I come a freight train. In a beautiful darkness, the Petty Express. In a beautiful darkness.
All right, you guys, we are ready for day 10 closing arguments, and we are going to be listening to the jury instructions this time because I think it's going to be very important what elements they have to, what the elements the state has to prove in order to get this first-degree murder charge to go. Because I do see where you could watch this trial and say that they didn't get the premeditated, element in as a layperson would see premeditation, if you don't watch trials and don't realize that premeditation can be the instance before something happens. You don't need to have like a full notebook of premeditation. So I do wonder if that is going to, be an issue or something that the Commonwealth clearly defines for the jury. So let's get into this. There should be audio.
230091, matter continues on jury trial. Council's present in court. Council, starting with the Commonwealth, kindly identify yourselves once again for the court and the record.
Good morning, Your Honor. Greg Connor for the Commonwealth.
Good morning, Counsel.
Good morning, Your Honor. Ann Yaz for the Commonwealth.
Good morning.
Good morning, Your Honor. Tracy Cusick for the Commonwealth.
Good morning.
Good morning, Your Honor. Good morning, everyone. Kelly Porter on behalf of Mr. Walsh.
Good morning.
Good morning, Your Honor. Larry Tipton for Mr. Walsh.
Good morning. We'll wait for Mr. Walsh, but while we're waiting, I'm just going to pass you out a couple of versions of something I want you to look at. I have a preference.
Ooh, orange today.
I don't know how many copies that is, but I think it might be enough. If we need more, I have more. I just put that to the side, Counsel, until we get there.
You're right, sure. Thank you.
All right.
Also, what adult kid, why did his mom get him a tight suit? Ugh.
Good morning, Mr. Walsh. I said good morning to everybody else, so good morning to you, too.
Good morning. Thank you.
So since the version that I sent you at 1:55 p.m., I've made the following edits, either based on prompting by you or by my own accord. So on page 9, the use of a dangerous weapon is out. On page 17, the stipulation, separate instruction, I incorporated that into the evidence instruction. On page, it was on page 19. So what I did is I just added into page 19 some text. It's the second sentence. The evidence consists of the testimony of the witnesses, as you recall it. And then I just added in there the things that were marked as exhibits and the stipulation/agreements of the parties, rather than have it as a separate to-do. Just making it a little bit more streamlined. I edited out the last sentence of graphic photos instruction on page, I think it goes to the top of full page 18 as irrelevant. to this case. And I also have removed the separate section later on page 18 about opinion testimony as repetitive of the expert testimony section above. On page old page. Now I can't find it right away. You may know where it is when you read through it. It says you'll have all the evidence with you. And I removed the non-relevant weapon and put in including the tools. But as I was thinking about that last night, mental note was, what does the Commonwealth, or how does the Commonwealth intend to safely put those tools? So what I've done in other places, or what I've seen done in other places, and it most often comes up in the context of a knife going back. I've seen other DA's offices basically take the knife and it's like they put it on a hard board and then they strap it down. So the jury can see the item but can't hurt themselves unwittingly with the item. It seems that the same could be done of the tools in this case, if you have the capability to do that. I think I've seen that done in Middlesex, Plymouth. That's how they sort of handle the issue. How are you planning on handling it?
We're working on it this morning, Your Honor.
Okay. So what I have in my mind, just so that, and I think law enforcement in the past has done it for the DA's office. So they may have the strapping mechanisms, but as long as I'm assured that they can go in safely.
Ooh, evidence bondage. If you had evidence bondage on your bingo card, I didn't even think of that, but that is now a new topic.
To the jury deliberation room, either with a sheath cover on it or preferably strapped down to a hard board. It seems to me that that would be a good approach. Anybody object to that?
No, Your Honor. We'll work with defense counsel, but we're trying to get some supplies to do that this morning.
All right.
We don't have any objection.
Like a charcuterie board? Yes.
So I passed out to you two versions. I went back to look at different instructions I have. I looked at a few different things, and this relates to the direct and indirect evidence instruction. And the version 1 is what I will call I put this in air quotes, I'll call it the Superior Court version of or what I most often see in the Superior Court, which is different than the District Court version, which is a little clunkier, I think. But anyway, you always like what you like, right? That is probably the more traditional, old-fashioned perhaps. As I read through it last night, I think it reads better than the version that I put into the first draft, but I don't have strong feelings about it. So if we have agreement between the parties as to which one you like better, I'm happy to read that. I think both of them are accurate representations of the law. I have a preference for version 1. Take a look at that and let me know when you've finished looking at them and have an opinion.
I find I'm not too fussed
The
about...
Commonwealth doesn't take a position, neither one seems
Fine.
suitable.
Normally, honestly, I don't spend a lot of time on this in most cases but this case is one that I spent a little more time on it. Yes, Attorney Porges.
Your Honor, we're requesting version 2. So if no one else has a position, I'd ask the court to read that.
All right, which is my version 1, I guess, right? It's the version that was in the instructions yesterday.
I believe so.
All right. Both are correct recitations of the law, so if you wish to draw from any of them, they're all good. And I'm not sure that they make a huge difference. All right. Any other edits to the draft instructions beyond those that I've just incorporated?
Your Honor, on page 12 of the 155 instruction on reaching a verdict, I believe there's some references for each charge, and I would suggest that that might have been a carryover to the plural version.
The four-person,
I have page 12, reaching a verdict, the third paragraph for each charge,
for the charge, yep.
and then has proved every element of the charge beyond a reasonable doubt, then you should find that Mr. Walsh is guilty of the charge or just is guilty.
Okay.
In the next paragraph,
And same thing, particular?
yes, Your Honor, particular, and then the on that charge.
I'll just end it at not.
This is the woman you need if you're like me and you don't spot grammar errors because you make so many and it's just kind of your normal way of typing. This is the woman you need because she's going to find your dangling participle. She is going to find when your verb tenses don't match. She is going to be the one that's going to save you. It's never going to be me. Ever.
Guilty.
At least on grammar.
Your Honor, on page 13, roll of the jury, second paragraph. Do not be influenced by the nature of the,
Charge?
yes, Your Honor.
I think I already made that change. I just didn't tell you I did.
Your Honor, on page 31, alternate jurors, I believe there's a reference to 3, and I believe it's 4.
It is. I made that change later in the day too, and I didn't tell you about that either.
That's all the Commonwealth has identified, Your Honor. Thank you.
Anything additional from the defense?
No, Your Honor, content, except for the previous exceptions made.
Although now I think most of the previous exceptions you made have been removed,
Just being cautious.
but I get the point. All right, let me step off the bench quickly and make these changes. And the reason for that is I want you to each have a all to have a copy so that you can follow along while I'm doing it. It shouldn't take me very long.
All right.
I mean, at least you know she's actually making copies, unlike, Judge Bev, who was definitely adding Baileys to her White Claw. I mean, her coffee. Allegedly in Minecraft, of course.
You are unmuted.
Please.
I like her little lacy doily thing.
All right, all set? Good.
I will say he's looking oddly confident and chipper today. In like those lemmings that don't know that they're going to the edge of the cliff. They're like, we're going to a party. Like he's in the middle somewhere. He just doesn't know that the lemming party. I don't know. he seems much more upright in his posture and oddly confident today. Well, now he's gone back to sloth mode. He admitted to basically the movement of her parts. I guess the dismemberment is kind of assumed in that, because the statute they've got him under is improper conveyance of a body. So again, I don't know if that's because Massachusetts doesn't have a functional statute against dismemberment, or this is how they charge that. But that's let's see, willful misleading of the police, obstruction of justice charge he pled guilty to, and improper conveyance of a body. So again, I'm not sure if that dismemberment is wrapped up into the improper conveyance or how they parsed that out.
All rise. Jurors entering. Hear ye, hear ye, hear ye. All persons having anything to do for the Honorable Justice Diane Frenier, Justice of the Norfolk Superior Court, draw near, give your attendance, and you shall be heard. Let's have the Commonwealth of Massachusetts in this honorable court. Please be seated. Please turn up your cell phones.
Jurors, and welcome back to the House. Jurors will start today, as we have every day together, with the 4 questions. Jurors, were you able to comply with my order that you not be on any social media or any news media?
Yes.
Yes.
And were you able to comply with my order that you not do any research about this case?
Yes.
Are we able to comply with my order that you not speak to anyone about this case?
Yes.
And do you all still have open minds?
Yes.
Open, not empty.
Those 4 answers, for the record, all answered affirmatively by all 16 jurors in the box. We're ready to begin today's work. So as I promised yesterday, jurors, there's 2 chapters that will come interspersed now as we start today. And those chapters are that I will give you the instructions that are specific to the charge of murder here in this case. Then the parties will do their closing arguments. And then, depending on how you're doing, given the time that's passed since then, we may have a short break, the bathroom break. Then I'll come back and give you the more generalized instructions on the law.
So we will be listening very carefully to this instruction on murder for this case, because I do think it's very important, depending on what the state needs to prove to satisfy the first-degree murder. We need to listen to that. Now, the generalized instructions are basically like stipulations are stipulations, blah, blah, blah. Look, my ADHD is not going to handle that. I can handle this short little bit. And then for Verdict Watch, we have several different options, and we will go over those when we get there. But when we get to them actually starting the closing, I do have a closing, case or closing Walshe bingo card. So let's buckle up.
Deliberately break it into 2 chunks. It's more consumable for you that way. The jurors, I want to thank you for your service on this jury. to a person when I've looked over. You caught me many times looking over at you. You've been paying attention, and that's exactly what I anticipated, but it's refreshing and rewarding for me to see it. So I know that you have paid attention to the evidence in this case, and I appreciate your attention. Your jury service in this case is a very important part of our democratic self-government. You are responsible to uphold the law and our principles of justice. That's what you promised to do at the start of this trial when you took an oath as a juror. You've all devoted a substantial period of time on this case, time away from your personal lives, your work, studies, your families, to sit as jurors in this case and to decide the very important matter, an issue now between the Commonwealth and the defendant, Brian Walshe. You've done so in...
Roan, I do think that's a serious question, and that's what I worry about, because I can see both sides. I can see that, again, if I'm looking at just the amount of evidence, the circumstantial, the bit by bit evidence that the state has brought together, I have nothing but to conclude that something very violent happened that day. But there's no concrete evidence, and so I can see it both ways, but I don't think Brian's walking out of there because of some very principled person saying, but the state doesn't have her body. I don't think he's walking out of here. Now, what Brian and his mother believe is going to happen is a whole other Fig Newton of non-imagination.
accordance with the finest traditions and the highest aspirations of our system of justice. Again, I thank you for your service and your sacrifice. You must now consider all of the evidence, decide who and what to believe, and decide whether the prosecution has proved beyond a reasonable doubt that Mr. Walshe is guilty of the crime of murder. The final part of this trial, as I said, will take place in those 3 steps. First, I'll give you on the law that is specific to the charge in this case. Then the attorneys will make their closing arguments, in which they will highlight the evidence that they think is important and will argue in favor of the conclusions that they ask you to make. Defense attorney, Attorney Tipton, will argue first, and the prosecutor, Assistant District Attorney Yaz, will argue last. After the closing arguments, again, I'll give you those generalized instructions that will help guide your evaluation of the evidence and your decision-making and your deliberations as jurors. And then you will work together to reach a unanimous verdict. Please pay careful attention to all of my instructions. All of my instructions are important and you must follow them, whether you agree with them.
At this point, I am not listening to any of her instructions because I am wondering how much hairspray it takes to keep this bit of hair looking very Jackie O and not falling down on her face, because I'm guessing at least 1 to 2 cans of Aquanet. And I'm jealous because I have never achieved either A, this volume, and B, that comb-overy bit. And she pulls it off. Very Jackie O. I'd look like a football helmet.
Or you do not. To make sure that I give you the instructions accurately, you can see that I'm generally reading them to you. You will also get written copies of the jury charge, the jury instructions, in the jury room when you deliberate the case. I do my best to make sure that the instructions that I'm giving you while I'm speaking match these written instructions. If there is any difference between what I say aloud and the written instructions, please follow what I say aloud. So let me start with the prosecution's burden of proof, and I'll start with the presumption of innocence. There is a fundamental rule that applies in all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Mr. Walsh is presumed to be innocent of the charge in this case. That means that you must consider Mr. Walsh to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at the trial that Mr. Walsh committed the crime charged. And I will explain what I mean by reasonable doubt in a minute. Mr. Walsh does not have to do anything to convince you he is innocent. He does not have to explain anything to the jury. Mr. Walsh does not have to testify, call or question witnesses, or provide any evidence at all, because you must presume he is innocent. Instead, it is up to the Commonwealth to prove the charge against Mr. Walsh beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all of the evidence carefully and fairly, if you have a reasonable doubt about Mr. Walsh's guilt on the charge of murder, then your verdict must be not guilty. You may find Mr. Walsh guilty of the charge of murder. Only
Be safe,
if
Tammy.
all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. So, the burden is on the Commonwealth to prove beyond a reasonable doubt that Mr. Walsh is guilty of the charge made against him. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though not easily defined.
Granny Smith, as far as I know, the judge yesterday, and I do believe the day before, reaffirmed, because it was actually the Commonwealth that motioned for the defense and the Commonwealth to not be able to tell the jury that he had pled. So I believe that they renewed that. So I don't think either of the sides are allowed to say that he pled guilty, because basically the judge explained it in such a way that the jury is supposed to be paying attention only to the evidence that they looked at, and because they know that he has already pled guilty, it might get them to thinking about potential consequences or sentences that he's looking at, and that's definitely not part of their purview. So in order to, shy away from that issue altogether, she just said, we won't be talking about this, because basically, because he's pled to both of those things, it has bypassed the jury entirely, and now she will be the one passing sentence. That's at least how I understood it broken down. Lawyer, or Emily D. Baker might have a more, lawful law breakdown, but that's kind of what I understood it about, or understood that. And welcome, Vicky. Not a whole lot, that's probably going to be different from the other coverages. We have been scratching our heads at this defense the entire time and are now waiting to see the dumpster fire of closing that the defense is going to bring forward.
Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, or everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proof beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden is on the prosecutor. If you evaluate all of the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty. A certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That's what I mean by proof beyond a reasonable doubt. There's one indictment or charge in this case. You must decide whether Mr. Walsh is guilty of that charge. For the charge of murder, there are certain things, we call them elements, that the Commonwealth must prove beyond a reasonable doubt to show Mr. Walsh is guilty. I will explain these legal rules to you now. There are two different degrees of murder. Murder in the first degree and murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder.
Okay, this actually does make a lot of sense, and a lot of states will have this kind of different depending on how they name things or how they do lesser included. So I was wondering if there would be the lesser and included. Now, for first degree murder, there has to be premeditation. Now, I'm sure the Commonwealth will go into what standards they have for premeditation. For second degree murder, it's considered more a crime of passion, which I think might be something that the jury will be maybe easier for them to accept. Now, there were examples that, Brian looked up William Fastow on, Christmas and things like that, that he might have been aware of the possibility of an affair. I don't know if that equals into premeditation, but I'm not a juror, so look, it's not my choice to decide, but I do like that there are lesser includeds because I didn't want to end up with a Casey Anthony sort of situation where had the lesser included of crime of passion or something like that been in there, Brian wouldn't walk free. So I'm glad that this
Wealth alleges that the defendant committed murder in the first degree on a theory of deliberate premeditation. To find the defendant guilty on this theory of murder, you must be unanimous. That is, all of the deliberating jurors must agree that the Commonwealth has met its burden of proving every element of this theory beyond a reasonable doubt. If you are unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt this theory of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. I'll begin by instructing you now on the elements and the additional requirements for the proof of murder in the first degree with deliberate premeditation, and then I will next instruct you on murder in the second degree. Murder with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following three elements. First, that the defendant caused the death of Anna Walsh. Second, that the defendant intended to kill Anna Walsh. That is, the defendant consciously and purposefully caused Anna Walsh.
And this is where I think a lot of people get premeditated wrong. I know I did before I was watching trials, before I was listening to lawyers, because I assumed, you had to have like the murder board with all the little, cut up newspaper stuff. And it is kind of having to shift your whole way of thinking when you realize that premeditated can be you intend for this to have a fatal consequence. You picked up that knife or whatever tool or whatever happened, but you intended Anna not walk away from this.
Walsh's death. And third, the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. I will now discuss each of those requirements in more detail. The first element is that the defendant caused the death of Anna Walsh. A defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred.
I think
The
we can mark
second element
check.
that the defendant intended to kill Anna Walshe. That is, the defendant consciously and purposefully intended to cause Anna Walshe's death. The third element is that the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration whether to kill. Second, the decision to kill. And third, the killing arising from that decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then decides to do it. Murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. First, that the defendant caused the death of Anna Walshe. Second, that the defendant A, intended to kill Anna Walshe, or B, intended to cause grievous bodily harm to Anna Walshe, or C, intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail.
Okay, so now we know what the Commonwealth, I really did want to know exactly what she was going to say about premeditation. And y'all, it is too cold to be sitting here listening to her talk about, this is kind of boilerplate stuff that we have seen in other trials. I do want to get to the closings. Please tell me that old man Grandpa Simpson can find the mic. All right, get your drinks, get your snacks, get your Quaaludes, allegedly in Minecraft. Buckle in, y'all. Looks like we're going defense
You
first.
haven't been sitting there that long. You're going to go for a stretch now. So I'm going to ask you to stand up. And, as I've said to you before, shake a leg.
Oh, God. Well, we avoided it for just a little bit.
With that, we'll turn to the closing arguments. As is the custom, we'll hear first from the defense. Attorney Tipton.
Oh, God, brace yourselves, my children.
What could happen to a loving father and a loving husband?
We're making line of police before they
Search for the unspeakable on the internet.
exposed body of the woman that you adored. Government suggests it was an affair. There's no proof of that. There's no proof that Brian Walsh knew anything about an affair between the woman he loved and William Pence.
Okay, let me see if Law and Crime has had better audio, but let's see if Court TV has better audio, because for the love of Cheetos and gummies, as much as I don't want to hear this man's ridiculousness, let's actually listen to this ridiculousness for its final time. Okay, yes, Court TV is a little bit better. I think we're winging it. Y'all know I'm a genius at this stuff.
To a loving father and a loving husband. We're making line of police before days. Search for the unspeakable on the internet. Exposed body of the woman that you adore. Government suggests it was an affair. There's no proof of that. There's no proof that Brian Walsh knew anything about an affair between the woman he loved and William Tesser. Money? Second reason that the government suggests. Family money? Money that the family had worked together for years and continued to talk about in text messages and the sales of property, trying to protect the assets for the benefit of the whole family and the future of their 3 children. A motive? There's no motive. Refusal to consider prison for a terrible mistake he made. The case that began in 2018. There's no proof of that he was afraid to go to prison. Who wants to go to prison? But prison was always on the table.
It continues to be on the table. Prison is more on the table than that Lord of the Ring meme being used. Basically, Brian should be hearing, "We're off to Isengard, we're off to Isengard, we're off to Isengard." That's all he should be hearing as the orcs are taking his ass away.
And it was just something that he had to face up to, and something that he did. So, what would cause a loving husband and a loving father to do the things that you heard about in this case? Could it be something that was sudden, something that was unexpected, something that was unbelievable, something that only a medical examiner would understand, have knowledge of?
Again, I make this point. If only there was this number that Brian could have called when he found her, dead, and he could have said, "Hello, hello, my wife looks like she's asleep, but she's not breathing. Yes, I can do CPR, staying alive. And then they would send people, like medical people. No, holy shit, hear me out. So they would send medical people to take Anna and try to assist her in the hospital. Now, if they were unable to do that, what if, holy shit, you guys, there was this person whose only job, no, hear me out, his only job is to look at dead people that we don't know how they died, and then he could tell us. I mean, if only we lived in a world that had those things.
But not a man like Brian Walsh. Something that is terrifying, something that defies logic when it happens. How do we know that Mr. Walsh was a loving father and a loving husband? We know from
Porsche. It's a drinking game. I don't recommend it, but every time he says Porsche and ring, go ahead and take a drink. Allegedly in Minecraft, though I don't endorse it, you will end up plastered, I'm sure.
Much of the testimony of Jim Mutlow. We know from simple testimony from Julie Basler from Kindergarten. When asked questions about her experience with Mr. Walsh and the children, that he would show up and he'd be interested and he'd be friendly. And he was always interested in the progress of his.
You can go ahead and mark Grandpa Yell's cursed audio, what federal case, and let's see. If only there was a body.
Children. And how do we know he was a good father? Because Anna Walsh trusted him with their 3 children. 24 hours a day, 7 days a week, for all those times she was up in Washington, D.C. The unthinkable happens. It happens in a variety of ways. In the Commonwealth.
All right, if he does say autoerotic asphyxiation during closing, I will take a drink. Now, normally I'm not a drink on stream kind of person, but if a miracle happens and this does happen to be an autoerotic asphyxiation close, I will drink.
Must prove to you beyond a reasonable doubt that a homicide occurred, that a killing occurred. Nothing proves that beyond a reasonable doubt on the facts and circumstances and the evidence given to you. There's evidence that he lied to the police. There's evidence that he searched the internet. There's evidence that he disposed of a body. But there is no proof in all of the evidence that you have heard and been presented that he ever once thought about harming the woman he loved. That he ever thought about harming the woman he loved. That he ever planned to harm. That he ever intended to harm.
Okay, call me crazy. And look, I'm not a good humaner. I tend to kind of miss a lot of social cues. But I don't think one of those love languages is dismemberment. But, I mean, maybe I'm confused.
So, when we talk about the evidence of the affair, when we talk about evidence of financial concerns, when we talk about evidence of being ready to go to prison, those are the motives that the Commonwealth needs to prove to you to support any notion that a loving husband and a loving father would kill his wife. And the evidence suggests there was no motive at all. And without a motive, without...
Sir, you happen to live in a state that contains Baltimore. I think you, as well as any other public defender, will know that there doesn't need to be a reason for an unaliving. I mean, there does need to be, you know, a bit of a motive for first degree, but it doesn't. You live in a state that it contains Baltimore, for the love of Cheetos.
A reason that is based on facts and circumstances, logic and understanding. Without that, you have a sudden and unexpected event that results in confusion, and panic, and fear. All of those things that are so troubling and horrific that you've heard evidence about, they may be argued that they show consciousness of guilt.
Just 1000% consciousness of guilt. In fact, what was the reason that he caught her up, lied to the cops, if not to hide his guilt? It's almost like he was conscious that most normal people don't flippin' slice and dice their wives and make a scavenger hunt to go cash, geocaching with their children for mommy's steamer. Yeah, it's almost like that's a bit of a consciousness of guilt. I mean, I don't want... Brian was what we like to call not subtle.
But people do things, terrible things sometimes, not out of guilt, but out of fear, out of disbelief, out of confusion. Certainly, a loving father and a loving husband would feel guilty about what he did do. Not just about lying to the police, but what he did do in the context of what he did to the woman he loved. In a moment, in hours, and in days of confusion and disbelief and horror.
Yeah, you could probably. So here's where the defense falls apart. You can probably say that, yes, he was panicked in the moments after. The rational, organized, and deliberate, calculated way he tried to mislead everyone, and the thousands of dollars that he spent on multiple Red Run kits, you know, along with the days-long dismemberment process, you can't maintain hysteria for days on end. It kind of stretches reality, especially when he's both hysterical and, you know, in shock, but is able to create these elaborate stories and talk to a bunch of different people and maintain calm, cool, collected, you know, information. Sure, Jan. Horror, disbelief.
But that feeling of guilt had nothing to do with the killing, because he never killed Anna Walsh. You will hear arguments that you've seen the evidence that might evoke emotion. Who wouldn't feel emotional in what you've heard, what you've seen? But your obligation, and I don't mean to sound like I'm lecturing you at all.
Yes, he does. Yes, he in fact does. What he is hoping is that your mind will be so open that it is in fact empty.
Will instruct you on the law, and that is not my province, but you cannot base your verdict on sympathy for Anna Walsh. You can't base your verdict on anger to what Mr. Walsh did. You can't base your verdict on passion, based on the evidence that you've heard that is upsetting and terrifying and at times disgusting. But that's not what you can do as jurors in this case. At the beginning of this case, when you were sworn as jurors, you might not recall it, but the clerk of this court read you some words.
Trust Me, Bro, by Cato Kalin.
To this indictment, the defendant pleads not guilty. He places himself before this country which you are, the obligation that you have accepted in this case is unlike perhaps any obligation that you've ever accepted in your life. Perhaps. That's for you to judge. But your obligation requires that without passion and without anger and without sympathy, that you assess the facts as troubling as they are, and at times as horrific as they are, and make your verdict rest on the evidence, and nothing less and nothing more. Unbelievable, facts that don't make sense at times, something that is incongruent. An example of that is the end of Mr. Jim Lutlow's testimony, where for almost an hour, he talks beautifully about the love between these two people, that he talked glowingly about Mr. Walsh. And then toward the end of his examination, He wanted to say something about now he was thinking there might have been some kind of problem. And reflect upon the evidence that he gave of a phone call he had with Mr. Walsh on the 4th, when the conversation was confusing to Mr. Mutlow, confusing where he kept asking what could have happened that would result in Anna Walsh leaving. The lie that Mr. Walsh was telling people out of fear that no one was going to believe him about what happened, so he lied. But consider the way that Mr. Mutlow had a terrible time trying to understand that. And why? Because he knew both of them. Because what he was thinking, why would Anna Walsh leave? They love each other.
No, what he was thinking at first was commercial real estate doesn't generally open and wouldn't have emergencies that would require Anna to go back. Now, I know that you have done this selective hearing thing where you think that he spoke glowingly of Brian. He was kind of tepid on Brian. Now, I guess you were listening with your Sarah Boone ears, and that's why you heard only positive things.
I know them both. It makes no sense. And that is what happens when something happens that is totally confusing. You just can't believe it. And you seek answers. You yearn for answers that make sense of something. And when something sudden and unexpected happens, something tragic, your ability to come to terms with it, when it's such a dynamic, such a tragedy.
The defense is playing with fire, and let me explain here. Now, y'all know me if you know me. I lost my first husband, and having had to deal with that very intimate, grief and kind of dealing with all of the ins and outs, you can say as a person, both with, familial and personal experience, that there's no way in hell. I know exactly how devastated I was. I was not, moved to get a hacksaw. I was not moved to go to Lowe's. I was not moved to, get an entire roll of trash bags. No, I was willing to wait and let the medical examiner do his job. Now, we've all known we've had relatives, we've known someone who passed, unexpectedly or in their sleep or without a lot of answers. And, 99 times out of 100, you call the medical examiner and they can find an answer, or they can at least give you some idea. The only reason he couldn't show the body is because there was some indication that that was a violent death. In my opinion, speculation, the state didn't prove it, but that is the only reason in my book why you wouldn't call the medical examiner. If she had really died in her sleep, there would be no problem getting her examined.
You change. You change. The evidence of the searches. The dark, troubling evidence of the searches. They began at 4:52 a.m. on January 1st of 2023. And the first one is, how do you dispose of a body? It causes chills. It causes disgust. Look at all of those searches. Think of how they evolved.
Bold move, Cletus. Yeah, go ahead. Look deeply into the dismembo searches. Comb through those intimately. And then realize that my client he just had a little bit of hysterical grief dismemberment disorder.
Consider how they go from one subject to another in rapid fashion. Searches conducted by a man that is in disbelief, in confusion. 5 hours spending with his wife on New Year's Eve, enjoying life, talking about the future. And then the sudden and unexpected tragedy happens, and it doesn't make sense. If Mr. Walsh began to make those searches with murder in his heart as a result of murder, then why isn't the first search how to dispose of a body after murder? Because that's
This is not real. Where is Ashton Kutcher? Someone is getting ready to punk me. If he didn't Google murder, you must acquit. If he didn't Google it, you must acquit. Jesus, Mary, and Joseph, All right, you know what? I'll drink to that one. That, I hadn't thought of that particular angle in this particular case, your lawyerliness. You know what? I'll be back, y'all.
search that occurred 6 hours later. And when you see that word murder, no one would not react to that word. And certainly as jurors in this matter, you're expected to react in a way to that. What does that mean? Does that mean that he in fact murdered his wife? But think about it in context.
You also learned that the defendant had no assets. He told Jammu.
Logical to suggest that he cleaned.
Sorry, my butt moved the clicker because, well, who didn't? Yes, so let's see here. I have some raspberry elderberry, or elderflower, not elderberry. I was like, I don't think that's right. Yes, we will rerun that. Sorry. Jeff had his own little system set up. Now, you guys, I am not a big drinker, so this is a little tinky dinky shot, but he didn't Google murder, innocent, y'all. I did not have that on the bingo card because honestly, I could not get my mental acuity that low to make that argument. So let's. All right. Here we go. Back with the he didn't Google it, so you must acquit.
The dark, troubling evidence of the searches. They began at 4:52 a.m. on January 1st of 2023. And the first one is, how do you dispose of a body? It causes chills. It causes disgust. Look at all of those searches. Think of how they evolved. Consider how they go from one subject to another in rapid fashion. Searches conducted by a man that is in disbelief, in confusion. 5 hours spending with his wife on New Year's Eve, enjoying life, talking about the future. And then the sudden and unexpected tragedy happens, and it doesn't make sense. If Mr. Walsh began to make those searches with murder in his heart as a result of murder, then why isn't the first search how to dispose of a body after murder? Because that's
The Johnny Cochran that we all deserve. It's not if the glove don't fit, you must acquit. It's if he didn't Google it, you must acquit.
the search that occurred 6 hours later. And when you see that word murder, no one would not react to that word. And certainly as jurors in this matter, you're expected to react in a way to that. What does that mean? Does that mean that he in fact murdered his wife? But think about it in context. If this,
Even if he typed it, you can't indict it. Good God. What the hell is this? Why are we sitting here? If I would have burst out laughing in the jury. This is
case on these facts, context matters. And so the first time the word murder is used in these horrific searches is 6 hours after they began. And I tried to ask Trooper Garino, one of the forensic specialists, as he called himself, associated with the Mass State Police. I tried to ask him, well, it's only logical, isn't it, that if you don't get results, you change the wording. We all know that from our own common experience. And you look at those searches that...
Wait, the search database for dismemberment advice is so at such a depth and breadth that you need to really be very pedantic in your word search, your terms, because there's a whole different database if it's a natural dismemberment and a... Where the hell are you going with this, sir? Not even Carmen Sandiego can get the GPS of where in Narnia you are taking us.
Came and went during this time, and the results had to do with funeral parlors and cemeteries and things like that. Mr. Walsh, given the tragedy that occurred to his wife, and given the time that had passed and his fear and disbelief, he couldn't call a funeral parlor. We need to try to understand, what can I do? Then the searches become darker. They become more upsetting. Now the thought is dismemberment. And there's searches like that. You've heard about them. You'll read about them. And then you see searches that cover days. And there's searches about cleaning. And there's searches about how to clean up. You'll read them. And even though they don't talk about murder, they are equally upsetting, because you're thinking, as jurors in this case, he's thinking about cleaning up the basement. He's thinking about how you clean a concrete floor.
Which is why I, as his defense attorney, made sure to focus on the fact that the state didn't find anything in his bedroom and didn't test his comforter of horror. I'm a good lawyer.
Context. 1,034 pages of digital data, 3,667 records.
I mean, it is a bold strategy to say how many gigabytes of, well, damning evidence your defendant has against him in your closing statement. I mean, it's a bold strategy, Cotton. Let's see how it works out for him.
Taken from his MacBook. Not one record, not one page refers to any plan Not one record, not one page refers to any intent to kill. Nothing. So keep it in
He didn't look up premeditated. Wonderful.
context when you review. I suggest to you respectfully, you are the jurors. What is the evidence of premeditation? There's evidence of a knife. There's evidence of a knife that is seen in a kitchen cabinet. Could I please have exhibit 201? And next exhibit 202. And finally exhibit 203. The knife. It was above a refrigerator. It was in plain view. Had no visual red blood stain. And yet the government wants you to think about this knife. So think about it. Don't ignore it. Do not refuse to consider it. Of course you will, but think about it. In a cabinet above a refrigerator. And they first test it with some screening test. It doesn't prove that it has even blood on it. And they take it, and they should. And then, what happens is everybody loses interest with the knife. Everybody, the Mass State Police, the crime lab. There's no further testing of this knife. And ask yourself, if that knife is to be considered a weapon used, then why is it in that cabinet? You have heard.
No, they basically found a knife, and given that Brian decided to, leave 10 bags of trash at mommy's house, they basically took everything. But after about the 8th tool that they tested with, I'm trying to be delicate, but honks of Anna on it, they kind of figured they had your client dead to rights.
Evidence of bags and bags being thrown in dumpsters over a period of days. The government wants you to think that Mr. Walshe killed his wife and perhaps used this knife. Then why was it sitting in a cabinet days later in open view for the police? What?
Your client hasn't shown himself to be smart. So, or, actually do a good job cleaning. So it's not beyond the realm of possibility to assume that your client just got lazy.
Logic is that. And there is no proof that it had one piece of biological evidence on it tied to any killing or any harm. And they simply lost interest in it. You can take it down now. Digital data, talked about that briefly, but there is nothing in that data. All of that data. And we're talking about text messages. We're talking about backbook searches. We're talking about the life that's embodied in computers that this day and age we know apparently keep track of everything we do and to some extent everything we think about. Because that's how the government is using that data.
When did he go full Dale Gribble? I'm waiting for him to say, "My name is Rusty Shackelford." He's kind of, I'm kind of warming up to him with his general governmental hate and disdain, but the fact that he can't use logic just kills the whole appeal for me.
They ask you to look at certain things and indicate and try to argue that, oh, this is what he was thinking. So look at it and judge for yourself. What's in this data that demonstrates premeditation or intent to kill or intent to harm?
mean, it's more intent to disarm, but chink.
You have heard and seen much physical evidence. You've seen pictures of gray slippers with blood on them. You've seen pictures of all kinds of physical evidence.
Ah,
And if the argument is made by the government, something about a dark gray slipper with blood on it indicates that a murder happened because, listen to the argument, of course you will. But a theory, an opinion, does not make it true. And to suggest something like, the evidence shows that Mr. Walshe went and bought a Tyvek suit, and maybe there's just not enough blood on the Tyvek suit to satisfy the Commonwealth, and so they suggest that some killing happened, and that's why there's so much blood on that slipper and those slippers and all that other evidence. But ask yourself, what do I know about that evidence now?
what is evidence? I mean, you might have 10, 11 bags of it. But what really is it? I mean, the government's going to try to lie and tell you that they collected it and show you pictures. But it's the government. They own Kodak.
From what we heard, every piece of evidence was put into a bag, but then was put into a compactor eventually, and was pressed together and then found. And you will see all of this evidence of when they pulled it out of dumpsters and unloaded the bags, and they first put it on damp ground without any paper below it, without any tarp below it. And you heard from no less than 3 witnesses. Mr. Gould from the Mass State Police Crime Lab, Mr. Sheehan from the Mass State Police Crime Lab, and Ms. Celine from the DNA unit. They all consistently said cross-contamination or transfer. They used different terms, but they all agreed. So the evidence, the physical aspect of the evidence, the thing you see in the photographs, the thing you see now, if you open up one of the bags and take things out, is not representative, or may not be representative, of how it looked before. And you must consider that. So when the government makes an argument based on the state of the physical evidence as it appears now, ask yourself, maybe that makes sense, but maybe there's another way of thinking about it. And why is that important to your deliberations? Because you are allowed to rely on what's called circumstantial evidence. You're allowed to rely on inferences. And Her Honor will instruct you on that. I will not. But whatever reason and basis you have for making your choice and determining your decision must be reasonable. And if you, as jurors, talking amongst yourselves, find that some of your fellow jurors say, well, I think maybe it means this, and I believe this, and your other jurors, fellow jurors, say, I think this, and I believe this.
Okay, how many people do we think that the jury's going to go, gosh, we have wildly divergent ideas of what happened here? Do you think we're going to go in and the jury's going to take an hour to say, what the fuck was that defense? Look at each other and basically spend an hour roasting this defense and then come back, get their free lunch, get their lunch. Not that it's free. I mean, they have had to work and listen to Grandpa Simpson tilt at windmills for an hour. But yeah, I don't think there's going to be, I don't think we're going to be pushed to fisticuffs on the violent disagreements between the jury.
You'll all consider it, but if you don't agree, then you have to ask yourself, is that inference reasonable? Is that circumstantial evidence built upon inference? Is that reasonable? And can I use that? And should I use that to try to reach a verdict under a standard of reasonable doubt or moral certainty.
Oh, he's Shatnering the shit out of this. Look at this pregnant pause. Dramatic pause.
What is the evidence that something violent happened in this house?
Seriously, dude? The fact that there's a rug saturated with AB positive, the fact that there's clippers, snippers, a hatchet, a hammer, a hacksaw full of chunks of Anna, that there's, hair clumps, plural clumps, that there's tissue in a dumpster. I mean, I don't know. Where is the evidence? You're right.
I went through every room as best I could with Mr. Sheehan.
Yes, WTF is on the
There
bingo
was
card.
nothing found in the upstairs.
No, you went through Brian's room and the second floor. The basement seems to be where he did the dismemberology. Where they kept finding blood stains all over the basement floor. Now, he probably had the plastic wrap and, he tried to do a bit of dextering down there.
Bedroom. There was nothing found in the sinks and basins, showers, of multiple bathrooms. Nothing found, meaning biological evidence that might indicate something violent occurred. There was nothing found in the kitchen other than a knife that they lost interest in. There was nothing found in the living room that had padding around the fireplace to protect the children from falling. There was nothing in that bedroom where Anna Walshe, Brian Walshe, as adults, enjoyed their life together and had spent their life together, perhaps every night, before she moved to D.C. to take that job. How do we know that? We know that because the photographs show there was
God,
nothing
how much
there.
longer?
Even what was characterized as red-brown stains on curtains in the bedroom turned out not to be blood at all. We know that because trained examiners from the Mass State Police examined probably every square
We're
inch of
going
the
up to
house.
1.25.
We know that because we saw photographs in her testimony about floor that was dug up based on their experience and training. That biological evidence, like blood, can fall between the cracks of flooring and reside on the subfloor. And so they tore the floor up, and you saw those photographs, and you'll have them. And nothing was found. Nothing at all. I asked Mr. Sheehan about blood spatter, and he forthrightly and honestly said, I'm not a blood spatter expert. But he explained it sufficiently to you. Someone wielding a knife or a weapon and causes blood to let out of a body, and you look for blood that has spattered with directionality. Nothing. Nothing in the bedroom, nothing in the living room, nothing in the bathrooms. No evidence that blood drained down the drains. Could I have Exhibit 217, please? That test that I asked Mr. Sheehan about, the Serotek Hem test, that checks for hemoglobin, for blood. That test, he agreed, can detect blood at the sensitivity of 20 nanograms per milliliter. 20 nanograms. A nanogram, as he agreed, 1/1000th of a gram. Think of how minuscule that is. And they used that all over the house. And so the government...
No, they didn't use that particular test all over the house, you absolute jackass. I was hoping that you had been watching, or at least selectively watching, parts of this trial. Okay, this is the part, again, where the defense is playing with fire. Now, I don't know about other people, but I do know about myself. And myself as a juror, there is nothing that pisses me off or I find more irritating than someone absolutely misstating what was shown to me, particularly where he's going on and on about these other floors in the house and avoiding the basement. Now, insulting the jury's intelligence is, hey, it's a strategy, but I don't think it's going to work. And if I'm a jury member right now, I feel like he's insulting my intelligence. I feel like he thinks I am dumb enough to listen to this.
Elicited questions and answers from many of their state police, the 10 or 20. They didn't call everybody. That's up to them. But apparently there was no need to, because 10 people or more, as Mr. Sheehan had described to you, he was estimating. He was trying to be as honest as he could and credible, and he was. 10 people pouring over that house all day on January 8th. 10 more people or more pouring over that house on January 9th with their tools and their experience, and they don't find anything except multiple bloodstains. Where? In the basement. In the basement. On the concrete floor. Ask yourself, when you heard testimony that Mr. Walsh attempted to clean, and so therefore they couldn't find evidence in the other parts of the house because he cleaned it. Well, ask yourself, wait a minute. Is that logical to suggest that he cleaned the bedroom up so well nobody could find a thing? He cleaned the living room.
No, again, he got almost $1,000 worth of a red rum kit. I think at least between the reusable plastic tarps that he bought at 2 different locations, he had enough plastic wrap that in theory, had he done a good damn job, there shouldn't have been any evidence left over. So yes, God, this is the dumbest defense this is dumber than Daryl Brooks. Change my mind. Daryl Brooks did better in his defense. And I never thought I'd say that.
Where the rug may have been, and they couldn't find anything. Well, then you see those searches where he searches specifically for how to clean concrete. So you might infer, and it might be a reasonable inference, that he attempted to clean that concrete floor. And yet, what was found on the concrete floor? Multiple red-brown stains that turned out to be blood, and in some instances, we can all agree, based on the testimony of Ms. Salim, the profile of those blood drops matched the profiles of Anna Walsh. So to suggest that Mr. Walsh did everything he could to clean the basement concrete floor with hydrogen peroxide and mops and cleaning fluids, only to have...
No. What we are saying is that he bought all this stuff, but he's lazy as all get out because mommy's always done whatever he needed her to do. So yeah, he did buy all this stuff. He could have, in theory, again, hidden a lot of evidence, but because he was lazy, we found it. I mean, I've never seen a defense attorney basically say, my client is terrible at cleaning up his own mess. But he didn't kill anyone. He was just messy.
Blood found on the floor defies a reasonable inference that he was able to clean any part of that house. Sufficient.
UK Anton, you missed the drinkable argument that we all missed. That Brian Walsh did not start out his dismembo search by typing in the word murder. And if he had murdered her, wouldn't he type that into Google? So in the spirit of Johnny Cochran, if he didn't Google it, you must acquit. Then we did, they didn't find any evidence of violence in the house. What evidence is there of violence in the house, and what evidence is there of murder?
To avoid detection. And why is that important? Because nothing violent happened in that house, and that's why there is no biological or blood evidence anywhere in that house.
Other than the
act
basement.
of trying to hide the body of his wife and the blood evidence that is seen on that carpet. That's what happened. There's no blood in the living room. The inference might be that the carpet was taken downstairs. Because you can look at those.
Wait, we can make inferences to make this a dismemberment case, but not a murder. But if we dare try to infer anything from the Commonwealth, well, then there's just no evidence, is there? You guys, I'm pretty sure I'm not smelling burnt toast. What in the hell is this? I have genuinely never been this what the fucked on a closing.
You can look at the physical pieces of carpet and you should. If there is no evidence of who killed it, and there's no evidence.
Jesus Christ, he just told them to take the pieces of carpet, you know, the ones that have like decomposed human bits on them, clumps, I believe is what they were characterized as. He's like, go back, look at them, smell them. You won't smell murder. Jesus Christ, what is that? Has he been checked for it? Why is this man allowed to drive? Has someone done a cognitive test on this man? And look, I'm not trying to make fun of, look, I just lost a relative to dementia, so seriously, what the fuck is this?
That anything was done before Mrs. Walshe died. And there's no evidence of premeditation or anything. There is evidence of lying and disposing of the body. You can take that one. So now we look at the evidence, and I'm just going to characterize it. Some of the evidence that the Commonwealth has presented to you, and there is no question that their obligation is to present to you evidence. But I just ask you to think about, in some cases, how that evidence was presented to you. And I'm going to use a phrase that may or may not be entirely accurate, but it's cherry picking. It's looking at thousands of points of data and asking you to think about it, but not telling you why you should think about it. And what am I talking about specifically? And I'll give you some examples.
Oh, you could talk Atlantically, Pacifically, dead ocean, the Red Ocean, the Black Sea. Nowhere on earth does your argument make sense.
I already talked about the hole in the ceiling, but let's talk about it a minute. They kept talking to you about that hole in the bedroom ceiling as if it was of some significance.
You guys, no. Look, Hagatha the leg is done. I am done. No, we are saving our sanity.
There is no evidence in all
righty.
women that he loved.
And
how does it go?
Seems like we're going about the same.
Well, I don't know if I love them as much as I used to. Those are her words. I'm paraphrasing, but that was the gist.
Sounds like something I would say.
And what are the words? What a year. And yet we are still here.
Oh my God.
186. Record 682. That's the data.
All right. Well, I think we have an expert speaker on what exactly would like to insert their opinion or give their professional opinion about that closing. And here we are, the judge of this closing.
What you just said is one of the most insanely idiotic things I have ever heard. At no point in your rambling, incoherent response were you even close to anything that could be considered a rational thought. Everyone in this room is now dumber for having listened to it. I award you no points, and may God have mercy on your soul. What you just said.
I will probably go back and listen to the full entirety of the closing, but y'all, I can't. I cannot. There is nothing more insulting to me than when you insult my intelligence. And if I'm going to put in the time, like the jury did, to take all the notes, and then for you to accuse the Commonwealth of cherry picking, as you cherry pick, not mentioning anything about the basement of the house, or all of the murder kit that he bought, or all of the times he talked to mommy. No, no. And here's the problem that I can see. The jury could start to see this as so insulting an argument that it is not only disrespectful to the jury, but the jury could interpret this as being incredibly disrespectful to Anna. The jury could interpret this, again, with all the facts and evidence presented, that here is a jealous, incredibly vindictive little man who found out his wife was having an affair and decided that, taking her body wasn't enough, taking her away from her children wasn't enough. Now he is going to try to pull this farcical, ridiculous story, all while touting himself as father and husband of the year, to rewrite the story of their not great marriage. Again, the defense doesn't know. I mean, neither does the Commonwealth, but this is sort of the potluck, the gamble that you're taking with a jury. Is there are things to me that are so, offensive, like treating me like I'm stupid, or trying to cherry pick facts and then say the other side is cherry picking. When you are ostensibly lying to my face about the facts that I've written down, I will no longer listen to you. And I do think that the defense, again, with going with old man Simpson, tilting at windmills, they are playing with fire. I don't know, and maybe I'm not the litmus test for normal, but I can tell you, if I were a juror, if I were working hard and I had taken a bunch of notes and I thought I knew about this evidence, and I can see the defense intentionally ignoring a lot of evidence, it would irritate me. It would very much irritate me. So let's see. We are going to go back to normal speed for Ambien Lady, because I think we all need a blood pressure detox.
Everyone good? When you're ready, you may be seated. Yeah, we'll hear the closing argument of the Commonwealth. ADA, yes.
Ooh, leopard.
You may proceed.
Thank you, Your Honor. Anna Walsh is dead. Anna Walsh is dead because he murdered her, and he intended her death. Anna Walsh is not missing. She never walked out of her class at home on January 1st of 2023 between 6 and 7 a.m. to take an Uber to Logan Airport. She wasn't going to D.C. for a work emergency. There was no emergency. She didn't say goodbye to her son. That's just a story that the defendant told people. But since January 1st, Anna Walsh has not been seen by her friends, her co-workers, or by the people who love her. Anna didn't take an Uber. She didn't take a Lyft. She hasn't used her phone. Her phone's had no contact with the Verizon network since January 2nd, 2023, when it was in the vicinity of 516 Chief Justice Cushing Highway. She hasn't used her bank accounts, her passports, her credit cards, her email. She didn't vanish. The defendant was the only adult in 516 Chief Justice Cushing Highway after Jim Boo left around 1:30 a.m. on New Year's Day. And after he left, Anna was home alone with the defendant and their 3 sons, ages 2, 4, and 6. This defendant caused Anna's death, and the evidence does show you that. The evidence shows you that Anna didn't die of natural causes, but that Anna died a violent death in her Cohasset home on January 1st. You have the photos of those pieces of rug recovered from the dumpster at the defendant's mother's complex. The rug that had been in the living room.
Remember what I said about him looking confident? Strike that. Because, yeah, someone has, he's beginning to look a lot more complected like Mo than like himself.
You have the photo of Anna in the living room on top of the rug. The photo shows that there are wood floors in that room. There's blood on that rug. The rug was recovered from the compactor outside of the defendant's mother's apartment and taken to the office of the chief medical examiner for examination. And Dr. Atkinson found a blood clot and a piece of Anna's Gucci necklace embedded in one of the cut-up pieces of rug. So look at the piece of metal stamped Gucci. It didn't break on its own. The rest of the necklace is missing. This is the necklace that Will Fatsow said that Anna often wore. Look at the slippers from the dumpster. The 2 pairs of adult slippers. The dark gray slippers have hair and blood clumped to the bottom. And the DNA testing tells you that the slippers had the DNA of Anna Walshe and the DNA of the defendant. Then there's the bathrobe. And there are 2 bloody white towels. A towel was tested and had Anna's DNA. Why did the defendant throw those items out? Because they had Anna's blood on them. And the evidence shows you this, because the defendant was researching cleaning. How to clean blood from what floors? Does dishwasher clean blood? Is it possible to clean DNA off knife? The defendant still had a cut on his thumb on January 9th, 2023. And on January 1st, before he even went to Lowe's to buy any cutting instruments, an initial stop that he made when he left his house was to go to Walgreens to buy antibiotic ointment and Band-Aids. Then he went to Bin and Liquors, where the manager identified the defendant, and the defendant threw a bag into the dumpster. Store is closed. The parking lot is empty. He's not yet gone to Lowe's. On January 2nd of 2023, the defendant went to Home Goods because he had to buy a new rug for that living room cover the hardwood floor. He did this days before the forensic scientists got to the house and knew that the rug had been changed. Anna Walsh dying a sudden death from natural causes defies common sense. She was in great shape. The defendant told police that Anna was a sturdy Serbian woman. Listen carefully to his recorded interviews, because those are his words after her death, after he killed her. Mark Salvaggi told you that Anna had the highest health rating of the life insurance company. Anna had to complete an interview, have blood drawn, provide her medical records, and the life insurance company and the underwriters gave her this health rating. Anna was an active person who took care of her health. Ashley Samino, her bar instructor, told you about this exercise class that she took the morning of December 31st of 2022. And Anna was the type of person, she said, who made others want to work harder in their exercise class. Will Fastel told you that Anna was very active and did yoga together. Sergeant Amy Waterman described Anna's home gym in BC. And Dr. Atkinson told you about the different ways a person can die, and that it's extremely rare for a 39-year-old in good health to suddenly die of unknown causes. But without a body, it's not possible for the medical examiner to tell you the exact cause of Anna Walsh's death. No autopsy can be done. The defendant deliberately got rid of Anna Walsh's body. The defendant did not want anyone to find Anna's body and to know how she died. So the defendant bought cutting tools at Lowe's and Home Depot, and he cut up Anna's body, the woman that he claimed to love, and he threw her into dumpsters.
Yeah, that repetitive use of the woman he loved is so incongruous with what he did that the defense has been farcical from the get-go. Again, almost to the point where it is deliberately insulting.
He was hiding her body. The defendant intended to kill Anna Walsh. He didn't just want her dead, he needed her dead. This was a marriage in crisis, and it was heading towards a breaking point. It began with the defendant's federal case. And through the defendant's interview and his federal probation officer, you learn that the defendant was on home confinement. He was going to have to pay over $400,000 in restitution, and the case had been pending since 2018. You also learned that the defendant had no assets. He told Jamulu that he only made $50,000 to $60,000 that year, but he had told the police that he had businesses that were not making any money at all yet. Peter Capozoli told you that the defendant's mother had signed the lease for the Cohasset home, and it was his mother that was paying his rent. Meanwhile, Anna was beginning to thrive. The marriage was beginning to deteriorate. Anna had her dream job. She had risen to become an executive at Tishman Speyer, and she was making close to $300,000 a year. She earned a bonus. And Teresa Marchese said that Anna was a good employee. And the defendant knew this. He bragged of her bonus and salary. She bought a townhouse, and she furnished that townhouse for her family, and she set up bedrooms for each of her 3 boys. But the reality was, her family couldn't join her because the defendant needed the children with him. Being the primary caregiver allowed him to avoid prison. The separation of the defendant and Anna was taking a toll. Anna wanted the children with her, and Anna began a relationship with Will Fastow, which became more serious. The defendant and Anna were growing apart emotionally and physically. Anna struggled not having her children and not being able to be the mother that she wanted to be. This got worse when Anna took the trip to Serbia to take care of her sick mother. Anna and Will Fastow spent the Thanksgiving holiday first in Dublin before Anna went to Serbia. And Anna bought her plane ticket with the credit card that the defendant monitored. And the defendant told police that he monitored their joint Chase Freedom credit card statement. The MacBook history also shows the defendant looking at the Chase account. The defendant knew about Anna's travel because in a recorded interview, he told the police that she had a layover in Frankfurt, and that connection in Frankfurt is on the same credit card statement. And you can see that, it's right in front of you. The defendant was angry about Anna missing Thanksgiving, and he mentioned it repeatedly when he spoke to investigators.
I got angry about Thanksgiving, and then I realized it was just sad that we're not spending a lot of time together. And she was sad about it too, and it was exhausting for both of us. She was away from the boys, I was always dealing with the boys.
Anna returned from Serbia in December, but she only spent one day in Cohasset. And she was supposed to come home for Christmas morning, but she missed her early flight, and she couldn't get a flight, and then she had to drive up. The defendant told police there was an argument.
I did have an argument with her for the Thanksgiving and the Christmas Eve, so I wasn't going to make the same mistake 3 times.
So what did the defendant do on Christmas Day when his wife wasn't home? He looked up Will Fastow on his cell phone. The man his wife...
And I think that's going to be the biggest part. All of the defense falls apart. But there is no logical reason that if you think your wife is dying, because remember the searches around Christmas Day were Anna Walshe found dead, Spirit airline crash, emergencies in Washington, all the hospitals and the morgues. Why are you looking up the guy that sold your wife her townhouse?
Had just spent the night with him. The defendant was losing Anna. Anna was missing her children and wanted to be them. Anna quickly returned to D.C., and on December 27th, the defendant was looking up the best strategies to divorce for a man and the D.C. divorce laws. This was not to protect assets. That wasn't the search. The defendant told the police that everything was in Anna's name. The defendant had nothing without Anna and the kids. And on December 29th, Anna...
Oh, okay, he moved. I was like, did the defense attorney go full Stephen Hawking? I was like, will someone check on the defense attorney? Grandpa Simpson died.
And on December 29th,
but he moved.
Spoke with General and told him that she was upset about the travel, upset being separated from the children, upset about the defendant's federal case. It was ongoing. It was getting to be too much. On December 29th, Anna went out with Alyssa Curry. and she broke down. This strong Serbian woman who was supposed to be having a fun night out with a girlfriend, going to dance karaoke, instead broke down. Anna told Alyssa that she had told the defendant that he needed to take responsibility for the federal case, go to prison. She wanted the children with her in D.C., and she and the defendant had not been intimate in close to a year. In Anna's mind, the marriage was broken. Anna even questioned if she could just take the children because she had already established a separate household. She said that she was falling out of love with the defendant. And at home in Cohasset, what was the defendant doing? He was looking up the Mazda building and the FBI raid on the Crossing building. Looking up something that had happened in the spring of 2022 when Anna first started working for Tishman's Fire. Interestingly, this was when the defendant brought up something he brought up in his interviews when he lied about Anna having to leave early for a work emergency. This thing, the work emergency. The defendant was going to lose Anna, and when he lost Anna, he would probably lose his freedom. Anna would have a house in D.C. and a nice job, and he would likely go to jail. So the defendant pretended. He lulled Anna into thinking that everything was okay. He joked with her about a Porsche. He didn't want her to realize that he was aware of the relationship with Will or her ability to leave him. He wasn't going to let Anna know that she wasn't safe. On December 31st of 2022, the defendant claimed that he could not find his phone. Why is that important? The mislaid phone allowed the defendant to be unavailable for 2 days. The mislaid phone allowed him to carry out his plan uninterrupted. And the mislaid phone allowed him to show the police when he eventually reports Anna as a missing person and not have the police question why he didn't contact Anna earlier. The evidence shows that the defendant was methodical. Just look at how he shopped at Lowe's with a list. He planned it with precision. So Jem Lulu came over for dinner on New Year's Eve, and the defendant told Jem that his phone was lost and it was free. Anna was texting throughout the night, including with Will Fastow. This is now the third holiday where Anna was concentrating on the other man in her life. When Jem left, Anna was alone. She was with the defendant, the man she was cheating on, the man she was telling to take responsibility for his actions, and the man who had her children. The defendant murdered Anna that morning in their Cohasset home. And this is what the internet history shows. His internet history, written words. He was looking at best way to dispose of a body. Better to throw away crime scene clothes or wash them. Crime scene. Can you be charged with murder without a body? Anna was dead. The defendant killed her, and he began researching how to get her money, how to inherit, how to get away with the crime. And he might have gotten away with it, but he didn't know that his MacBook was syncing with his son's iPad, the same Apple ID. His demeanor changed during the interview on January 8th when the police mentioned the searches on the iPad. Not because the iPad involved his children. He had already involved the children in his lives. But because he knew he was caught. We know he had already involved the 6-year-old when he had the 6-year-old say that he saw his mother when she left the house on the morning of January 1st. The son could not have seen Anna leave the house. The defendant had already killed her. Listen to the recorded interviews. During the January 5th interview, the defendant spoke about what his son supposedly had seen. And the defendant involved the 4-year-old by saying that the 4-year-old hid the defendant's iPhone 13 mini. So, the defendant's phone made a reservation at Nightshade Noodle Bar for New Year's Day. After the defendant told Anna that they were going to have a special party. This is ironic because the defendant was very clear with police on January 7th that he and Anna had no plans for New Year's Day, and the defendant also knew that he would be violating the terms of his federal probation by going to a restaurant on New Year's Day. But let's look closely at Exhibit 170 about the Nightshade Noodle reservation, which was on the defendant's iPhone Mini 13, which the defense just said was deleted. And if you look on page 2, on the bottom of one of the bubbles, you will see that the message was deleted on January 1st at 7:59 and 5 seconds a.m. This happens to be one of the times that the iPhone Mini 13 was unlocked when it was supposed to be missing. The forensics show.
Stay here. I don't like where she's going into this Brian mastermind, megamind kind of, breaks the fourth wall and tells us his inner thoughts. I don't need that. I don't want that. Look, I have an active imagination. I don't want to be anywhere near Brian's train of thought. Stick with the facts. You have plenty here. You have more than 10 bags full of facts here. You don't need to go into this. He was trying to lure her into a false sense of security. Stick with this.
That the defendant's phone was unlocked 4 times and it was plugged in on January 1st. You heard testimony that the phone had a password of 197512. And in the January 4th recorded interview, you hear the oldest child needed help with his iPad password, which was 121212. The children didn't unlock the defendant's phone. The defendant blamed his misplaced phone on one of his children when he said that the children hid it. But it makes no sense that a 4-year-old somehow unlocked the defendant's phone and deleted that text reminder. Listen to the defendant's recorded interview. The deletion is made when the defendant is supposedly making French toast and playing with the kids. The defendant had access to his phone. Context. The defendant also had access to 2 other phones when his phone was supposedly lost. He had Anna's phone and he had the iPhone SE. And in the recorded interviews, the defendant told police that on New Year's Eve, Anna had an argument with a friend, and as a result, Anna put her phone upstairs in his bedroom.
You said she went and put her phone upstairs after that?
After that, she, let's say it's 10 or 15, and then she, I remember her putting her phone upstairs because then she came back down without it.
Was Thomas came down at one point and hung out with you in the
Yes. Yeah, exactly.
Was this before, during, or after Thomas was participating as well?
Oh, yeah, Thomas went to bed at he went to bed and then he came over at like 9 or 10 or something. I think Anna took a bunch of photos. Jem and I don't have any because she didn't send them to us yet. But I think she sent one to Will Fasto. So that was when, that's when the photo was taken about. So it was maybe 10 o'clock or something like that.
Somewhere upstairs, she put her phone at that point?
Yeah, on her bedstand.
That's not what Jem said. Jem said that Anna was using her phone all night. Melissa Kirby texted with Anna. The defendant was telling investigators a story about Anna's phone. How else do we know that the defendant intended to kill Anna and had a plan for doing so? Look at his internet history. Look at what he did. The defendant set up an area in his basement where he surrounded it with plastic sheeting or a tie-back suit and dismembered his wife, the love of his life. Hacksaw, the best tool for dismembering a body. Then, the defendant got rid of Anna's body. He got rid of her belongings. He got rid of her clothes and a bag that he told police that she had, that she supposedly left on January 1st. He threw her in the garbage bags, tossed those garbage bags in different dumpsters. Disposing of a body in the trash. Chatham West apartment rental. The Claremont apartment rental. And police confirmed this with the location data from the SE phone and the iPhone 13 mini. The evidence shows that the defendant did this to hide the fact that he murdered Anna. He could not let Anna's body be found because Anna didn't die of natural causes. The defendant murdered Anna, and then he had to hide the evidence of his crime. Look at his mindset, look at his internet history. Want to get away with murder? Use a special detergent. Can you be charged with murder without a body? Best way to dispose of body parts after murder. When you deliberate, look through the binder of the MacBook internet history. There are no searches of natural causes of death, sudden death, heart attack, aneurysm, stroke, or how to help your children when someone dies unexpectedly or goes missing. The defendant was not sad. Look at his demeanor in the surveillance videos. He's cool and calculating. He's calm. He had a plan. On January 1st, he went to the Lowe's store an hour away, even though there were hardware stores approximately a mile from his house. And when he was in Lowe's on January 1st, he wore a mask and he wore gloves and he had a list of what he was shopping for. He was calm as he helped bag the purchases. A hacksaw, buckets. He used cash. Does this show confusion, panic, or fear? But he doesn't stop there. He went to CVS.
GCon 7, the Commonwealth did not present any evidence as of cause of death because they can't determine it. They don't have the body. Now, it is possible, and I do have a video on this playlist where I talk to an actual factual lawyer about kind of the potential drawbacks from both sides, the Commonwealth and the defense, when there is not a body in a murder trial. Now, he practices law in Michigan, so it might not be the same nitpicky statutorial things, but he did talk about, what you would have to do to overcome the fact that there isn't a body on both sides. And he does it quite well. I'm not a lawyer, but yeah, basically the short answer to your question is because he disposed of the body and there is no way for us to determine the cause of death or manner of death, then no, there hasn't been one presented. Now, the state did present evidence that Anna is dead by going through the fact that none of her financial accounts have been looked into. Her social security card hasn't been used, her passport. Now, I was shocked that when the medical examiner was on the stand, the state did not ask any questions as to the size and saturation of the blood that was found on the carpet and whether that would have been a survivable amount of blood loss, because I do think that that could have been something you could have tied in, but that might have been too much speculation. Again, I'm not a lawyer. I'm a mom of six who likes to watch trials. So that's kind of what I got out of that. But feel free. This is not, I encourage you to go to ask Emily D. Baker or a lawyer or actual factual lawyers, because that's about all the wisdom I can give to you. Do I think that they established first-degree murder? Tenuously, the way she is outlining the evidence now, I do think that it's possible to look at or to find first degree murder. I think that second degree murder is more likely, but juries are wild animals. Now, I don't think that not guilty is likely. I do think that it's going to be a toss up between the murders. It will just be the first or second degree. I don't think he's walking away to go home to mommy tonight.
To buy hydrogen peroxide. And then he went to Stop and Shop to buy ammonia. No wonder the house was so clean. And on Monday, January 2nd, he went to Home Goods for rugs and handles. And then he went to Home Depot, where he bought buckets with lids this time, baking soda, and a hatchet. And at some point that day, he got a call from his probation officer. And he lied, and he said that he was picking up his children. He was able to calmly speak with her. No panic. He had everything now that he needed to dismember the woman that he supposedly loved. And he
I think that the way they have presented it now, the way she has linked everything, I think it's more clear for the, I think that they do have planning. Now, do I think that Brian, twirled his little fake mustache and was like, hoo, I've got her where I want her. I don't think he went all, oh gosh, rascally rabbit on her. I don't think it was that logicked out. Brian is an impulsive guy. Brian is not a planner, is not a thinker. That's why he had to go to multiple different places and buy multiple different buckets.
started to take her body and to throw it into dumpsters, because he had to cover up the crime to get rid of the evidence of the murder. This was not a man in crisis. This was a man who on January 4th went to TJ Maxx to buy pants with a store exchange card. He was calm. But Alyssa Kirby texted him on January 4th asking about Anna, and so he called Tishman's Fire a few minutes later and started to pretend to look for her. He called Will Fastel, but he didn't leave a message. He called back later, and then he calmly left a voicemail. No panic. The defendant knew where Anna was. The defendant even texted Anna's sister in Canada and said that she was missing. He was methodical. Look at the text messages. And at 4:30 p.m. on January 4th, the defendant went to Lowe's to buy a trash can. Comfortable. Not compact. The police were coming to the house soon to talk about Anna. And the defendant had the house ready. The police think his wife is in D.C. He had his phone ready, and he sent text messages to Anna, even though he knew she would never see him. Despite everything that he had done, on January 2nd, the defendant wrote a text message to R. I still love you. Ha ha. Ms. June. The defendant prevented anyone from ever finding Anna's body. There's no autopsy. Dr. Atkinson told you that the medical examiner can't do an autopsy without a body. And all that remains of Anna are 2 hairs, some blood, and a few things that belong there. A part of a necklace she often wore, her hunter boots, a black jacket, a purse, her COVID card, and a few other items in the dumpster in his mother's apartment complex. The defendant searched his MacBook for a murder conviction without a body. Please do not allow the defendant's self-serving act of dismembering and disposing of Anna's body to let him get away with this murder. At the start of this trial, we asked you to use your common sense. When you do that, when you analyze the evidence as you deliberate and continue to use your common sense, you will see that the evidence shows there is only one verdict. Find the defendant is guilty of the premeditated first-degree murder of Anna Walshe. Thank you.
I will see counsel at the side of the bench.
Okay, and JKD Buck. So, Mo, if at Dollywood 2026 I keel over and expire, if this is upsetting to you and Kaiser and Shizzy and Expert, don't chop you up. Look, y'all, in a past life, in a galaxy far, far away in a life long, long ago, I thought I was going to be a surgical technician. Now, this was before I realized I pass out at the sight of blood, which is something that one should know if they're going to be a surgical technician. If you don't know what that is, it's the person that hands the doctor the scalpel. I think you guys can see why my passing out at blood might be a problem with this. So, no, I will not be assisting in any Ed Gein arts and crafts. No, thank you. Look, I am the absolute worst person.
George, you're my guidepost. Do you need a break to the bathroom? Okay. All for one for all.
All right. Wait, what is this now? Yeah, he's aware no one has bought any of his crap.
Seated. I will give you a quick break as well, but something's been on my mind that I want to discuss now that the closing arguments are over. And that is, I had asked in connection, this relates to the sentencing, at least for the other 2 counts, and asked the Commonwealth to provide victim impact statements for any immediate family members of Anna Walshe that wish to provide information, and I haven't received that yet. And there might be a good reason for that. I had told you that I was putting off the sentencing until we had a verdict on the charge of murder. But now that it's a Friday, and I don't want this to linger over into the next week, has the Commonwealth heard back from the Department of Children and Family Services?
Your Honor, we've been in touch with them. They are working on their impact statement. They were hoping to have the impact statement impounded. And I can, as soon as we're done here with the charge, I will speak to the attorney that I've been dealing with. They've been working very hard on this. They're certainly worried about their privacy interests of the children and the social.
I think there's a valid privacy interest of the children, and I'm highly likely to impound it, obviously, with the exception of counsel for both sides being able to see it so that they can make appropriate arguments as
I absolutely agree with this. I absolutely. So the children are in the custody of family services. I was not following this trial prior to just kind of hopping on 2 weeks ago. So I am not sure that. I am not sure the circumstances that led to the children being in children's services. I don't know if there's a custody battle going on between Anna's sister and Brian's mom. I am not aware of all of that. I tend to stay out of kiddo involved stuff, especially family court stuff. I feel like these kids have been through enough, so I tend not to dig into that. That's kind of why I've stayed away from the Sarah Boone stuff while it's in family court, just because I don't like to. I don't make any judgment on any other channel that does it. It's just, to me, it's not one of the things that I like to cover. That being said, I absolutely agree with them being impounded. I have no problem with this. I don't need no one other than the court to decide sentencing needs to know these children's private pain. So much of this horror has been, public and for the rest of the world, their grief, their pain, and how this has affected them personally, that can absolutely stay their own. I have absolutely not one problem with that. And I know there might be different opinions, but keep these kids as innocent as they can and keep them as private as they can. They are going to have to live with the aftermath of this incredibly heinous event for the rest of their lives. We don't need to know how this affected them.
Result of the victim impact statement.
I think the department will be very happy to hear that. And they also, much of what they have is through a social worker privilege, so they're concerned about that as well. But as soon as we break, I will be happy to have that conversation.
Well, I'm happy to hear that there's forward progress because I guess I assumed, because I hadn't heard anything, that you were still not getting the answers to the questions you were asking.
No, quite the opposite. They've been working very hard on this.
All right, I appreciate that.
Thank you.
Anything anyone needs before I step off the bench briefly? Thank you.
Now, we are going to go into basically the judge doing jury instructions. So we have a couple options.
Any special consideration?
So we can watch some police body cam footage. I do have the hearing of the Charlie Kirk, first hearing in his trial, if you guys would like to watch that. So you guys can choose. We've got, let me add a poll. We've got cop cam or body cam footage, or we can do the Kirk hearing. I don't care either way. I will just need to get another notebook if we do the Kirk hearing, because this one I did manage to fill an entire notebook with the notes in this trial. So
Your verdict must be based on the law as I have given it to you, and on the evidence.
give you a
and the
couple
facts
minutes to
as you
put
find,
votes in.
and nothing else. By contrast, my job as the judge is to impose sentence if the defendant is found guilty. Therefore, you are not to consider the sentencing consequences of your verdict.
I have something for that. Wait, let me. I have something for that.
Hades is gonna kill us when he finds out what happened. You mean if he finds out?
If.
Of course he's gonna If is good. He's not.
This is basically Brian Walsh's defense brainstorm at this point. I think the Kirk was long. I'm glad it was televised. Would like hear those arguments. Yes. Now I do know that there were issues in the Charlie Kirk hearing, depending on how we vote. I can cover this next week. So, if you guys still want me to cover this, we can do body cam stuff, and have fun for Friday. There was an issue with the media coverage. It looks like there was some really good focus as far as focusing on the defendant and focusing on some documents on the defense's table. So we might be looking at this judge already getting very irritated with the media. So that will be another story. Fridays are more fun, so I do tend to stick to more fun kind of things on a Friday. But that is the one I haven't watched the hearing myself, but that is the one thing that I have heard, at least breaking news about it. I have heard that it is, terrible. But you would think, again, I don't know how many times these cameras have been an issue. I do not know why they cannot seem to get it to be done, correctly by itself. Now, there is one other option. There looks like there's an Ohio case that started yesterday. If you would like to pick up an entirely different case, because I do know that the Charlie Kirk is politically, crazy, and there's a lot of, back and forth as far as that. So if you guys would like to look at Ohio versus Paul Hicks, now I have no idea about that one. The hyperbaric chamber one, just this close to Christmas, I'm trying to look at ones that don't involve kiddos. I know that generally I don't have a problem. I tend to be the one that will do like the Megan Boswell case and that kind of thing. But I will say that one's probably a no for me just because of the kiddo one. All right, it looks like the Kirk hearing is winning, so I do have a new notebook. Everyone is. We can do body cam, we can do the Ohio case, or we can do the Kirk hearing. I really don't care. I just would like to have something to do rather than watch jury instructions. So we will start here. If you guys, if we are feeling froggy, want to switch around. But let me get my headings because I do notes. Hearing, and that was yesterday, so that's 12/11. Sorry, I have a certain way I have to do notes, so to kind of orient myself. All right, we are starting off, and let's go.
Just a database of the people's stuff, right? It's not an interview.
If you want, I'll identify one of the sent you can look at it and say, okay, do we care? Okay. On this person, I did, or
So the first thing that's very observable are the very, very, buff and tactically appareled bailiffs. I would not expect anything different given the kind of cultural and political importance of the hearing. Yeah. Editing by J.J. Abrams. What the hell?
Just a database of the people's stuff.
I'll identify one of
Just a database of the people's stuff, right? It's not an interview.
If you want, I'll identify one of the sent you can look at it.
What's the derogatory? I've seen that before. For sure. I don't want to start talking about this. The last one, making the assessment that is referred to. We will address that. And then you just.
I haven't seen Landman yet.
Okay. 40 times.
Lola, I see this both ways. I do think that defense clients, and especially with highly public cases like this, are going to start having to look at the optics of how their client is perceived. I think that this is going to become a bigger part of defense law, how your client is perceived, how he is, maybe even PR for a client, because I do feel like the way that we are filming trials and they are becoming more of a kind of cultural touch point. I do think it's going to be much more important that lawyers, and especially defense lawyers, talk to their client about what they're doing in the courtroom. Now, I do think that defendants are damned if they do, damned if they don't. If they're stoic, then they, are stone-faced and lack empathy. If they cry, then it's crocodile tears. So I think that there's a damned if you do, damned if you don't, as far as a defendant. I'm not defending him, and I'm not, doing that. But, I do think that highlighting it, that filming it, could taint the jury pool. And I don't know, again, if the defense attorneys are aware of this, if they're aware of how their client is perceived. I don't know. And again, if they're making arguments about how their client is perceived, then they should be the ones being extra careful that their client not do something that a lot of people are going to find, quite frankly, maddening. Him laughing, him joking is going to piss a lot of people off, and they should be cognizant and aware of that and possibly tell him not to do it. If they're the ones that are aware that their client already has a very negative public kind of persona, then they should be extra aware of how he's behaving in court.
He's here. I saw him. Okay. He's sitting in the back.
But I don't think it's a good look. But this isn't something that the jury is seeing. This is something that we're seeing. But if everyone's a potential juror. All right, we are going to go ahead. Here we go.
All rise. Fourth and fourth, 2009 Secretary, the Honorable Tony F. Graff, Jr. presiding.
Please be seated. Court is now in session. Counsel, if you could enter your appearances, please.
Your Honor, Christopher Ballard, Ryan McBride, Chad Grunander, and Lauren Hunt on behalf of the state.
Good
All
afternoon.
rise.
Good afternoon, Your Honor. Kathy Nestor, excuse me, Richard Novak, Stacy Visser, on behalf of Mr. Robinson.
Good afternoon.
Good afternoon, Your Honor. Jeff
Please be
Hunt
seated.
and David Ryman appearing on behalf of the media interveners that are identified in our motion papers.
Court is now in session.
Michael Judd, Your Honor, Parsons, Bailey, and Latimer, on behalf of another set of media interveners also identified in the briefs.
Good afternoon. Counsel,
And I
if you could
recognize
enter your appearances,
Mr. Robinson
please.
in the courtroom as well. Good afternoon.
Your Honor,
Just
Christopher
for the benefit of
Ballard,
the record,
Ryan
calling
McBride,
case
Chad Grunander,
251
and Lauren Hunt
403
on behalf of the state.
576. Good afternoon. State of Utah versus
Good afternoon, Your
Tyler
Honor.
James
Kathy
Robinson.
Nestor, excuse me, Richard Novak,
Counsel, as
Stacy
we're moving
Visser,
forward
on
today,
behalf
I
of
want to
Mr.
give
Robinson.
an overview of what we anticipate doing.
Good afternoon, Your Honor.
And
Jeff Hunt
it
and
comes
David
down, we're
Ryman
addressing
appearing
three
on behalf
issues.
of the media
The first
interveners that
is
are
the
identified
October
in our motion
14th,
papers.
2025 audio recording
Michael
of
Judd,
the
Your Honor,
closed
Parsons,
hearing
Bailey, and
and the
Latimer,
October
on behalf
24th,
of another set of media
2025
interveners
transcript
also
of that
identified
hearing.
in the briefs.
The second is the state's motion to amend
Mr. Robinson
or
in the
clarify
courtroom
the
as well.
publicity
Good
order,
afternoon.
commonly for the benefit of the
known or
record,
referred to
calling
as the
case
gag order.
251.
And finally,
403,
the motion for limited
576,
intervention, a request for
State of
notice
Utah
of motion
versus Tyler
to
James
close,
Robinson,
seal, or reclassify.
Counsel, as we're moving forward today, I want to give an
Which has been filed
overview
by
of what
the
we
media
anticipate doing.
organizations and by counsel
And
who are present
it comes
today.
down, we're addressing three issues.
So as we begin, the first
is the October 14th, 2025 audio recording
and the October
of the closed
24th
hearing and the October 24th,
This portion of the
2025
hearing will be
transcript
closed,
of that hearing.
so that I may hear from the parties
second
regarding
is the state's
which
motion to
portions
amend or clarify the publicity
recording,
order. The
commonly
record
known
should
or
remain
referred to
sealed.
as the gag
All
order.
Okay, I thought that was just me. Let me move forward just a little bit and
sensitivity of it. I believe it is appropriate to treat all parties.
okay, because I was going through all of my
Robinson. Thank you.
Okay, so it looks like, yeah, I was muted because I was trying to figure out what the hell, where I was getting two tracks from. Okay, so it was the audio because I was going through all my tabs and I'm like, where the hell is the double thing going? That's why I was muting because I honestly could not think. All right, thank you guys.
Thank you for your request. All right, we will go into the closed session. Thank you.
Okay, so this is mainly closed. But we can get into the live bits. Or are there any live bits? No, I have not seen this. I have been doing the Brian Walshe trial. I get up at 4 a.m. to do mornings with Mo, and then I, do Brian Walshe stuff. Then I do mom stuff. Then I'm kind of in bed. Oh, I couldn't. It was just going through. I'll have to look for it for the specific time ones. His hair's thinning pretty bad. I wonder if he'll be fully bald by the time the trial happens. Oh, no. No, I don't. This case is about, this is going to be the first hearing, pre-trial for the alleged assassin of Charlie Kirk. Charlie Kirk was, depending on who you look at, far right, medium right, conservatarian, somewhere in there. But he was a public speaker who would go to college campuses and try to have debates about topics, both cultural, political, faith-wise. So he would go to college campuses in America and sometimes overseas. I think he'd last gone to the UK. Oh, here we go.
We're going back on the record in case 251-403-576, State of Utah versus Tyler James Robinson. I note the presence of counsel that previously entered their appearances. We have come out of the closed session and concluded that business. However, the court became aware of an event that happened before.
And welcome, Broken Baker Raiders. Welcome, welcome. We are on verdict watch. The jury officially went, let's see, to verdict watch at 12:22 p.m. Eastern Time. So we are on verdict watch, and we are watching the open part of the Charlie Kirk hearing, and then we'll probably devolve into body cam, you know, crazy people doing crazy things, running from the cops. That's kind of what our plan is for today. I do not know how long deliberation's going to go in the Brian Walshe case. I was guessing all of 10 and a half minutes, but, you know, the jury's probably going to want their lunch at least.
And my understanding was during the open portion of this hearing earlier that there was a violation of the standing decorum order as it relates to transmission of these proceedings. I want to hear from counsel, and then I will make a ruling concerning that shortly thereafter. Ms. Visser.
Thank you, Your Honor. I'm referring specifically to Rule of Judicial Administration 4-401.01. This gives the court discretion to terminate or suspend electronic media coverage at any time without prior notice, if the judge makes particular findings and that the specific circumstances warrant it. It is our position, the defense position, that there has been a violation of the decorum order. It is our understanding that those live streaming this signed and declared that they would follow the decorum order, and they violated it. So we are requesting a sanction. We believe these court's orders are binding and they need to be respected. We also believe that it threatens my client's right to a fair trial. It's the whole reason we filed a motion in the first place to remove his shackles. It's our understanding that his shackles are visible. It is also our understanding that potentially some audio from counsel table was heard. We are definitely taking more measures on our own to ensure that that does not happen again. But there has also been some filming of computers and materials at counsel's desk. That's entirely inappropriate. And I think everybody in this room will agree that's entirely inappropriate. So we are asking for some remedial measures here. We're asking for it to terminate for today, and we can proceed after that.
Thank you, Ms. Visser. To the state.
Your Honor, the state, as stated earlier, we believe that the court's order was very clear, and if there's been a violation of that order, then we agree that there needs to be some measure taken. We'll leave it to the court to decide the appropriate response to that violation, but we agree that any violation of the court's order needs to be addressed.
Thank you, Mr. Ballard. To the press, attorneys for the press.
Your Honor, Jeff Hunt for the media interveners. This is the first time that we've heard about the violation. We've not had an opportunity to look at the video or investigate the audio or look at the capture of the computers, but filming of the inadvertent filming of the shackles, I did talk to the pool photographer. My understanding is that there was a zoom out shot that did inadvertently show the shackles. That was improper. That was inadvertent, and we apologize for that. They've taken measures to make sure that the pool video that is disseminated to the rest of the pool does not contain any capture of the defendant in the shackles. We can't do anything about the live stream, of course, but we can control what the rest of the video is that we capture and disseminate. So that is being done. The audio for counsel, my understanding is the only audio that they picked up was from counsel's microphones. I don't have any further information about that and whether that's a violation. Filming of the computers is not a violation of the decorum order. If the capture can show the document that counsel is looking at, then that is a potential violation. So I just don't know how much detail the shot is that is of concern to the court. But I'll just say that we reiterated as soon as I heard this from Mr. Ballard with the pool representatives that this is very important to follow to the letter the court's EMC order. They understand their obligations. They take that very seriously. They're not perfect. Mistakes happen. We're trying to correct as much as we can on that. But we think termination is not an appropriate remedy. An admonishment from this court, a reminder that they need to follow to the letter the court's EMC order is appropriate. That's the message that counsel has delivered to the media representatives and the pool operatives, and we think that is the appropriate remedy.
Thank you. Thank you.
I just want to make it clear, we're still receiving messages that shackles can be seen on the live stream as we restart it. So it's still a problem.
Thank you. I appreciate all parties weighing in on this important matter. And I find that there was a violation of the standing decorum order that was in effect as of October 30th, 2025, based off what's been proffered, as well as the EMC order signed by the court. As previously stated by Ms. Visser, the court does have discretion in determining whether to terminate the broadcast of these proceedings, and again, if there are specific circumstances warrant such action, that the court would need to make findings in order to do so. I find that excluding the cameras from the courtroom would be disproportionate for this hearing. I find that making it very clear, first, that the transmission cannot begin until court is in session and must end as the court ends the session, and cannot be filmed before or after. The filming of, as previously stated in the decorum order and EMC, must be followed to the letter. The sanction for today is that this camera will be relocated away from defense table to where the bailiff is, where Jeff is standing over here. I want to immediately address any possible transmission of shackles, as previously stated by counsel, and remove the possibility of capture of screens of the computers at defense counsel's table as well. In addition, if there's further violations of the standing decorum order, this court does have the right and will exercise termination of broadcast of these proceedings. And I simply want to put all parties on notice, to the press, to all parties, that this court takes this very seriously. While the court believes in openness and transparency, it needs to be balanced with the constitutional rights of all parties in this case. As such, we will take a brief recess to allow the relocation of the camera and to the place indicated by the bailiff, and then we will resume these court proceedings. I am anticipating this take perhaps 5 minutes. All right, and then we'll come back on the record and handle the remaining of this hearing. I appreciate the patience of parties as we move forward. We are trying to do the best we
Okay, so now we should be... Okay.
And of course, I'm looking for my notes, and they've disappeared. That's okay. It happens. All right. Let's go ahead and address the state's motion to amend or clarify the publicity order. And I'll hear from all parties. And I know it has been briefed, but in responses, but I'll hear brief argument, and then we can go from there. Mr. Ballard.
Thank you, Your Honor. With respect to this motion, I think as we've expressed in the past, everyone in this room shares the same goal, and that is to ensure that there's a fair trial that happens in this case. And we recognize that the court's pretrial publicity order is intended to further that goal. And again, as I've stated before, the state plans to try this case once. The state is also committed to complying with its ethical duties with respect to pretrial publicity. We have complied with those duties. We will continue to comply with those duties. The issue we bring before the court here is that there's one portion of the pretrial publicity order that can be interpreted to reach beyond those ethical requirements and have the effect of being what would be an unlawful order, an unlawful prior restraint on speech. And our goal, therefore, is to get an order that's clear, that's lawful, and that the state has the ability to comply with. And the issue with the order that the state has is the use of the term witnesses in the order. We believe that term's vague and ambiguous. Does it mean anyone with relevant information about this case? Does it just mean those people that are going to be subpoenaed to testify in this case? Or is it limited to just the prosecution team? And I think as we've expressed in our filings, we believe that the court intended that term just be limited to the prosecution team because that is the way that Rule 3.8 reads. Rule 3.8 of the Rules of Professional Conduct that deals specifically with requirements for prosecutors talks about investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor. So in other words, the prosecution team. And there's no rule or case law or statute that expands the prosecution's duties beyond that group, the prosecution team. So with respect to clarity, we're seeking clarity as to what exactly does the court mean by witnesses. And we think the court just means the prosecution team because if that term stretches beyond just the prosecution team, then the order is written we don't believe is a valid and lawful order because it would result in a prior restraint on certain speech, and at the very least would have a chilling effect on that speech. If the prosecution agrees that we have an ethical duty to take reasonable measures to make sure that those who are identified with the prosecution team are alerted to the requirements of the court's order and to make sure that they do not make a statement that the prosecutors themselves would not be able to make, a public statement. But if the order extends beyond that, then we have concerns because a prior restraint is an order that forbids certain communications in advance of the time that they are to occur. And as the Court of Appeals has recognized, the Utah Court of Appeals has recognized in State versus LM. And widespread publicity in a case does not itself justify a prior restraint. As the United States Supreme Court has recognized in Nebraska Press Association, there's no justification for a prior restraint unless it's
That probably is the jury box, Ronan, but since this is a pretrial hearing, the media is not under requirement not to show the jury box, and I believe that this is the camera that had been near the defense table, and they switched it to stay away from the defense table. So they're under no obligation to not show the jury box right now.
Clear that the further publicity, unchecked, would so distort the views of potential jurors that you couldn't find 12 jurors who could be fair and impartial. That's the high standard that applies in this case. And so in order to apply a prior restraint to persons beyond the prosecution team, the court would need to engage in a very detailed and demanding analysis. The court would have to make a factual finding of necessity, that the speech that would be restrained poses a risk of material prejudice to the ongoing judicial proceedings. The court would need to make findings that there are no less restrictive measures and that the prohibitions are likely to prevent the potential prejudice, and that whatever prohibitions this court decides on are very narrowly tailored. And as the state has explained, the Spencer versus State case from the Arkansas Supreme Court that just issued earlier this year is very helpful, I think, on this issue in explaining the analysis that applies to various different people that might be associated with the criminal case. You have attorneys, that category of trial participants. Certainly the court has the highest degree of ability to be able to restrain the speech of attorneys, and in fact, as I've expressed, the ethical rules require that. But when it comes to trial participants, like witnesses, the standards are more demanding as far as restricting the speech of trial participants. And as the Spencer case pointed out, non-attorney trial participants, the court can impose a restraint on their speech only to the extent that the court first finds that any speech by those non-attorney trial participants poses a serious and imminent threat of material prejudice to the ongoing proceeding. And I think the court also needs to note that there are several people associated with this case who have very significant interests in exercising their First Amendment rights in talking about how this case has affected them. And of course, can't say that one person's First Amendment right is more important than another person's, but there are certainly some people here who have a larger, some people involved who have a larger or a greater interest in speaking than others. And so I think the court needs to take that into consideration if this order is meant to apply beyond just the prosecution team. And then finally, as far as making the order, so we need a clear order, we need a lawful order, and then we need an order that the state can actually comply with. And the state recognizes that there are serious sanctions that this court can impose for violations of a court order, as we've just seen. And so we want to avoid these. We want to avoid litigation over whether there's been a violation of the order. And as it stands right now, we don't believe that there will be any issues if the court limits the term witnesses to just the prosecution team. We can comply with that order. It gets more difficult for the state if the term witnesses then applies even broader at this stage of the litigation for the state to be able to comply with that order, depending on how the court clarifies what witnesses mean. Does the court have any questions for the state?
No, thank you,
Okay, thank
Mr.
you.
Ballard. Mr. Novak.
Thank you, Your Honor. I'm going to try to be brief because our views on the propriety of the court's order were set forth in a publicly filed document, which, of course, the court has reviewed. And the first thing that I want to say is that the order that the court issued is not a prior restraint on any member of the public, and it's certainly not, I think as the state's motion suggested, some sort of a prior restraint on the press. This has nothing to do with the press. The order, as we noted in our papers, is directed at the conduct of and the court's expectations for counsel. So even if, under that order that the court issued, somebody who we could all agree is a witness within the court's definition of that, made public statements which implicated Mr. Robinson's fair trial rights, the potential sanction is on the party who had a duty to make a reasonable effort to notify witnesses that they should not be doing so.
So I believe that this is all about, and I could be very wrong. Again, I haven't watched this, and I have not pulled the documents for this particular case. I believe this is probably talking about Erica Kirk speaking out, maybe at Charlie's memorial service. But that's again, a very basic speculation on my part. So I don't know if this is exactly what they're speaking of, or if in fact they're just trying to hammer down who exactly is being covered in this particular order.
I represented a witness who was accused of saying too much publicly. The first thing that I would tell this court is the order isn't directed at the witness. The order is directed at the counsel for the parties. There may in the future be some theoretical situation where the court issues orders that control the statements or conduct of specific people, but this, or other than counsel, but this order is directed at counsel. And we have no, meaning Mr. Robinson's defense counsel, have no problem complying with the order. And we also think that we understand what a witness is when the court uses that term. So it is our view that the court's order is not overbroad, it's not vague, doesn't put the state or the state's attorneys in some untenable position. And I think it's a little too simple to say witnesses are either everybody under the sun or people who are under subpoena at the last second. Because counsel have not only the training, but a duty to figure out along the way who the potential witnesses are and to notify those people. And yes, down the road, maybe there's going to be an issue and maybe an attorney on either side of litigation is going to have to explain to the court when a particular person did or did not become a potential witness in the eyes of that party. That doesn't make it impossible for the state to comply with the order. It just means that the state needs to be thinking along the way about who its witnesses may be. And that's why in our papers, we refer to it as a potential lay witness, because we believe that the court intended it to go beyond members of the prosecution team, which are law enforcement officers, retained experts, retained consultants, and we don't believe that that creates an enforcement problem. We don't think it creates a compliance problem. We noted in our papers, and I'll emphasize here again, that the court's order actually places responsibilities on defense counsel that the rules don't. The rules have special guidelines for the prosecution, and the court has expanded that to include the defense, and we don't have a problem with that. I also think that the standard that the state is suggesting for when a potential lay witness, as we've defined that in our papers, may make public statements that violate the court's order. The best standard is actually the one that we believe the court should look to, which is the standard set by the 10th Circuit, because as the state points out, it may be that there isn't any Utah law on this issue. So it seems to me that the closest source of authority on this.
Roan, I think it is. I think we all started doing it when, right at the kind of dawn of LawTube, Rekieta got struck by Law and Crime because he was using their feed, and it was a big thing. So basically, we've just covered up the logo. I don't believe there's ever been a problem past Rekieta having an issue, but I think it's just one of those things.
Constitutional question is going to be the 10th Circuit, and that's the case United States versus Tijerina, and I'll spell it. It's Tijerina, 412 Fed 2nd 661, 10th Circuit 1969, where the court says that the constitutional balance between the First Amendment rights of a non-attorney participant and the defendant's right to a fair trial are properly balanced where extrajudicial statements present a reasonable likelihood of prejudicing a fair trial. That is a more protective standard than that which appears in Rule 3.6, and we think it's the appropriate standard which should be applied here. That's part of, as we've told the court before, a motion that we will bring, because we actually think that while the court's order is wholly appropriate, it's not vague, it's not overbroad, it's not a prior restraint, and it doesn't create a lack of clarity for the state, we would like it to be a little bit broader in other areas, especially concerning the standard.
So I do think that they're going to run up against an issue here. Now, the defense is making the case that basically any statement that any witness, and I'm guessing, again, this is my speculation, that this is more aimed at Erica Kirk and maybe Turning Point USA and maybe bigger creators. I haven't popped my mouth off. I don't typically talk about political stuff on my channel. More only in the sense that it intersects with either the headlines or, just absurdity. But what they are doing is trying to get basically any hot take, any sort of person that is connected with this to not be able to talk because it could taint the jury pool. Now, I do think that there is going to be that the judge is going to have to balance the First Amendment rights of the people and that were there and affected versus the right, for to find a fair trial, to have a jury that's not tainted. But I think that the cat's out of the bag. I think that you could move this trial anywhere. And because of the internet, because of the availability of everything, there's no way that you are going to find a jury that hasn't at least been partially exposed to this incident.
To be applied and the definition of what is the prosecution team, but that's not germane to here. So we think that while we understand the state's concern, we think that their motion should be denied. I think at the last hearing, the court actually clarified verbally from the bench what it meant by a witness, and I think that's pretty close to what we described in our papers as a potential lay witness. So I feel like if I say anything more, I'm going to be reiterating again what's already in our papers. If I've muddled it, I'm sure the court will tell me and I'll clarify it. I hope I haven't.
Thank you, Mr. Novak.
Okay, thank you.
All right, and we'll turn to the last matter. Anything further, counsel?
Yes, thank you, Your Honor. I do want to point out that the court's order as it's written does impose limitations on speech. And the issue here is whose speech? Is it just the prosecution team members, or does it extend beyond that? And limitations on speech are a prior restraint. The court's order says that, if you look at page 2 of the order, it specifically talks about lawyers, that lawyers cannot make a statement that would violate Rule 3.6 and need to inform witnesses that they cannot make similar statements, and then requires the parties to inform lawyers, I'll just read it. Lawyers participating in the investigation or litigation of this case shall inform all witnesses, and then the list that I read, about the prohibitions contained in this order. So the order is prohibiting speech. And because if it extends beyond the prosecution team, it needs to have the findings that are required for that kind of prohibition on speech. That's what we're asking the court to do.
Thank you, Mr. Ballard.
Thank you.
All right. Let's turn to the final matter before this court, the motion for limited intervention and request for notice of motions to close, seal, or reclassify. And I'll hear from the parties on that.
Thank you, Your Honor. David Ryman, representing the news media. Mr. Judd and I represent different groups of clients, so I'm going to invite him, if I miss anything, to weigh in after I'm done. But my intent, the issues are basically the same, so my intent is to.
So basically, these are going to be the hearings where media, interested parties, and there are a lot of interested parties, are going to make their case that this is an important public, trial. The public deserves a right to hear all of the hearings, see all of the things, that anything that's ruled classified should have to meet certain, things like that. Definitely. Yes. Sorry, Tammy. This is the alleged murder of Charlie Kirk. These are pretrial hearings, so we are allowed to see the jury box. Sorry, youngest most feral is out of school today because of the snow and cold, and so he's been in and out. You've probably heard me like, quiet, no. So
address them for all of the interveners at once, and I'll be very brief. We have only ever sought in this case.
It is that he is kind of every kid, that he doesn't look like what you would assume a monster, I think is more scary. I think I find myself studying his face more, trying to see what was it? What did it? Allegedly, he is presumed innocent, but to try to make sense of how this happened, of what we saw, I think I think it is a little bit strange that he looks like every kid you could see at Walmart in a college town.
Limited party status. That is what we do in every high-profile case that involves these type of closure issues. We are not seeking to be parties for all purposes. We are just seeking to be parties for the purpose of showing up and being heard, which we unquestionably have a right to do. We unquestionably have standing. That is settled law in Utah. And the last filing at least, that we got from Mr. Robinson's team that just came in, I don't know if it was a couple days ago, basically gets there at the end where it says, look, if you're going to grant them intervener status, it should just be limited. That's all we've ever sought. And so the question that was raised in the only case that they cite, this FL case from the Utah Supreme Court, that addressed whether we wanted to allow full party status under Rule 24 of the civil procedure rules in a criminal case, they said we don't need to do that. The woman in that case just needed limited party status. And so in a way, we're not really, the state really hasn't disagreed with this either, but we're not really disagreeing with Mr. Robinson's team. We have explained in our papers we've cited the court to extensive authority saying that this is the procedure to use. It's the most efficient procedure to use. Otherwise, I don't know what exactly the suggestion is for Mr. Robinson's team that we're supposed to do from here on out, but it kind of sounds like just this sort of ad hoc, show up anytime you happen to see something on the public docket that might affect the public's rights, and that's just not the orderly way that this typically happens. The other thing, as I've mentioned in our papers, that it does is it allows for the media to be able to take an appeal of a closure issue without having to rely on the court's extraordinary writ jurisdiction. And that was what they had to do in either Kearns Tribune or Bullock, where the media was not granted party status. And it is the situation that happened in FL, where they had to review her claim regarding records under extraordinary writ jurisdiction rather than invoking their appellate jurisdiction because she was improperly denied limited party status. So all of that authority supports the process that we are requesting in this case. We think it's the most orderly way to do it. And I'll end just by saying, you know, there's been some discussion, and especially from Mr. Robinson's attorneys, about what rule it is that you need to do this under, whether Rule 24 applies. They seem to suggest that it doesn't. I will just point the court to two different rules that give you the authority to do what we're requesting aside from Rule 24. Rule 24 is in the civil procedure rules, but Rule 81, and particularly subsection F of that rule, says that the rules of civil procedure govern in criminal proceedings where they don't conflict with a rule of criminal procedure. That's the case with Rule 24. That's why courts in criminal cases have relied on that rule. The other one is Rule 31, and that's in the criminal procedure rules, and that gives this court the discretion, if it's not inconsistent with the rules, to fashion remedies and to deal with civil procedure, or not civil procedure, but rather just procedural matters. And so that is essentially what happened in the FL case, which is that, you know, whether you do it under Rule 24, whether you do it as a judicially created, you know, remedy, it doesn't matter. It's the same, it gets to the same place, which is just that we are interveners for the very limited purposes that we've set forth in our order. We're not going to be here at every hearing arguing, you know, we didn't take a position on the gag order motion that you just heard. We are only planning to appear and argue so that the court has the benefit of someone who's representing the interests against closure. Because as you know, and this is sort of why we're here today, a lot of time this just happens by stipulation, because these, you know, the state and Mr. Robinson's lawyers, they may not want to fight over a particular issue. And so it really is a situation where no one really represents that interest. And the purpose of this whole process is to give the court the benefit of the briefing that we've submitted and the benefit of arguments to represent the public's right to attend these proceedings. So unless the court has any questions, that's all I have.
Thank you.
Thank you.
To the state, Mr. Beller.
Your Honor, as the state briefed in briefing on a prior motion, I think it's clear that part parties have outside entities have the ability to intervene in a case as a limited purpose party when there's a statute, a rule, or case law that authorizes them to take specific action in a proceeding. And there's well-established case law that allows the media to intervene, to be able to appear and be heard on matters of public access to court proceedings and to court documents. And Rule 4-202.04 of the Rules of Judicial Administration also make it clear that the media can appear and do just exactly what they've done in the closed session that we held earlier. So it doesn't make them a capital P party to the case. It makes them a limited purpose party, and they certainly have the right to be able to do that. Thank you.
Thank you, Mr. Mallett. Ms. Visser.
Thank you, Your
Okay, it is just a barrel of laughs. And what in the Ally McBeal is this dress? The early aughts called, we do not want Ally McBeal back. You can keep her. Callista Flockhart, I hope you're having fun with Harrison Ford, but we can all forget Ally McBeal.
So I just want to clarify the issue really, if we boil it down, is if these 23 media entities have met their burden to be a limited purpose party in this case. And I think another part of that is what that means. And really that is what we are primarily concerned with. What does that mean? What does that enable them to do? What jurisdiction is this court exercising over them as a result of them being a limited purpose party? Because I do believe that is another aspect of asking to intervene in a case. I do think that Rule 24 does not apply here. I think that's what we learned from the Supreme Court. They don't want individuals using Rule 24 of the Rules of Civil Procedure because it's too expansive. It's about broad entry into a case for many purposes. In the instances where our courts have allowed intervention into civil cases, and I want to be very clear here, the case law is in the civil arena. There are very few instances where we're dealing with this in a criminal case on appeal. So we're a little bit in the dark, and we're asking this court to kind of wade through and make a decision that potentially hasn't been made before. But I would ask the court to be very clear, no matter what it does, on what the media can and can't do in this case. And it sounds to me like the media has somewhat conceded that their role in this case is under Rule 4-202.04, and their role is to have a voice regarding closure, which has already happened today and will surely happen again. We have no objection to that. And to be clear, we're not objecting to the court's order about notice. We will provide notice. We will follow the court's order. We have no problem with it. But we do want this court to make the procedure very crystal clear. We want time frames. We want orders saying this is when you need to respond so that we don't end up with filings like we did this week, very shortly before the hearing, that we have to rush to respond to. We're all attorneys. We all know that these things happen from time to time, and we're not unreasonable folks. If they reach out to us, we will grant reasonable requests for extension, just so everyone is aware. But there was no communication. So I want it very, very clear what they can and can't do. It's less about semantics. This isn't about semantics. It's about substance. What are they allowed to do? If this court wants to call them a limited purpose party, that has to be, well, it's so you can exercise your rights under 4-202.04. And in doing so, this is what you need to do. That's what we're asking the court to do. And I also have some practical concerns that maybe need to be addressed with the court's clerk. for example, are we adding all 23 media entities to the court docket? Will they have access to all of the filings? I have had instances in the past where, unfortunately, parties have been added to a case and still receive documents that are intended to be private or non-public. I'm very concerned about that. So I think it would be appropriate, if they are going to be added to the docket, that it be reasonable, perhaps just the two entities that are requesting, the two conglomerate entities that are requesting, and that there be an order from the court saying if they receive something that they shouldn't have, they notify us in the court immediately and they delete it, they don't review it. At a minimum, I think that's necessary. But I also think it would be reasonable for this court just not to put them on the docket for that very same reason. So we don't think that they should have permanent status in this case. We don't dispute that they are going to be here. They're already here, as we well know. But we do think how that happens is important, and that this court should exercise its authority to make very clear what everyone's roles are here. And as I believe they put in their briefing, that they are neutral observers. Neutral observers. We don't want the chaos that is out in the media in this courtroom. So whatever this court can do to prevent that is what we're asking. Does the court have any questions for me?
No, thank you.
Thank you.
All right, counsel.
Thank you, Your Honor. Just very briefly, I'm not sure what neutral observer is supposed to mean. We have interests in the case. We are here to advocate for openness and against closure. And so I don't think that's what counsel meant to imply, but that's the whole reason we're here, is that no one else represents our interests. That is straight down the middle of what the intervention rule requires. Just a couple clarifications. Counsel said we haven't cited any criminal cases where this has been allowed. That's not true. We cited the court to 8 different cases, all criminal cases in the state of Utah, where this is the procedure that judges routinely follow, including judges in this building. Counsel said that our role is strictly limited to advocating for what is under Rule 4202.04. I don't think she meant this, but as the court probably knows, that just deals with court records. We're also entitled under governing constitutional case law to advocate against the closure of proceedings. And that rule does not technically apply to proceedings, it just applies to records. So just to be clear, but I think we have been clear, and this is all, I mean, there wasn't a whole lot of daylight between what counsel was just suggesting our role should be and what we've asked for, you know, which is just if they file a motion that seeks to prevent, that wants to classify something as non-public, like they did last night with the motion to disqualify. They were able to at least provide that to us. It's not very hard to send an email. That's all that we've asked for in terms of the notice. And then we have the right to be heard on those issues. And so I didn't really hear from counsel any reason why we should not be granted limited party status in this case, other than just some sort of, you know, confusion on their part as to what that would actually look like. I don't know how the clerk deals with parties on the docket. I assume you guys can sort that out. Typically, when we intervene on behalf of the news media in cases, they are listed because they are limited purpose parties. But the court can, you know, if it doesn't want to hear from us on a particular issue, it can certainly say that. I mean, we don't have any interest in weighing in on aspects of the case that don't have anything to do with the public's right to know. And so I didn't really hear an argument against what it is that we are asking to do. Just one last point on, well, 2 things. One is that counsel's chastising us for filing something late. I mean, this was a stipulated motion that got us here today. We weren't asked to weigh in on it. It was submitted to Your Honor with an order, you know, which they just assumed you would sign because it was stipulated. It was only because this court said, no, I'm not going to do that. I want to actually hear from the parties that we weighed in. So this was not your typical, like, deadline where we were invited to weigh in and just didn't. Last thing is, in terms of docket access, you know, Mr. Hunt and Mr. Judd and I are all officers of the court. If the court says you can have access to things that the parties are seeking to classify as non-public, but you can't share them with your clients until further notice from the court, that's fine. Some judges do handle it that way. Sometimes we just, if they don't concern closure, sometimes we don't weigh in at all. But, when they file things that they say, we need to file this under seal, and we're not allowed to see it, then the briefing for you is not super helpful, And so typically, the way this happens is we are allowed attorney's eyes only access to, documents just like the state and the defendants would be. Their counsel can see things that are non-public, and we don't share them with our clients unless the court orders otherwise. And typically, if the court decides, no, this really doesn't need to be filed under seal, then we can provide it to our clients at that time. But this idea that our clients are somehow going to get access to things that are non-public, that's just not the way this typically works. If they're not public on the docket, if they're public on the docket, anyone can get them. And if they're not public on the docket, then our clients can't get them. And if there's a procedure where we can see them so that we can give the court the benefit of briefing substantively as to what it is, then we keep them attorney's eyes only until the court orders otherwise. So that's just typically the way this works. So, thank you.
All right, anything further?
Your Honor, I'm not going to belabor what's already in the briefing. I do think it's concerning to just cite to a bunch of trial court cases without providing any pleadings or context for what occurred in those cases. I can't argue against what happened in other cases. This is our case. Our case is different. This court has already acknowledged it. There are many interests. We have concerns about leaks, information getting out that shouldn't be.
I have concerns about these shoes. I do not like them. I do not like them, Sam I Am. I do not like them. Or green eggs and ham. It's like it was a boot, but we cut off the calf. It's not my jam.
Out. I think those are valid. And our concern is access. I'm not impugning the integrity of these gentlemen. I'm sure they would act as officers of the court. But the more this court controls the information that ultimately it determines to be private, the more able we are to identify if there are leaks, if there's information that's getting out that shouldn't be, and who did it. So we are objecting to providing the media our pleadings in advance, even just to their counsel. We don't think that's appropriate. I don't see any authority for that. We're asking the court not to consider that. And we're concerned about opening the door to multiple other entities just filing in on this case, getting involved in the proceedings. We don't know exactly what media means either. So our position is and remains, they can file what this court has authorized to file in the manner this court authorizes to file it and be heard in the manner this court indicates. We understand they're entitled to closure hearings, and I did make a mistake. We agree that they have standing to object to closure as well. So they should be able to file those things, but we do not agree that that requires status in our case. So, does the court have any questions?
No, thank you.
Thank you.
All right. I appreciate the argument from all parties throughout this day. I wish to commend the preparation and the quality of the arguments, as well as the civility that is sometimes overlooked, but I wish to recognize that and appreciate counsel's demeanor and their arguments today. I previously stated when we began that I would be issuing rulings on the first issue. And when I began, I initially said October 14th. It's actually the October 24th audio recording of the closed hearing, as well as the October 24th transcript of that hearing. And so I wanted to just make that small correction. But given the the in-depth and necessary arguments made in the closed hearing, I wish to take the time to issue a ruling that will say what will be disclosed and what will be kept private, because this court has a duty to do so. And I would rather do it right and take more time than to be rash and miss the mark. I need to be narrow in my approach, and it is an important issue, and so I plan to do that. In regards to the motion for limited intervention and request for notice of motions to close, seal, reclassify, I also wish to craft my order in such a way that is concise and addresses all the issues, the important issues brought up by all parties. And so I will be issuing that ruling at the same time. And so I will be issuing the ruling in regards to the state's motion to clarify court's pretrial and trial publicity order, and I am prepared to do so. Before I do that, what I want to do is, and counsel is being caught off guard because they were anticipating a ruling today, but what the court is intending to do is, and proposing to the parties, is issuing an oral ruling on WebEx that all parties can attend to. The reason why is I don't want to take a lot of time. These are important issues. I don't want to wait until January 16th. And I want to talk about potential dates. I don't imagine it will take longer than 20 minutes for this court to issue ruling. And I want to get the parties' input in regards to their thoughts of the court issuing an oral ruling on WebEx. And so I'll open it up to the parties.
We don't have any objection to that, Your Honor.
Thank you.
We have no objection to that, Your Honor.
Yeah, same.
All right. Well, next comes the trickier part when you have a room full of attorneys trying to find a date that we're all available. To our staff.
A lot of these are going to be closed hearings. A lot of what, when they talk about very specific maybe evidence or witnesses or testimony, a lot of this is going to be closed for right now, as to not taint the possible jury pool, as they're arguing about whether this information is, let's say, permissible, is more probative than prejudicial. Both the defense, the state, but also the judge have been very aware that this is a very, very charged case. And that because it is so well known, because it happened nationally, publicly on television, the burden of trying to keep as much, evidence behind closed doors as to not taint a potential jury is much higher. Because, anything that gets out, that's why the defense is being so persnickety about the media having any access to the docket. Even though all three of the, lawyers for the media have stated that they are officers of the court, if things are labeled as, not for the public eye, it's not like they hand this over to CNN or Law and Crime, it stays with them. But given how incredibly explosive, political, and divisive this case could be, I imagine that we are not going to hear anything. This is not going to get leaks out. But the desire to get information about this case out is going to be incredibly high.
What dates do we have available for a 30-minute block before the end of the year?
Judge, we do have December 29th at 10 o'clock.
How does that appear? How does that date work for counsel?
That was 10 a.m. on the 29th?
Yes.
Your Honor, that works for Mr. Robinson. Thank you.
Same for us.
All right. And to defense, in regards to Mr. Robinson, what is your position on, if it is on WebEx, he would be appearing by WebEx, or is there different thoughts?
Your Honor, if we could just have audio only for Mr. Robinson to appear, since we will not be present. I would rather not have him in the courtroom without counsel present.
All right. Thank you. I appreciate that. So we will set the court's ruling on those two issues for December 29th at 10 a.m. And note that it will be audio only for Mr. Robinson per defense's request. And to the last issue is, well, before I issue my ruling, I anticipate, and counsel, are we still on the same page in regards to our January 16th hearing? Are we planning for that?
Your Honor, we are. We believe that most likely what we would anticipate doing is on January 16th, arguing our motion to disqualify the county attorney's office, which was just filed. That should give them enough time to respond to that. And also possibly we anticipate filing our own motion about the pretrial publicity order that has a little bit different take on it. That should be filed in plenty of time for us to argue that on the 16th as well. I think we have set aside the 30th, and that might be the one we want to save to argue our anticipated motion that's coming about keeping cameras out of the courtroom. And we will, I imagine the media will, depending on the court's ruling today, will want to weigh in on that one as well. And that would give them enough time as well. So that would be January 30th.
All right, and before I go to the other parties, the January 30th date, there was some complications. And so we have to find another date.
Okay.
And so I just wanted to let all parties know before we lock in our schedules, when.
Okay, but are you going to apologize to me because I just wrote this down in pen?
What dates do we have available for a 4-hour setting?
It's okay. My problem.
And counsel, I appreciate you giving me that roadmap that helps plan, so it allows the other parties to take in consideration dates and filings as well. So as staff is doing that, they are looking for hearing dates. And one of the complications is, as a judge, I have 1,409 cases as of last Friday. And so trying to find a spot is tricky. And I'm grateful for my staff who work so hard to manage that calendar. So that is part of the reason for the delay. And we're trying to find a date because this is an important case, as is all of those cases. They matter to me.
Your Honor, while we're waiting, can I, if I might just make one point that might make things smoother as we go forward with the sealed filings? Just to Ms. Nestor's point, Mr. Novak earlier mentioned something about a redacted motion to disqualify, and I don't know if that is something that they're planning to file, but I was just going to say sometimes, what we heard earlier about that particular incident is probably not something that we care that much about in terms of what they would redact. And so instead of opposing the motion to classify, if Your Honor, I don't know if this is the plan already in this case or whether that's what they were planning to do, but if they file a redacted version that, just takes out the stuff they care about rather than closing the whole thing, then we don't have to say anything and probably avoids, fighting over unsealing that document. So I just wanted to say that. I'm happy to confer with counsel if you'd rather us do that, if you don't want to do it by way of a court order. But
No, I appreciate that input. I'll hear from both parties, and then we'll get to the date.
Your Honor, I do anticipate going through and seeing what we can redact and working with the state on that as well and with media counsel. So.
All right.
And we agree that filing a redacted version is a good way to go. We can work together on that. As far as the January 16th hearing, the state will do everything it can to respond to these motions as timely as we can, as expeditiously as we can. I just want to note that January 16th hearing was set with the expectation, the previous expectation was that defense counsel was going to get us these motions before Thanksgiving. And we just got the motion to disqualify last night. So we'll do everything we can to respond to those as expeditiously as we can and hopefully keep that date, but I'm not guaranteeing that we'll make that date.
All right. I appreciate the heads up. Going to staff, what dates do we have available for in lieu of the 30th?
We look at February 3rd, and we have every day available, so morning or afternoon.
February 3rd, morning or afternoon setting?
Your plan? That works for Mr. Robinson, Your Honor.
All right, thank you. And morning or after?
Okay, I mean, no offense, and I get that we do need to get Mr. Robinson, but he's in what, jail, prison, wherever the hell they stuck him. I mean, does he have, calendars full of macrame and, finger painting? I'm sure every single day is free and open for him.
Afternoon setting.
Either works for us, Your Honor.
All right.
As well as for the state, we're available on the 3rd.
The
Anytime.
afternoon would be better because it may be that it reduces travel time.
All right. Well, it is always nice when all parties agree. So we have February.
We are finishing up, it looks like, the Tyler Robinson hearing. Now, a lot of it, a good majority of it was closed to the public, but we are kind of getting an inkling of how very tenacious the fight is going to be from the defense's side on keeping cameras out, making sure people cannot speak to the media, cannot taint the jury pool. It looks like the defense is very, very keen on keeping a lot of their motions, their pleadings, and everything else behind classified or sealed documentation. So it is going to be interesting because I do think that a lot of the fireworks that we see in these early hearings are going to be. Oh, okay. Sorry. I thought I saw something about the Walshe trial. I do have it playing on my other monitor, but I thought there was a question or something. Nope. Just my phone being late and French and finally deciding to notify me that the closing statements in the Walshe case are getting ready to start. YouTube, you're doing an excellent job with those notifications.
February 3rd at 1 p.m. It is anticipated to be in person, and Ms. Nestor, is Mr. Robinson planning on appearing?
Yes, Your Honor.
All right, thank you. All right, that concludes that particular issue about future dates, and I appreciate counsel working with me on that. We have December 29th at 10 a.m. for the court ruling on these two issues, and that will be via WebEx. And then February 3rd, January 16th, I believe that is at 1 o'clock. Is that correct? All right, that's in person as well with, I believe, defense has indicated Mr. Robinson will be present and also indicating that Mr. Robinson will be present. And in regards to the final issue, the ruling on the state's motion to clarify court's pretrial and trial publicity order. This is the order of the court. The court issued a protection order regarding pretrial and trial publicity in this case. The order prohibits attorneys who are associated with the prosecution and defense of this case from intentionally, knowingly, or recklessly permitting a witness, investigator, consultant, staff member, or other member of the prosecution or defense team to make extrajudicial statements, which, if made by the lawyer, would violate Rule 3.6. To that end, lawyers participating in an investigation or litigation of this case shall inform all witnesses, investigators, consultants, staff members, or other members of the prosecution or defense teams about the prohibitions contained in this order. The state moves to amend or clarify the court's use of the word witness as used in the publicity order because it is vague, ambiguous, or overbroad. The state asserts that there are over 3,000 lay witnesses of the alleged homicide. The state does not know if it must inform each potential witness or each potential and possible witness of the prohibitions in order, or whether the order applies only to witnesses who are members of the attorney's teams, such as investigators or experts. Due to the potential confusion, this court grants the state's motion and offers the following clarification. The word witness, as used in this order, applies to all witnesses who are part of the prosecution and defense teams. This includes any witness, including lay witnesses, whom the prosecution or defense has a good faith belief will be called to testify at a hearing or trial. The court also clarifies that the publicity order as written regulates the behavior of attorneys who are associated with the defense team or the Utah County Attorney's Office. It requires the attorneys to abide by Rule 3.6 and, in order to deter non-attorneys from making prejudicial statements, requires the attorneys to inform witnesses about the prohibitions in the publicity order. Informing witnesses about the prohibitions in the publicity order is a necessary step. It is one moment as I regain my place as I read. Informing witnesses about the prohibitions in the publicity order is a necessary step toward not intentionally, knowingly, or recklessly permitting witnesses from making prejudicial statements. The publicity order does not regulate the behavior of any person who is not an attorney associated with this case. And this order will be signed today by myself and made public.
I actually do very much appreciate that he is going through and clarifying, because I think I think the state does have a very good point that you have a potentiality of 3,000 plus, witnesses. Is it required that everyone that was possibly there, be cautioned or admonished about what they say publicly? Or should they all, basically what exactly is going to be here? And I do think that the clarification of people that we know in good faith are probably going to be called again. While I don't think this is maybe completely just Erica Kirk, it might pertain to other people. I do think that for the defense, being able to limit what the decedent's widow can say publicly will be very important. I would look at possibly the defense filing a motion that Erica has prejudiced the trial with statements at the memorial. Even as distasteful as it is to make that argument, I foresee that coming. It's distasteful to me. Look, I'll just say it. It's distasteful to me, but I see the logic by which the defense could say that, she has potentially prejudiced, the jury pool by what she said and where the memorial was located. Do I foresee that going through? I don't know. But it will be interesting to see what kind of motions are going to be coming forward, because I do wonder, how far the defense is going to take this, and the defense is going to have to be very careful. Their client is extremely disliked, and any attempts, however strategic and possibly within the letter of this ruling they are, to silence Erica may have a very detrimental public opinion backlash. So I do think that the defense has to be incredibly careful with how they present this and how far they go with this extremely opaque stance that they're putting on right now. They don't seem to want the media to know anything. They don't want the media to be party to anything. They don't want anything to get out, and I understand that, but I think depending on how aggressive they are, this could be extremely detrimental and just as prejudicial to Tyler as, anyone saying anything on the internet.
Counsel, is there anything further that we need to address today?
Thanks, Your Honor. Yes, just the matter of having Mrs. Erica Kirk designated as the victim representative in this case. She has filed through her counsel a request to be designated as the victim representative, and we would like the court to formally acknowledge that request and formally designate her as the victim representative. And I guess along those lines, I wanted to make clear as well, I think this court stated earlier that there was an alleged victim in this case. And I know that there is case law talking about being careful about how we refer to victims and alleged victims. But in this case, that case law makes clear that those cautions don't apply with the same degree, where it's clear that we have a victim who was killed in this case. We don't have an alleged victim. We have an alleged perpetrator, but we do know that we have a victim in this case.
Thank you, Mr. Ballard. I'll hear from the parties.
Your Honor, on behalf of Mr. Robinson, we certainly think it's appropriate for Mrs. Kirk to be designated as the victim representative, if that is the desire of the state, just so there can be no doubt that she's afforded all of the rights assured to her under our state statutes, and we have no objection to that.
Thank you. Thank you to all parties. This court will recognize Ms. Erica Kirk as the designated victim representative in this case. Thank you. Counsel, I believe that concludes our matters for the day.
One more
Or maybe
matter,
not.
Judge. I can take the podium, Judge?
Yes, Mr. Gernander.
Purpose, I want to just give the court an update with respect to discovery. We've done that at previous hearings.
I appreciate that.
The state has received approximately 13,900 files from law enforcement in this case. Approximately 300 of those we believe are duplicates. We have since provided to counsel, as of I believe this morning, 7,951 of those files. For the court's information, we had reached close to 100% had been disseminated as of last week, but we received quite a large batch within the last few days. So we were working on that. We still have a full-time paralegal that's dedicated to reviewing that, organizing it, Bates stamping it, and sending it out to counsel. Of course, there are necessary redactions that are being made along the way. Our next real hearing in this case, second matter, our next real hearing in this case is not scheduled till January 16th. We understand the court's caseload. We understand the difficulty of finding dates for a preliminary hearing. And we would like to make a request that the court calendar a preliminary hearing in this case.
All right. In regards to, and I appreciate the heads up and acknowledging the busy calendar of not only the court, but all of you. First of all, how many days does the state anticipate, which helps us in our calendaring efforts?
Judge, given that it's a probable cause standard and all the inferences go in favor of the state is asking for 3 days. We believe that we can present the evidence required to meet that standard, and that would also allow the defense to cross-examine witnesses and argue that standard.
Thank you, Mr. Gernander. Turning to defense, what are your thoughts?
Your Honor, we were not aware that he was going to make that request today. We do have one more member of our team that's not present that we would need to consult with. I don't know when he's talking about, but I don't see how we can set it until all the discovery has been received. And also, we do need to deal with the disqualification motion, just in case. So it doesn't seem like a good idea to set it before we have the disqualification hearing. We were only talking about a month from now. I think that should probably be resolved before we set any dates. But I am concerned about setting a date when we still don't have all the discovery materials. We have significant discovery materials that have not been received yet, that we know are out there and coming and important. And we have to, have time to review it all and absorb it all. And I am going to be involved in another trial that is not over until the end of March. So that's going to take away my ability to work and process through discovery and communicate with our team. So it seems to me that with the understanding of what Mr. Grunander's trying to accomplish, that maybe we come to the hearing on the 16th with an idea about, we can have some conversations with with Mr. McBride and also with the paralegal that's dealing with all the discovery, and see realistically when we think we're actually going to have the vast majority of the discovery materials to us and how long it's going to take us to review it all. So maybe we could just come prepared in about a month to try to accomplish that.
Mr. Grunander.
Just 2 points, Judge. Sometimes I feel like we as practitioners sometimes lose sight of the purpose of a preliminary hearing. It is a probable cause determination. The primary purpose, according to case law, is to ferret out improvident prosecutions. So again, it's a probable cause standard. We are working as hard as we can, being very diligent with respect to collecting and disseminating discovery. Rule 16, subsection 2, speaks to the timing of mandatory disclosures. And it is it's a continuing duty. So as far as complete discovery being provided, in a case like this, complete discovery is going to be ongoing until probably trial. There are times when things become available during trial that are discovered to opposing counsel. But it says here, the prosecutor's disclosures must be made as soon as practicable following the filing of an information, except that a prosecutor must disclose all evidence that the prosecutor relied upon to file the information within 5 days after the day on which the prosecutor receives a request for discovery from the defendant. That's been accomplished. It then says, in every case, all material or information listed under paragraph A1 that is presently and reasonably available to the prosecutor must be disclosed before the preliminary hearing. So we are in the process of that, collecting it as quickly as possible, making any necessary redactions, and moving it to the defense as quickly as possible. But complete discovery is not required before a preliminary hearing. We have to provide it as quickly as possible. We have that duty, and we continue to do that. So we think we can schedule a preliminary hearing and work towards that. I'm aware of Ms. Nestor's schedule. I know she's going to be in trial, I think, in February and March. And I'm probably overestimating the availability of the court's calendar, but the hope would be sometime in April to schedule a preliminary hearing.
All right.
I'll submit it, Judge.
Thank you.
Your Honor, can I just clarify one thing? I mean, the county attorney has made a decision, very public decision, to announce their intent to seek death the day that there was an arrest, which means that that obligation to provide us with the probable cause for everything they relied upon to charge applies now to their intent to seek death. And we're nowhere near getting that material. So that was their decision to release that. Normally, that decision is not made until 30 days after a preliminary hearing. They made it in advance, and now they've got an obligation to tell me their aggravation and what they've relied on to make this a death penalty case. And we have not received that. So I'm waiting, but I'm just laying that out there for now.
Thank you. I appreciate the arguments from all sides. I do not find there is any prejudice in setting a date for a preliminary hearing. It is not set in stone, and it certainly can be moved. I recognize that the parties have a lot of obligations, but I also recognize the importance of this case moving forward, and if nothing more than this is a goal for the preliminary hearing. If it needs to be changed, the court understands that. That is what happens a lot in the criminal calendars and criminal dockets. What is a date that we may have available for a 3-day setting for a preliminary hearing?
Judge, the first week that we would have available is the week of May 18th. We also have a week of some days in June. We could accommodate. We do not have any in July. have some in August.
All right, let's take a look. So council, well, what dates in June?
June starting on the 15th.
All right. Council, I'll turn to you. Again, this is a goal. This is not a date that if we can't meet, there's any prejudice that will be attached to a party. In regards to May 18th, how does that tentatively look for council?
May or June?
May 18th is the first date, I believe.
Oh.
18th, 19th, and 21st.
So 18th, 19th, and 21st, just to give you the full range.
The state can make those days work, Your Honor.
I do feel, I get the defense that she's saying she has to process all of this as well, but so does the state. The state has been processing through this. They are trying their best. I mean, the fact that they have just a ADA or someone in their office who is on top of just going through these files and getting them to the defense, that they have quantitated exactly how many files they have, how many are possibly duplicates, and how many they've sent over, along with a paralegal that's working on this, is far more attention to detail than we get in a lot of cases. A lot of cases, the defense is constantly having to ask the state to hand over discovery. The Richard Allen case, a lot of those, Lori Vallow, when she was representing herself, although I think that's, neither here nor there. But the fact is that the state is doing a lot more, along with, I have rarely heard, the state give a report as to how their discovery transfer is going.
Okay, perfect. Your Honor, we have availability the May 18th with the understanding and the appreciation that if it's not feasible for us to get done when we need to get done prior to that, we would ask to push it back. But we don't have conflicts at this time.
All right, thank you. So May 18th, May 19th, and May 21st. And it will be in person. And do we anticipate, if that date moves forward, Mr. Robinson being in attendance?
Absolutely.
All right, thank you. I just want to put that on the record as well. All right, I don't want to be presumptive, but is there anything else? All right. Counsel, thank you again for your hard work today. And I wish you all, Mr. Robinson, a good afternoon. Court is in recess.
Thank you, Your Honor. Thank you.
All right.
All righty. Okay, so we are done with that. I am keeping the court on watch, and we are just watching a clock. So let's get into body cam footage. Oh, wrong one. No, you shouldn't be watching my channel.
In April 2024, dispatch informed deputies of a semi-rollover in the town of Hope, Wisconsin. Coincidentally, an off-duty cop was driving on I-41 when he encountered a semi-truck driven by a 26-year-old man from Milwaukee that was having trouble staying in its lane and repeatedly crossing the center line over several miles. While passing the semi, the off-duty cop swerved.
You want to terrify Mo, get an 18-wheeler that's crossing lanes and doing that. I have watched Final Destination. I'm afraid of 18-wheelers. I'm afraid of lumber trucks. I'm afraid of everything after Final Destination.
To avoid a collision with it. The semi then drifted into the shoulder, and the driver's abrupt correction sent the truck rolling over completely. Upon arrival, the deputy observed an individual attempting to help the driver get out of the truck.
The guy's there. It's gonna be median side out of traffic. We got one driver trapped right now. I tried to pull the window, but he told me not, so he's walking. Are you okay? All right.
As the deputy peeled back the windshield, he detected an odor of intoxicants humming from inside.
You don't say. What was the first thing that gave it away? The fact that it was on its side and he was drifting across the highway?
All right, can you crawl out? Crawl out, buddy. I'm holding this up. Crawl out.
Don't worry about your ID. You
Come
get
on.
your body out. Let's go.
Crawl out.
Oh, hell no. He is on his side and he's like, I've got my registration and my license. Bless his heart. He was trying so hard.
Watch your head. Watch your head.
Duck down.
Go as low as you can go. Oh.
Anybody else in there?
Is there anybody else in there with you? No. 471 Coney, we got the driver out. Are you injured? You're injured?
I'm okay.
You're okay? You don't have any pain?
No.
No? What happened?
Nothing.
Nothing? Nothing happened?
No.
Did you witness it? All right. All right, why don't we have a seat right up here? Have a seat on the grass for me. Right here, buddy. Have a seat for me. Where are you coming from? Driver's okay. Possible 55. It's going to be a heavy record. Are you fully loaded? What do you have in your trailer?
It's loaded.
What's that?
It's loaded.
It's loaded with what? What's it loaded with? How heavy are you? I'm asking.
It's loaded.
What is in your trailer?
It's loaded.
Yeah, I understand that, but what's it loaded with?
Eggs. That's what he's trying to tell you. It's too late. It was filled with eggs. It seems possibly that beyond the possible language barrier, there is an alcohol barrier too.
What do you have in there? You don't have anything in there? So you're empty?
Yep.
Although the driver claimed his trailer was empty, it was later found to be filled with canned food.
You just want to talk to the witness for me? Get them rolling. So where were you coming from?
From Green Bay.
Green Bay? Where are you headed to?
To Milwaukee.
To Milwaukee? Okay, and what were you hauling?
Nothing.
You dropped something off in Green Bay and you're coming back empty?
Yeah.
Okay. 471 the trailer should be empty. It's going to be a full-size enclosed box on its side. Nothing on the road. I can't tell underneath it in the ditch side, but if there's any fluid spilled, I'm sure there's something spilled, but...
Yeah, there's something, but...
Do you have your insurance?
Yeah.
It's in the truck?
Yeah.
We might have to wait for that. Where's your shoes at, buddy?
It's in my truck.
You're in your truck? You drive with them off normally?
Yeah.
Okay. What are you looking for there? Putting your credit card away? What's the last four of your number? You don't know your number? No? Okay. So how much have you had to drink today?
A lot.
A lot? Yeah? Like
Well, at least he didn't say 2 drinks. I mean,
what's a lot?
I could tell you.
You could tell me?
I could tell you.
Yeah, I'm asking you how much?
A lot.
Like, were you drinking beer, wine, whiskey, vodka? You were drinking whiskey? Where were you drinking? You want to sit down for me?
Yeah.
Why don't you have a seat right here? I don't want you to tip over. Hey, have a seat for me right here. I don't want you to tip over, okay?
Yeah.
Can you do that?
Yeah.
Okay, sit down.
So let's go. Let's go in my truck.
Well, what about your truck?
Let's go in my truck.
We're
no, sweetheart, we can't sit in your truck and talk about it because it's currently on its side. Now, the fact that you haven't paid attention to this leads me to believe that you are not going to win when we do the drunk hokey pokey. But I'm willing to give you a chance. I say we do the sobriety hokey pokey.
We're not going in there right now. We're going to wait till it gets uprighted. Then we can go in there and get some stuff.
You have a seat right now.
I don't want you to tip over. I can't hear you. What?
Whiskey, vodka.
Whiskey and vodka?
Yeah.
Where? While you were driving? Yeah, I was driving.
You didn't stop at a bar or anything like that? No?
I was driving in a bar.
Okay. When's the last time you had something to drink?
In Winnipeg.
How long ago was that?
Like 2 hours.
2 hours ago? How long you been driving today?
2 hours.
You've only been driving for 2 hours? Where did you start your trip? Down in Milwaukee? You started in Milwaukee, went to Green Bay, and now you're going back to Milwaukee? Yeah. You must have been driving for more than 2 hours. Yeah. All right. Can you look and see if there's shoes easily available? What color are your shoes? What are you wearing? Tennis shoes, boots, or what?
Shoes.
Like these?
There's nobody else in there?
I just want to put shoes on him. Yeah, right there.
There, you got it.
I see boots and sandals.
What do you want, boots?
Something for his feet. I see 2 sandals. Just grab those. That'll be easy. Yeah, right there, and then right by your hand here. I can put them to the field with that. Yeah. All right, buddy. We got you some shoes. Why don't you put these on? Can you put those on for me? Yeah? Okay, do that. What?
Because you were drunk, you were driving a big-ass machine, okay? You were basically in charge of Optimus Prime, and you were drunk as balls. And yes, that's why we're treating you like a bad person, because you know what happens? You end up turning over your truck and falling on, a bus full of puppies and orphaned nuns, and you walk away scot-ass free. So that's why we're treating you like a bad person, because you've basically told everyone else on the road, screw us, you'd like to drink. That's why we get a little irritated with you.
This guy, he just me like a bad person. I don't want him to treat me like a bad person.
Take you to prison?
I don't want him to treat me like a bad person.
Oh, no, we're not treating you like a bad person. I just want you to put your shoes on, because based on what I'm seeing, I want to put you through some tests to make sure that you're okay to drive, okay?
Okay.
So if you can put those on, then we're going to walk up to the squad car. You want to do that for me?
Yeah.
Okay, thank you. Can you put the other one on for me?
Why don't you put your other shoe on for us, boss?
There you go. All right, we're going to walk up to that squad car with the lights on right there, okay? You do that?
Yeah.
All right, let's go. You need help?
Yeah.
All right. You got any weapons on you? Any knives or guns or anything like that? No? So how did this happen? How'd you tip over? You don't know? Were you wearing your seatbelt?
Look, as I tell my mom when I was learning to drive, those mailboxes jumped out of nowhere. Oddly enough, she treated me just like this cop did. She didn't believe that the mailboxes jumped out and attacked me.
Weren't? All right, just stand right in front of right here, buddy. Stand right here. Lean against that. Just hang out right here, okay? Think you were injured at all?
No.
You're feeling okay?
Yeah, I'm okay.
You're okay? Okay, good.
So I'm gonna get to lucky and then.
Yeah? Okay. Do you have any injuries on your body anywhere, like prior to this? Like, do you have any physical defects?
I'm not doing any weapon.
Okay. Did you ever hurt I'm not talking about just today, like, have you ever injured yourself, like your ankles, your knees?
No.
No? You said you were drinking whiskey and vodka today?
Vodka.
Just vodka? Okay. And you last had a drink up in Green Bay?
Yeah.
When you dropped off your load?
Yeah.
You had a couple drinks, or how many did you have? 1, 2?
I can't remember, but I remember that I had like 2 bottles of vodka.
2 bottles?
Yeah.
Like, are we talking little ones, big ones? Little ones? Your drink was last in Green Bay.
Yeah.
And then you were driving here, and then this happened.
Yeah.
You don't remember how that happened?
Yeah.
Were you just driving and?
I was driving there. I just remember that my truck just fell over.
It just fell over?
Yeah.
Damn thing fell over on me. Damn thing, some bitch gravity just attacked me. He's like, officer, I was just driving and all of a sudden Isaac Newton and gravity assaulted my truck.
Okay. I'm just going to pat you on, make sure you don't have any weapons, okay?
No.
I'm not going to search you.
I'm not a violent guy.
No, I'm not saying you are. I have to do it for everybody that I deal with.
All right.
You're good, man. You're good.
I'm relaxed.
I got to do that.
I'm relaxed.
For my safety, okay?
It's a job, but...
So I'm going to put you through some tests now to make sure that you're okay to drive. Okay. You good with that? So just stand off my truck or my car a little bit. Come to me. Okay, stop. What I want you to do is I want you to put your feet together, put your hands down at your side. and you're going to stay like that while I do this test, okay? You understand that? So I'm going to be checking your eyes, okay? What I want you to do is I want you to follow the tip of my finger with your eyes and your eyes only, keeping your head perfectly still. Do you understand that? Okay. You got that? Just keep your arms down at your side, all right? Keep your head perfectly still, like watch my eyes. Like I'm following my finger, see that? Just use your eyes to follow the finger, okay? So watch my finger right here.
Okay, this man is gonna get run over. Again, I have seen Final Destination and Bride of Chucky. All right, why are we doing this right next? Every bit of the mom in me is like, get away from the road. All I see is this man weaving and tipping, and I'm like, why are we doing this on the shoulder? Seems like a great idea. Look, he is obviously drunk as a skunk. You can wait to take him to a flat, like, parking lot or somewhere, because I just foresee a Final Destination and, you know, a cleaning of the asphalt happening here.
Ready? Oh, you're moving your head. Do you know what I mean? Yeah. Like, keep your head, pretend your head can't move. See my finger? You're looking at me, buddy. You see my finger? Follow my finger, buddy. Do you see my finger way over here? Yeah, I see. Look at my finger. I see it. Okay. You're not understanding what I want you to do, I think. I do. You're having a hard time doing it, though. I'm going to try a couple more times, all right? Would it help if I use a pen?
In my defense, any officer that ever pulls me over, I couldn't tell you my right from my left, even stone cold sober. I'm dyslexic and I tend to be really directionally challenged. Also with that ABC thing, yeah, that's not going to happen. So I'm willing to do other tests. I'm just letting you know that I will never, ever be able to do that count backwards and forwards thing. I mean, that's not even something I'm going to achieve sober, okay? And I will not be doing the alphabet one.
You see that better? Okay. You keep your fingers down. Move it to the left. Yep. Left. And then you look at it. No. Left. Okay, watch it. Move it to the left. Right and left. Follow it with your eyes. Keep your head still. No, you keep your hands down. Ready? Here we go. Okay. Look up at my finger. Don't move your head, buddy. All right, no, hold on. We're not done. We're going to do a couple more. You stand right here, okay? I want you to imagine a straight line, okay? Yeah. Going right from your feet to where that officer is, okay? Can you imagine a straight line going right that way? Yeah. Okay, so we both, hold on.
Okay, officer, please, God, don't tell him about a straight line. He is going to run right into the road on that straight painted line because he's a moron and he's drunk and he doesn't quite understand what you're saying. So why am I playing the part of OSHA? I feel like I shouldn't have to be the safety monitor for body cam footage.
So we both know where that line is. What I want you to do is I want you to put your left foot on that line, put your right foot on that line. So you got your left foot, and I'll put your right foot in front of your left foot there. Right? Oh. Look at my feet. Ready? Left foot, right foot. Remain in that position while I explain the rest of this test, okay? Yeah. And you're going to take 9 heel-to-toe steps down that line. Yeah. A series of small steps. You're going to turn around and take 9 more back, okay? Yeah. I'm going to demonstrate this for you, okay? So watch my feet. It's going to be 1, 2, 3, taking a series of small steps. For demonstration purposes, I took 3. How many are you going to take? How many steps are you going to take? 3. No, 9. You're going to take 9. Okay? Do it. I just demonstrated it.
Okay, for those of you from the UK, David Lammy has been pulled over. For those of you who don't watch a lot of UK news, then that doesn't really bother you, but ladies and gentlemen of the world, I give you David Lammy. LOL. Just kidding. Allegedly in Minecraft, and I don't live in the UK, David, so you can't really get mad at me.
For you. Do it for me. You want me to demonstrate again? Yeah. Okay. 1, 2, 3. You're going to take 9. I did 3. While you're doing this test, I want you to look down at your feet, count your steps out loud, and keep your arms at your side, okay? Do you understand that?
Yeah. So, do it for me. Let's go.
We got to do a couple more, and then we're going to go.
Okay.
So do you understand what I want you to do?
So, I want to do a demonstration.
No, we're not doing any demonstrations. I got to do these ones, okay?
Okay, so let's go, and then...
Do you want to do that test?
Yeah.
Okay. Why don't we do it? Remember, left foot, right foot? Do you understand everything that I explained?
I know.
Okay. You ready to do it?
Yeah.
Okay, whenever you're ready. Get in that position though. Left foot, right foot. Whenever you're ready, you can begin.
So
Look, just like I told you told me you understood. I want you to do 9 steps.
Okay, when Mo is president, instead of this, we are doing the Cupid Shuffle. Now, this will get all of us dyslexics really confused, so, but it will be more hilarious than this. Now, for dyslexics, you will be able to do this. That doesn't mean we will still actually get it, but we will be given, you know, this accommodation.
Take a series of small steps, 9 more back.
What do we to do?
Okay. Are you ready to do it?
Yeah.
Okay, go ahead whenever you're ready.
Ooh, he's got a little swager in there. I like that. A little dip and sway. A little bend and snap.
Yep. Just like I told you, 9 steps. You done?
Yeah.
Okay, let's go back to the car. We're getting a little far away here. Stand right here for me. Okay, face me. So for this test, you're going to pick up either your left or your right foot, just like this. And you're going to count in a manner of 1 1,000, 2 1,000. Keep your arms down at your side and count out loud. You understand all that?
Yeah.
Which foot do you want to raise?
So what do you want me to count?
You're going to count like this. 1 1,000,
Your fingers.
2 1,000, until I tell you to stop. Can you do that?
Oh yeah.
So which foot do you want to pick up?
Left.
You're going to pick up your left foot?
But I want you to.
We'll get to that after I'm done. I got one more to do after this.
But I want you to understand that I'm not joking.
Okay.
I'm not joking.
I'm not.
Okay, Brian Walsh, you're also not guilty.
I'm not saying you are. Are you ready?
I want to understand my
Okay. Yep. All right. You can begin.
Eh?
You can begin the test. You're going to pick up your left foot?
I want to pick up my chop.
Okay. I got one more test I want you to do, okay?
Okay.
Then we're done. I want you to take a breath test, okay?
Yeah.
Have you ever taken one of these before?
Yeah.
Yeah? So what I want you to do is like, have you ever blown up a balloon before?
No.
No?
Never.
Never?
Never.
Okay. See it's at 0? Okay, what I want you to do is I want you to take a real deep breath in. You're going to put your lips around the straw, real nice and tight, and you're going to blow until I tell you to stop, okay?
Okay.
I'm going to hang on to it though, okay? Okay, take a real deep breath. Blow, 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 blow. You're sucking in. There you go. Keep going, keep going, keep going. Okay, stop.
After agreeing to a preliminary breath test, the result came back as 0.297.
So what do you get?
So apparently that verbal, you know, breathalyzer where he was like, I am not drunk. Now, the actual preliminary breathalyzer says that gravity did probably not assault this man. This man was drunk and drove off the road. But let's see how he handles the fact that he could be intoxicated despite his verbal attestations that he is, in fact, sober.
What's that?
What do you get?
What do what?
What do you get?
What did it say? 297.
So
That's not good.
am I drunk?
You are drunk. I'm going to place you under
just
arrest
a
for
scotch.
operating a motor vehicle while intoxicated, okay? We're going to go to this car here now. There you go. Did they advise any priors?
None. No prior. I'll see if we can get the video from TV on.
Yeah. He initially told me he was drinking and driving, and then he told me he was drinking up to Green Bay, so I don't know. There might be
I want to make sure we all know I'm not drunk. Oh, okay. Thanks for clarification.
So you've never been arrested for an OWI before? No. How long have you been driving truck?
2 years.
2 years?
How long have you
gotta
been
be
driving
patient.
drunk?
Let's go. Drive me to jail. Let's go.
Oh, hell no. Oh, hell no. This is again why I cannot be a cop. Because if you start ordering me from your back seat, do you know what the petty in me decides to do? Oh no, we are driving Miss Daisy to the prison. You would like to get there soon? I am driving 5 miles under the speed limit. I am keeping my left blinker on the entire time. Don't play with me because I will pull out petty police.
Drive me to jail. Let's go, man. Let's go.
We either have somebody pick you up and take you home, or you go to jail. I can't order an
Why
Uber.
can't you just use my credit card and then...
That's not how it works, man.
Oh, hell to the tell to the no. I am not ordering you an Uber. Do I look like your mother, your wife, or someone that gives a damn? No. Yes, I know that's a bad.
And I need somebody to take responsibility of you. So it's either a family member comes up here and grabs you, or you go to jail for 12 hours. No. Until you sober up, and then you can call for an Uber. Can you come out?
So you understand how you messed me up?
I understand how I messed you up.
Yeah.
I never said you're a bad guy. Go in there. Go in there. I never said you're a bad guy.
I'm not the person.
I know.
Let's do it.
No, remember, we're not going to do the Uber. Your wife has to come get you. Either your wife or a family member, or you go to jail.
Uber.
Uber's not going to work.
His wife doesn't know how to drive. Allegedly in Minecraft, but speculating based on being able to observe patterns.
I need to sign you off to somebody responsible. So you haven't been drinking or using drugs?
No.
No? Okay. Are you under the influence of alcohol or drugs at this time?
Right now?
Yeah.
Yeah.
Were you involved in a crash today?
No.
You don't understand the question? Were you involved in a crash today? While you were driving your truck, did you crash your truck?
Yes. Oh, good. That's all.
DoorDash? They ain't gonna take you home. Listen to me. Take a deep breath and blow out that way. I want you to practice, because I want you to get this right.
Let me do it.
I'll hang on to it. Don't touch it. Blow up a balloon. Blow, blow, blow. Keep going, keep going, keep going, keep going, keep going. Sit down. This is your last chance. Deep breath. Don't touch. Blow, 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 blow. Keep. Sit down. Try 3 more times. Don't touch. Blow, blow,
So he's
blow,
blowing,
blow.
or he's
Is that
sucking
your best
in.
sample?
Yeah.
Blow. Are you gonna blow? Blow air into this.
Exhale into the tube.
Keep going, keep going, keep going. Blow. Do you understand what I want you to do? Blow. Don't suck. Blow. Blow. Keep going, keep going. Okay.
This is unintentionally hilarious. Okay.
Sit down. You were the best driver of the month, of the year, or what? The month?
He was the best driver of the month.
Listen to me though. This is your last chance. I'll give you your phone right now. You can call your mama, your girl, whatever she is to you. You can call for a ride.
Okay, let's give.
You want to call and ask for a ride? Call her and ask for a ride. I'm going to stand here.
Can I call a friend or?
A friend?
Yeah.
You got a friend from Milwaukee or what? Yeah.
You
Dude, I've
have
been
a
asking
friend?
you that all freaking day. We got to call somebody. This is your last chance. Call for a ride or I'm taking you to jail right now.
Can you give me the address?
Let's make sure we got somebody coming first. We'll probably go.
Hello?
Ask for a ride. Tell her we'll meet her at Quick Trip in Richfield, off of 41 where you were. Highway 41 in Holy Hill Road. Quick Trip Richfield. Did you hang up on her? What? Why'd you do that? Why'd you do that? Call for a ride or we're going to jail.
Officer, can you believe what I'm going to it now?
I bet it sucks, but it's not the end of the world. Answer it. Do you want me to talk to her?
No.
Okay, we're not gonna. I'm literally. You want to make a call or not?
Then you're gonna sit in jail for 12 hours.
Okay, just you guys, just be quiet.
We don't have all day.
But I'm telling you, tell her to pick you up at.
I will.
Do you know where I'm talking about? The Quick Trip in Richfield?
Yeah.
Right off at I-41?
Yeah. I will talk to her.
Dude. Look, as your third-party intervener that you didn't ask for, you are about to get to walk away, but you are putting yourself in jail. Right now, you are acting like you get to talk to the manager or some shit. No. Hush your mouth, call your wife, take the hit, you drank 2 big bottles of vodka, and you dumped your truck over. Deal with it.
Okay, you tell her that.
What you guys?
Okay, I'll shut up.
Yeah, can you pick me up at the Quick Trip in Richfield? I want to.
She wants the address?
I can just. But don't just tell her you were police.
Okay, she's got it.
Good luck with that one.
How many people?
How many DUIs do I have?
Yeah?
0.
No?
0. Zilch. Nada. That's her right there? He rolled it, and he was arrested for operating a motor vehicle while impaired. We went and got a blood sample, and now he's being released. It's his first offense, so it's essentially a very expensive citation. I mean, he's going to have repercussions down the line with his job.
Subsequently, the driver was issued all his paperwork and released to his girlfriend.
Okay, you're good to go. You got your phone, your wallet, your ID?
Yeah.
Okay, do you have any questions for me?
No.
Okay. Do you want me to explain that to her? Do you have any questions for me?
So when he rolled it over, was anybody hurt or was
No,
it just?
it was just him. It's almost a 3. The legal limit for driving a car like this in the state of Wisconsin is a .08. He was almost a .3. That is very high, especially for driving a commercial motor vehicle.
As a result, the 26-year-old Milwaukee man was cited for operating while intoxicated, first offense, operating with prohibited alcohol content, failure to keep vehicle under control, and operating a commercial vehicle with prohibited alcohol content. The total fines exceeded $2,400. However, a few months later, he was found guilty after pleading no contest to operating while intoxicated. The other citations were dismissed at the prosecutor's request. Head over to Code.
All right, so now we go to how missing dipping sauce turned into a felony arrest. I mean, because how couldn't it? I mean, I know that I get really irritated when they don't put extra zesty sauce in with my, onion rings, even though I paid the extra 50 cents.
Yeah, I saw it as I was just walking down it, so literally I saw it grabbing and dropping my bag.
It starts with a simple disturbance call.
When this incident happened, would you say that it put you in fear at all?
Yeah. Maybe a little anxious, definitely.
But as the investigation continues, what seems like a bizarre matter to some sends the involved party straight behind bars.
Is that really what I'm being charged with?
It is.
Even though it wasn't. Oh my God, those for sauces. What?
But
go to Chick-fil-A, they give you all the sauces you want.
Right.
On Friday, November 29th, 2024, at approximately 1:52 p.m., a Largo police officer is dispatched to a Raising Cane's restaurant in Florida following.
Honestly, I am the princess. I'll write that down for Monday, but I actually had to order a new. So I really like. We're on tangent. I really like the legal notepads with the spiral tops. And I had to order another 10-pack. I am saving all of my pennies and dollars for it's called a Kindle Paperwhite, but basically it's like a tablet that feels like paper that I can write on because I just really like the tactile feel of paper. But that way I can upload my notes if you guys have any desire to see what I'm writing down all the time. But it also clears out because I go through a notebook, a trial. So Mr. Mo will be happy that I no longer have 97,000 notebooks running around because then I feel I never want to throw away my notes. Now you guys probably can tell or can't tell, but I have, if you guys have ever seen Seven, I have Seven John Doe handwriting. I always thought I was going to get beautiful loopy girl handwriting. No, John Doe from Seven handwriting. So I do tend to take a lot of notes. They may not have any sort of relevance to you guys, but if you guys want to look at them when I get the digital note thingy, I can just upload those. I'll probably have to have Shizzy walk me through how to make a site or Mr. Mo, but yeah, we can do that. I always hoped I was going to get really cute girl handwriting. Like when I grew up, I always thought I would really start to like salads. Neither of those things ever came to happen.
Reports of a customer causing a disturbance.
Ooh, not Raising Cane's.
Is there a out of here? Are you on us? All right. Where do you want to talk?
Outside?
Yeah, outside's fine. We'll just go over by the car.
Perfect.
So was this today?
Yes.
Okay.
Like
Is
around
she?
1:45?
Do you know her personally?
No.
Okay. So what exactly happened?
So apparently she was missing 8 cane sauces out of her tailgate order, and I replaced it for her. I let her know, hey, we're so sorry about that. Gave her the 8 sauces. She wasn't happy about it. She wanted more sauces for free. I told her, hey, we can't do that. That's not our standard. That's not our policy. She didn't like it. She kept saying how she wasted her gas driving all the way back up here. Just basically just upset that I wouldn't give her anything for free. And so she asked for my name, and by our standards, we're not required to give it to her for security reasons. And I let her know that, and she didn't like it. So after asking me another time, and I was like, hey, like, I'm not gonna give you my name, she goes and she grabs my keys, and then she grabs my thigh with it, and she's like trying to look for a name, realizes there's no name on it, and she lets go, turns around, and leaves.
And what time did she initially come in?
I'm gonna want to say like around 1:15, 1 o'clock, around there.
Is it all on footage?
Yes.
Okay. So she comes in from mobile pickup inside at, we'll find the exact hours, grabs her bag, and then leaves?
Yes.
Okay. Then she returns.
And at first she calls about it, and then she walks in, and we're like, okay, you're on the phone with us, but you're also already here too.
Yeah.
I think-
Okay. So she
I think moving forward, I think it's a younger white chick with like newer modern Junko jeans, so not quite as baggy on the bottom, and I think she has like Skittles hair. Now that's not a pejorative to me. I have had Skittles hair myself. I have Skittles hair wigs, so and thank you, Major Mom, for the super chat. And I am keeping an eye. The general consensus over on Law and Crime is that we are going to be waiting until 4. That is their general consensus over there, is that we are going to get a verdict at 4 o'clock. I don't know. I mean, it's Law and Crime, maybe, but I am keeping an eye on it.
returns an hour, we'll check after calling.
Oh, and thank you, Major
Was she
Mom.
on the phone when she walked inside the
appreciate that so
restaurant?
much.
And are you able to find the phone number as well?
Yes, it's on our mobile tablet.
Okay. So she comes back inside. She's on the phone. Who approaches her? Do you approach her?
Yes, I walk up to her first because I can tell that she needs something.
Yep.
And that's when basically the whole incident started.
The customer is 31-year-old Mackenzie. The incident was captured on the restaurant surveillance cameras, and the
She looks incredibly young for 31. I mean, okay, are those real freckles or are those painted on freckles? And I have a question. Why are we painting freckles on? I don't get this. For basically all of cosmetic history, we have used foundation to cover freckles, and now we are putting on foundation and now painting on freckles. I give up. Humanity has gone insane.
customer is 31-year-old Mackenzie. The incident was captured on the restaurant surveillance camera.
I think freckles are cute. I just don't understand if you don't have them while you're painting or tattooing them on. I think that they look cute if you just have them, but I believe that those are ones that she did themselves. Or did herself, because that is sort of a trend here lately. Again, why you would do that, I have no idea, but hey. Again, not my kid, not my taxes, not my... Okay, wait. No, all right. Sorry, I thought I kept seeing that...
And the officer would soon
verdict was
find
in, but
multiple
no.
eyewitness accounts testifying exactly what they saw.
And then, do you know which hand she used to try and grab your lanyard?
I think like her left hand, I think so. Yeah, because her phone was in her right hand still.
Okay. And where is it? Is that on your, like, your belt loop?
Yeah.
And then, so she grabs the lanyard. Like, how far out does she pull it?
I don't think that far. I think when she turned it around and realized there was
okay,
no
this
name
is
on it,
not-
that's as soon as she let it go.
Here, we'll watch. Thinking
On the
of
morning
taking
of
an
April
illegal
2nd,
drug.
2025, police were dispatched to a residence in West Salem, Wisconsin, following a report of a domestic disturbance. A 20-year-old man had moved in with his 78-year-old grandmother about a week earlier. Since then, she noticed that he had been displaying signs of paranoia and wasn't sure if it might be related to drug use.
Let's see. I'm going to go ahead and say yes, but I've never seen this. I'm going to guess that it's likely not street legal pharmaceuticals.
That morning, these concerns escalated. She recounted that he came downstairs after waking, grabbed a popsicle stick, and went back upstairs. A short time later, he returned holding the popsicle stick like a knife, said, "I gotta kill you," and began making stabbing motions, striking her on top of the head. After being hit roughly
With a popsicle stick? Okay. All right.
10 times, the grandmother managed to escape the house and run to a neighbor's home for help. later stating that she saw a look in her grandson's eyes that she had never seen before. Police arrived shortly after and went to the neighbor's house to speak with the grandmother.
Oh, so somebody's in the back so he doesn't run out. He's in there.
They think she might run out there if you guys want to hang out, but... Hi.
I'm a good grandma.
I'm also Donnelly.
Do you want the channel?
Not yet, no. Thank you.
While talking with the neighbor, officers noticed the grandson watching them from the front window of the home.
Oh, he's looking out the door.
Be advised, he's watching out the front door. Step over, thanks. Get it? So what happened today?
He's been acting paranoid. Him and his sister had a fight. He was living with her, so he moved out and staying with me till I got a new apartment. But lately, he's been so paranoid. You can't tell. He's always right, and you are always wrong. And we tried to make things better, but he just wouldn't accept that. And then this morning, he came downstairs out the door, and I don't know what he did in the kitchen. He went back upstairs. The second time he came downstairs, he had a popsicle stick in his hand, and he said, "I gotta kill you."
He said, I gotta kill you.
I gotta kill you. I said, "What's the matter?" "Well, let's talk about it." And he said, "Oh, Grandma, no." He said, "I have to kill you." And he started hitting me with this popsicle stick on top of my head.
How was he, like, poking you with it or just in his hand?
He was hitting. He was hitting.
Yeah, she's got blood on top of her head, but it's not bleeding, gushing, or
Okay,
anything.
do you want an ambulance to come check you out?
No, I think I'm okay. He hit me many times, and he had me to the ground, and I managed to get up once. And then I headed for the door, and he got me down. I fell again, but I was close enough to the door I could unlock it and undo the knob and get out. And then I came over here. But he didn't come after me, which I thought I was scared because I thought maybe he would. He was that mad at me. You could see it in his eyes. He's not a drug user. He wasn't. Put it that way.
Okay.
He did use some marijuana a couple of years ago and has always said that he has quit. Well, then he lost his key to work, and that just kind of...
Yeah, he called me about that the other day.
Did he?
Yeah,
He just kept...
paranoid, like you
Right,
said.
calling and talking. And well, he slept all evening last night. When I went to bed, he was fine. He got up and he said, "I'm going to bed." So, okay.
When did he say that?
Last night. And then this morning, and he had a look in his eye that was like the devil. I'm not kidding you. I knew something was up. Before he got downstairs, I found this black package of little round orange glow things, it was called. And it said to take 1/27th of a 1/27th. How do you measure that? But anyway, have you ever heard of that orange glow? I don't know what it is.
Yeah, it's one of those, I think.
The only
Is
thing
that-
I could think is like a THC gummy or something.
Yeah, it's like it's
Yeah, I was. Oh, yeah, it's a gummy. Grandma found his gummies. Yeah. Also 1/27th. Those are strong. Allegedly in Minecraft. I mean, if you're only supposed to take 1/27th.
stuff like a gummy bear. If you'd look, oh my God, if I'd have met him somewhere and didn't know him, he'd have scared me.
So just to recap, you were just at your house, came right over here after this whole incident, so maybe a half hour ago. He came downstairs, grabbed something, went back upstairs, and then he came back down with a popsicle stick in his hand and was holding it like
a knife.
And said, "Grandma, I gotta kill you."
Yeah, well, he
And
didn't say grandma, he just said, "I have to kill you."
I have to kill you. And you said, "What are you talking about?" And he says, "I have to kill you." And then he lunged at you and started hitting you on top
Well,
of the
actually,
head.
I had gotten up to walk to him to find out what was the matter, So, tell me what's wrong, and I have to kill you, wham, with a popsicle stick.
Okay, on top of your head. And he just kept
times.
stabbing you like a knife, but hitting you.
Right.
And then I know you said a lot. Do you have any idea how many times did you estimate?
Oh, 8-10 times.
8-10 times, and you fell to the ground?
He knocked me down, and but I had fallen close enough to the door where I could unlock it and get the doorknob open and knock my glasses off. They're broke over there somewhere.
And you have no idea why. Just
Nope.
maybe something to do with what he was taking, I assume.
I don't know. I've never seen anything like that in the house.
Okay.
I don't know.
Is he the only one home?
Yeah.
Okay. How long has he been living with you?
Maybe 3-4 days left. Well, let's see. What is it?
Has he lived with you before?
No, I don't think he has.
I normally don't ask this in these situations, but I need to, just in case it doesn't, I'm going a little technical here, but it needs to qualify as a domestic for a mandatory arrest. If it doesn't qualify as that, would you be willing to pursue charges?
Yes.
Okay.
He can't come back in my...
Normally I don't ask that, but being if he's living with you for only...
And I am glad that Grandma is not letting him back in the house. Sometimes I do feel like grandmas and maybe those of us who are really nurturing want to give people infinity chances. But I'm glad that this grandma is thinking of her safety first, even though it's probably, a hard decision for her. yeah, she needs to be safe. He needs to be safe, but she needs to be safe too.
For a week. So he'll be arrested. We'll put a no contact with you or your home. This is going to be a really silly question I have to ask though. Did you give him permission to hit you? It obviously hurt. It still hurts,
Yes.
from my understanding. Is that your arm?
That's my arm, yeah. I don't know, I think that's a cut from.
Would you mind just leaving it for now?
Sure.
I'm going to go take care of this, and then I'm going to come back and snap some pictures.
Okay.
And then we got some other forms for you and stuff,
Thank
okay?
goodness for Susie.
I just got home.
Yeah. Do I have permission to go inside your house?
Yes, you do.
Okay, and he's the only one there. All right, thank you now.
The information was then relayed.
And I just like how very calm and polite he was. I mean, now granted, he was talking to someone who's calm and polite back to him. So I can imagine that it's easy to be calm and polite to someone who's being calm and polite with you. But this is, a good example of being kind, de-escalating, trying to keep it calm, but getting all the facts, making sure you're getting the right story, that you're listening and taking in all the information. So this is good. Now, I'm sure this is going to go into, just a lovely little dumpster fire very, very soon. So sure, her grandson will be nothing but the most respectable gentleman ever.
To the other officers, and they decided to make entry into the home.
All right, so we have permission to go in. I definitely have charges. I got to get them all sorted out, but right now we got elder abuse and battery. He said he's paranoid right now. She doesn't know if he's on something. She found like little gummies. I'm thinking THC gummies. Came downstairs with a popsicle stick of all things and said, "I have to kill you." And she's like, "What are you talking about? What's going on? I have to kill you." And then he started stabbing her with the popsicle stick, hitting her in the head 5-10 times. She fell to the ground and was able to crawl out the door and run over to neighbors. She said, "Go in if you need to. He should be the only one home."
How do you think they're coming in? Silver Drive.
Yeah. Well, can she? Well, they're both kind of.
Yeah. Sorry, Michelle. I know you're here. I shouldn't talk to you.
Sorry. I guess I'll leave that up to you. Normally I would. She's a cop.
Okay. You guys back door? Okay.
Oh, and he's on probation? Yeah, this is going to end well.
Just go in.
You got consent?
Yeah.
I would say let's go in and announce at the same time.
607, hold the channel.
I'll go lethal, you go taser in hands. Yeah?
She taser certified?
All cars. I don't have a taser though.
Lethal taser hands.
I understand she's not taser qualified, but are you telling me there's not one of them big other guys, hanging out? We're letting the female go hand-to-hand combat? Sure. I mean, it seems like this is going to end real well. Again, if she can perform to all the standards that we require of the men and able to subdue a subject, I have no issue. But reality is that she's not a very big woman.
Salem police! Show me your hands. Stop.
Stop, please.
Stop. Down. Down. Stop resisting. Down. Get down. Stop resisting. Stop resisting. Stop resisting. You're gonna get tased.
Due to his active resistance and aggressive behavior, OC spray was deployed directly to his face, eventually affecting everyone in the room.
Right in the face.
Stop resisting!
Ew. And someone had to touch his feet. That's another felony. That is a foot felony.
Give me your hands! Give me your hands!
Again, the 30... Okay, look. Again, I'm terrible at guessing weights, but the 120-pound 5'6" chick, maybe you could have gotten one of the 6'4" MFers that was hanging around. Again, not judging, but judging.
Go.
Since the OC spray had little to no effect on him, he was generously introduced to 1,200 volts of electricity.
Yeah.
Where is your taser?
Someone's down.
Where is your taser?
This is how this is gonna go. You gonna put your hands on your...
At this point, it would be faster if I got my crippled behind out of my Barca lounger right here and tased him.
Back and get it tased. Stop.
True.
All right. Stop resisting! All right. Get on your stomach! Get on your stomach!
Jim, you want me to grab one hand?
Stop resisting! Another cycle back.
I got this hand. I'm not gonna let it go.
Stop resisting! Turn over!
There's more units right now!
Yeah, but I'm just another cycle.
Stop resisting! You're gonna keep getting cycles until you stop resisting and put your head behind your back.
Alright. Stop resisting. Okay, Michelle, you want to get handcuffed?
Yep.
Noticing little effect from the pepper spray or taser deployments, officers suspected he may be under the influence of drugs.
You think? What was your first clue?
Oh, you got one? Got that out?
Alright, I got
Come on. Stop
The magical meth powder? The crystal enhancement?
Not here to hurt you, because you are going to go in handcuffs.
The power of PCP
Put your hands behind your back.
compels
I
you?
don't want to hurt you. Here you go. Alright. Stop resisting.
Put your hand back.
Put your hand behind your back. Put your hand behind your back.
back here.
Behind your back.
Put your hand.
Nobody else. We still need help here.
No, good? Who got that? You got it?
Got this left. I got his left. I'm good.
I'll radio.
Yeah?
I got him.
21, Bruin Alskin 22, 195.
Who's getting
Are you okay? What's wrong?
I'm bleeding.
What's that?
I'm bleeding.
You're what?
I really don't know.
I really don't know. I'm gonna search you down. You got anything on you? I should be aware of any drugs, bombs, booze, nuclear weapons, Abrams tanks, nothing like that?
Nothing.
After he was in custody, officers confirmed that the ambulance was responding emergently not only due to the taser and pepper spray, but also because of his behavior, as they believed excited delirium might be a concern.
Take tri-state, multiple taser deployments, and pepper spray. You alright? Yep, good. I'm gonna roll you towards me, alright? Help me out a little bit. You good? No, your eyes are hurting. We'll get you some water. Alright. You need, they're hurt, right? Get you some water for your eyes. What'd you take today? You didn't take any drugs or narcotics?
Oh yeah, no, he is perfectly sober. That face speaks of sobriety. That is the most sober pupil-only eyeball I've ever seen.
No, nothing. No, mate, I mean what? Okay, I'm gonna sit you under my butt, right? Stay right here. Listen, look at me. Look at me. What did you take today? The ambulance is coming, they're gonna check you out. What'd you take today? We wanna help you. Got it?
Are you good, buddy? Yeah. You got more of a dose than me. I just came in for a little bit of airborne stuff. Thought I could already smoke.
Clear out the sinuses.
Do you have anything in your system you shouldn't have? I'm not trying to get you in trouble, I'm trying to help you. Trying to help. We're trying to help, man.
No, and he's trying to understand why the gummy bears are talking in human. This man is not on the same planet as you. You are, in fact, right now looking like human Muppets. That is why he looks terrified.
You got anything in your system? No drugs? No alcohol?
No drugs.
No? Why are you acting so crazy today? Brother, you want to stay crazy with me? Look at me. You okay?
Handcuffs.
Yeah, you're in handcuffs because you were fighting pretty good. Try to take that one good? 33 or no? I don't know that. Yeah, bring him at 33. I don't know. It's weird. 607, 633. Where were you sleeping at today? Which room? What's that?
I don't know, man.
Which room are you sleeping in today? Huh? Were you sleeping upstairs? You take over for him?
Yeah.
Were you sleeping upstairs today? Last night? I want to check your room to make sure there's nothing like. You seem to have taken something to me.
I'm gonna go grab a squad.
Some narcotics or something. Did you smoke some reefer? Or marijuana, I guess? I don't know what to call it these days.
No. Just gummies, any prescriptions, anything, buddy? This is medical stuff I just want to know about.
Do me a favor. You know Indian style?
Uh-oh, that's a hate crime.
Okay, let's do this then.
Sir, you're supposed to say crisscross applesauce. We can't say Indian style anymore because microaggressions or something. Believe me, I said it in one of my youngest feral school, and the looks I got, like I had not been made aware that, there was a referendum against calling it, sitting Indian style. I had not been made aware. And they're like, we call it crisscross applesauce. I have never felt more like Red Foreman in my entire life, but I kept it inside. However, my face might have said, whatever.
Huh? I got an ambulance coming to check you out. Okay?
Where's my grandma?
She's across.
She's safe, just not in the house.
Yeah.
No, I'm coming back to you.
Tell me how you're feeling.
I'm feeling dazed. Like, I don't know what the fuck happened.
Okay. What do you last remember?
Laying on the couch or bed.
Okay.
No, actually, what?
What's that?
No, like what?
What happened? You started fighting with the police, man.
Well, I didn't know you guys were here.
That's strange, because when you saw us, you started running. Can you take over here for a minute?
Hey, I don't even know where I was. You guys just kind of like woke me up. And then you guys paged me?
Yeah.
The glasses are under the chair there.
You guys just kind of like came out of nowhere and woke me up. You know, fight with us. I wasn't trying. You guys just kind of like woke me up. Hey, you hurting anywhere?
Do you have any pain?
No. Then yeah, kinda. Where at?
Want to switch?
Your hand?
Go get some fresh air.
Let's get a pepper spray in here.
Your hand?
Yeah, a little bit.
Put those legs up.
Let's put those legs. Go ahead.
But stop.
Let's keep those legs down. Let's keep those legs down.
You can just lay down too.
Put them on the side.
You want to sit up like this and us doing this to you, or do you want to lay down on your side? What do you want?
No. I know it's.
Work it.
Why don't you lay down?
Yep. We're just gonna lay down. I got that.
I think, and again, I'm not a copologist, but it seemed like they had at least a bit more control because of his unsteadiness when they had him up. When he's on the ground, he has a lot more, control. He has a lot more area to move around, wiggle. But look, it's not my job.
If you're gonna fight, then
Here, let's roll him on his side. We have medical coming, right?
Yep.
they're coming 33.
You just do it right now. Why are you doing that?
All right.
Do you want
One take each ankle and pin it
shackles?
down.
Do you want
Why are you doing that? Medical. Why are you doing that? What are you thinking?
All right, man. Now we got you in handcuffs. It's okay. We're getting the ambulance to come check you out, but you can't get all tight on us and rolling around because then we got to hold you down tighter. We don't want that, okay? So we're here to help you. We don't want to hurt you. No one here wants to hurt you. But you got to quit getting so tight on us because then we got to hold you down, okay? We're all good. It's all good. This heart's just going 1,000 miles an hour.
Probably not.
We got to make sure he still keeps breathing good. What did you take, buddy?
Just gotta get you verified. They're coming 33.
Yeah, they're coming 33.
He is not complaining enough.
Does somebody want to look around for any pills, meds,
Yeah.
anything that he took?
There is some somewhere.
His room was upstairs. He was laying on the couch initially, but this morning Grandma said he came down from upstairs.
Legal or illegal, anything he could have taken here on tables, countertops.
Yeah.
Where else does he lives here?
No, he just stopped in at his grandma.
Where does he live?
Where's your house at?
What is your address?
Listen, we're trying to help you out, but where are you living at?
Grandma said he had some gummies, and she found some gummies called Orange Glow earlier.
You okay? You all right?
Okay, dude, this isn't a criminal question. This is me asking for you. What did you take, buddy? I'm worried about you medically. Do you have any prescriptions, any meds?
We tried. That's why we started pushing around. Did you take any medication, bud?
Did you take any meth or anything like that? No? Why are you feeling this way? You don't know? What are you feeling?
Easy, buddy, easy. Chill out.
We're all right. You're fine. You're fine, buddy. We're all right. We just have to wait here, though.
No, this kind of hurts.
I bet.
We want to get you sitting up, but you get.
Do you want to sit back on your butt as long as you don't fight him? Yep, I don't want that either. Do you want to sit on your butt?
I'll help you sit up. We just don't want to fight with you.
You can't get all the way up. We got to sit down on 3. 1, 2, 3. Yeah, we got to sit.
Now take this one in. Like this.
Oh, we have to stay like this for now, okay? Hey, can you sit up a little bit more? Because it's actually easier to breathe when you're asleep.
Put your head up.
She said he had little gummies somewhere. I don't know where they are now.
Here, we're going to slide back on 3. 1, 2, 3.
Now you can lean back against the counter here.
Lay your head back.
Okay. Hey. Chill out, buddy.
So
Chill.
the paramedics going to look at you, but it's really hard to look at you when you keep doing what you're doing. So I need you just to kind of sit still.
His left ankle.
Chill out, chill out, chill out. We're gonna put you back on your back. I'm gonna put you back on your back.
There's a real option here.
All right? I'm gonna put you on your back if you keep on.
I would wonder if the parole officer would know if he had any known mental health issues that he was also taking medication with. Unfortunately, people that do have chemical imbalances, you're not supposed to take anything additional. Not street legal pharmaceuticals do tend to counteract with a lot of mental health, drugs. So there might be history there, and there can be some very serious, interactions depending on what he took. So maybe the, probation officer will know that.
Quirlin.
And you did not like being on your back because it hurt your hands.
Because
I'm trying to work with you.
I don't
I'm trying
think
to cooperate
this is a
with
gummy.
you. Okay?
I understand.
Okay, then stop moving around. Stop moving around. Stop moving. Listen, I need to know if you took anything because your eyes are big as the moon. And you're acting kind of funny. I've never known you to act this way before.
Yeah, I'm fine.
I think you took something.
I'm not even trying to fight.
I don't know why you're fine, but I need to tell the paramedics what you took. It's all right. It's all right.
It's okay. Easy. We're not here to fight. We're here to make sure you're okay. So we're not enemies. Hey, now with your hands.
You're good. You're good. You're in handcuffs, but you're okay. So we just need to make sure that you're okay. You take a couple deep breaths, chill out a bit.
Okay, but Puddletown, you did willingly take the intoxicant. Now, I think that there could be a case made if someone drugged you, that you're not responsible for it. But if he willingly put the, not street legal pharmaceuticals into his mouth hole or injected it between his toes, not being a, expertologist, I think he kind of chose to be out of his mind.
Easy.
What'd you get? Good?
Cut it off.
What's that?
Put me under and cut it off.
Cut it what off?
My neck.
No, we're not cutting off.
Look at it.
Well, this took an unexpected turn. That escalated quickly. This is another reason to call 911.
No, we didn't cut your neck off. Nobody cut your neck off?
No.
Just put me under and cut it off.
No one wants to cut anything. He's talking about hands.
Oh.
You cut it off.
Shut up, man.
Buddy, you're fine.
Shut off.
You might have a little probe in it. They're going to take it out.
Help me cut it off.
No, we're not going to cut off.
Help me cut it off.
Oh no, the probe landed in his twig and berries, his frankenbeans. Okay, to be fair, if I were out of my mind tripping balls and I had a frankenbeans, which would be, I guess if I had a taser probe and I was not in my, bits and pieces and I was not in control of my faculties, it would freak me out too. Not gonna lie.
Get off, but we'll wait for the ambulance. That's why we're trying to get all this information. What do you want me to cut off? Why do you want me to cut off your
Just do it. Just put me under and cut me off.
Why?
Just please do it.
Why?
Does it hurt?
Yeah.
Okay.
Well, yeah, you got a probe in it, but do you want us to work it out or medical people?
Yeah, no, help me medically.
Yeah, the medical people are coming.
Help me medically.
We are.
Help me medically.
But they're gonna not be able to.
Help me medically. Help me medically. Help me medically. Okay, help me.
Oh no,
Hurry
don't
up.
lay him on his stomach.
Help me, hurry up.
Okay, I'm kind of on this guy's side now. Don't lay him on his stomach if he's got a probe in his, bait and tackle. I would fight you too if I had a probing, you know, my nether bits, and you were making.
Hurry up, help me. Hurry up.
You want me?
Help me. Hurry up.
Put you on your back, ready? Dude, don't do that. Don't do that. You're gonna make things worse. Don't do that.
I'm excited to hear you.
Calm down, buddy.
The paramedics are here.
We're in a strap. We're strapped to the cart, so we'll be good.
Yeah, he's trying to rip the probe and is growing out himself.
Easy. Just the only thing I need you to do is just lay nice and still.
You're fine. Just lay down.
Just lay nice and still.
Your handcuffs are over here.
Sweetie, this is like one of these things you shouldn't want to do on your own. Let the experts do it. It's like cutting your bangs at home. You will always regret it.
They're on your back. Yep. You gotta stop fighting though. The guys are in Pig's Moon. Yeah. His grandma said there's some confusion going on, tried coming down the stairs. Stay there where that popsicle is. When's the last time you had any like drugs? When's the last time you think?
I don't know.
You don't know when?
Probably
Yesterday?
the
Today?
truth.
No, not today or yesterday.
What do you use when you use?
What's that?
I don't know.
You don't even know? Do you use meth?
Look at it. God damn it. Do you smoke it? Do you eat it? No.
How about like LSD? No?
You inject it?
You're fine.
I appreciate that. You're doing a good job. That's all we need you to do is just lay down. I know it's a lot of questions, but you're doing good. You're doing good.
Are you gonna stand up and walk over the stretcher? I just don't want to go through what we already went through.
Yeah.
You gonna do that?
Yeah.
We're friends now. Friends don't fight.
Yeah.
Friends don't fight.
Friends don't fight, brother. So.
Fish are friends. We don't eat fish.
All right.
Yeah.
Police department.
You must have been fighting.
Yeah.
Really?
Well, we all got pepper spray too, so.
You got pepper sprayed? Oh no.
Oh, we all did.
We all did.
From him?
No.
I pepper sprayed them. Your kitchen's gonna burn for a while.
We're gonna get off your legs now, okay?
Next to him.
So I'm gonna stick
We
my
need
hand
you to
underneath your
stand
arm.
up.
We're gonna slide you this way first.
Okay.
Okay?
1, 2, 3. There you go, brother. Good job.
What are you doing?
Your pants are already down. I'm trying to give them.
You're doing great.
Why don't you have a lay down?
Sitting better.
All right. You want to put this up? Up of them on first.
Just keep holding. You keep being cool, we'll take you out of those handcuffs, give you something more comfortable, okay?
Water?
Do you have a bottle of water?
So he wouldn't calm down for
Oh,
nobody,
he's
huh?
still not calm. He's fighting with Tri-State right now. Thank you. Normally when asked, I can't breathe.
Yeah. They get so strong, I'm sure it had to be drugs.
You're fine? I'm okay.
Keep being cool, okay, buddy?
But if I think of it now, way back last summer already, he was getting paranoid.
Yeah, typically that's drug related. Not saying it couldn't be other.
Yeah,
mental
yes, I
stuff,
know,
but-
I know.
You mind if I grab a picture of your arm and stuff?
We'll get that out.
We'll get you out of those in a minute.
I mean,
We're gonna get you in the soft ones as soon as we're done with your legs.
loosen my arms, please.
We're gonna
We'll
put
get
you in something more comfortable, okay?
Yeah. I think my knee too, but I think that's good skin.
All right, lift your arms up, bud.
Okay, you right first?
Yeah. I know.
Yep, we're taking them out. Just keep not fighting, okay?
It's up to
Yep.
I know. We're moving your hand.
No, he was trying to rip it out of, the taser happened to land in his twig and berries, and he was trying to pull it out himself or have the officers cut off his, wean in order to take the probe out. Because he's probably under the influence of not street legal pharmaceuticals, they did not follow his instructions and are waiting for him to go to the hospital to remove the taser probe.
He was pepper sprayed. He was tased a few times.
Oh my God.
So it did not go easy. I don't think I broke anything in your house though. Your kitchen's I would air it out. Your kitchen's gonna smell like pepper spray for a little bit. You'll notice it when you go in there.
Okay.
There you go. Okay, so just keep relaxing.
Ready?
Ow. What are you got my arm for? You
Because we gotta keep you safe in here.
So I'm gonna take this off.
Yeah.
Keep being cool.
Yeah, take it off.
Actually, somebody from that
Take
side.
it off.
Just keep being cool, bud.
Take my arm out of your house.
That's what we're doing.
Otherwise, I know where to find you. I'll if I hear more information, I'll come back.
Yeah,
I'll
I
probably
don't
come back and
know.
speak to you one more time once I can breathe and everything calms down. But I'm gonna go down to the hospital with him. We got to get him clearance and stuff before he goes to jail. So, do you have any questions for us?
No, I don't think so.
Okay.
This ain't my first rodeo.
It wasn't bad on my face or anything, but man, it got in my throat.
You know.
thought it was I think it was the best move to take a little fight out of him, but I was so close I didn't want to. I'd rather use pepper spray than taser right there.
My eye.
I'm gonna raise up.
My eyes. My eyes.
Thanks for coming, boys. Thanks for coming on.
Yeah. Subsequently, police collected the grandson's Delta 8 THC gummies and the broken popsicle stick, which still had hair attached to it. Ultimately, the 20-year-old grandson was charged with felony physical abuse of an elder person, intentionally caused bodily harm, misdemeanor counts of resisting obstructing an officer, and disorderly conduct. He was released a few days later on a $1,000 signature bond, only to be arrested again just over a week later for felony bail jumping and operating while revoked. Head over to Code
Did
Blue
they keep him in jail after that? No, probably not. They were like, and we let him go on a signature bond again. Well, let's see. Ooh, when every wrong thing you could do when arrested.
In October 2023, while performing his routine duties, an officer came across a suspicious vehicle in a church parking lot in Holman, Wisconsin. The officer recognized a 42-year-old man as Ricardo.
What in the name of cousin marriage is this? Wow. There's a lot going on in this photo. And some of it negates both evolution and intelligent design.
Who was outside his vehicle working on something. Aware of Ricardo's numerous past encounters with law enforcement and observing his unusual behavior at such a late hour, the officer decided to see what he was up to. When the officer pulled up in his unmarked truck and identified himself as police, Ricardo wasn't buying it and quickly jumped into his vehicle while yelling, "I'm going to kill you."
Yeah, I am. You don't believe me? I don't believe you at all. Oh, I can let you go. 702 at 28.
When all else
Had
fails,
awkward
threaten
contact
the
with
police.
him. I'm gonna follow him here for a little bit. He had yelled something about trying to kill me or wanting to kill me. Start me as suspicious for right now.
It was also discovered Ricardo was out on 3 misdemeanor bonds. And by the way, if you're interested in true chilling stories, check out our
702. I'm not even trying to stop him. We're going 60 now. He's increasing speeds. HD sunset.
333. I'm northbound on 35. I'll start angling that way. 326 and 35 and 02.
702 dropping erratic here. He's still southbound Holman Drive. Just ran a yellow light. HD and full court. Still waiting for a second unit before I initiate a stop.
He gradually increased his speed, soon reaching 70 miles per hour in a posted 35 mile per hour zone.
705, I'm at the South Interchange now.
02 to 05, just make sure you kill your light. Sometimes he doesn't see it. We are 70 southbound 35 right now.
Due to his threat and erratic driving behavior, a high-risk stop was initiated and several officers responded.
702, I'm going to initiate a stop here, 35 and 02.
Dropped down the main for the Holman traffic stop. Other cars loaded short too.
702, I think we're going to stop here, 35 and 02. We're stopped 35 and OT. When you guys get on a PA, we're going to order them out. Is there multiples? No, there's one. So you getting on PA? I'll find out. Get somebody on it just to order them out. You guys on PA or you want me?
Driver, you are under arrest. Place your hands out of the window.
Didn't need that, but.
Put your hands out the window. Show your hands.
Order them back.
Try to get him right here. Yeah. Stand up.
Is he on the ground?
Yeah, he's moved on the ground.
When you know a felony stop well enough that you know the steps that you're going to eventually take and you just get on the ground.
Face away from me.
Despite commands to exit the vehicle, Ricardo did not comply and would randomly reach into the vehicle.
Don't reach.
Hey!
Do not reach. Stop reaching.
Yep. No, I got him.
Back up.
Watch his right hand. Ricardo, walk backwards.
Stop reaching. Put your hands up.
Can you see another occupant?
And lift it up.
It looked like he was talking.
Back of your shirt by your collar. Grab the back of your shirt by your collar. Lift it up.
He eventually began stripping off all his clothes, and at one point dropped his box.
Hey, it's getting hot in here. He was just listening to Nelly. It's not his fault. It was a banger.
Exposing his bare ass.
Hey, he knows you're gonna check his prison wallet.
Put your hands on top of your head. Stop.
All right, well, this is getting weird. Hey, Ricardo!
Stop.
Ricardo!
Hands on top of your head.
Take some steps to your right.
Walk to your right.
The other right. Towards the grass.
To your right. Keep going.
Ricardo, leave your jacket there.
Keep going to your right.
Leave it there. Keep walking to your right. Keep going. Keep going. Keep going.
Keep going.
All right, stop right there. Walk backwards to the sound of my voice. I got hands, yeah. Leave the coat. Leave it. Go to the grass. Go to the grass.
Hamilton Road is the
That's it. Everyone I pull over has to pull their pants down and walk like this just for my safety and amusement.
Brian Road.
Get on the ground. Get on the ground. Coming from this side. Okay.
That's not cool.
35 Ricardo.
I was speeding. That's what I was doing. That guy was not a cop, dude.
No, I am that guy.
You're not that guy.
I am that guy, dude.
No, you are not.
Made a comment you're gonna kill me or something too. That was kind of weird.
You are not that guy.
I am that guy.
No, you were not.
Let's just check him quick and we'll try to get him stood up. 702, you can open the channel. We'll get 1 to 10. He stashed the keys on, that's what he was doing. So he locked it up. You got anything on you, bud?
No.
No, nothing at all? Okay, let's roll him my way. Okay. All right, bring your knees up to your chest.
Careful with my cell phone, please.
Yep, knees up to your chest. Come on.
I will.
I'm gonna help you get up. No, I want you to roll over this way, and I want you to bring your knees up to your chest.
Okay.
There we go.
Okay.
You stand up. 1, 2, 3.
I can't move. My legs are hurt. Sure.
I'm gonna pull the pants up.
All right. You've been here before, bro. Come on now.
Yeah. No. Where'd you put your keys?
Keys are in my pocket.
Put your hands on your pants.
Yeah, you don't want to.
I'm gonna look to my squad here. We'll search him, but he's got a bunch of crap in his pockets.
I would just make use of you guys so you don't get freaked out, you know what I mean?
Yeah, I appreciate that.
No problem.
I'm gonna walk up the front of my car here.
That was a strip. That was like a straight strip right there.
It literally was.
So if you can bag that up, is that cool?
You just never know some days. He's usually got a lot of stuff in his pockets. Yeah. Well, car is awfully full. What were you doing over at the church?
I was getting some dinner. Some guy came out of the woods talking about like, I'm a policeman.
I didn't come out of the woods. I drove up there to see what you were doing.
How can you put your lights on then?
Why would I put my lights on? I was just seeing what you were doing. I wasn't pulling you over.
You wasn't you?
Yeah, you kind of took off like a maniac.
Of course I did. You think I want to die out in the woods?
You weren't in the woods. You were in a parking lot.
I don't care. Stay out there. Holman's home and it's kind of out there. But I don't want to do this. All I did was reckless driving.
Appreciate you admitting that.
Speeding. The cross have been like $500 somewhere. Bunch of points taken off. I'll go to dummy class.
You act like you've done it before.
Been here, done that. Not drunk and drunk, but not that.
Okay.
Now I got to drive on eggshells. I haven't got no speeding tickets in there. Paid my parking ticket already, so that's good to go. I gotta go to court on 26, by the way.
For what?
I could go for one of your stupid idiots for having a crush on my sister. And, well, you're Coleman, I guess, civilian.
You have to go to court because
go on
cop has a crush on your sister?
No, some real little nerd. Bag of glasses.
You have to go to court because
Gotta go to court on 26. Over there for someone over here in Holman. I gotta go to court on 26 for lacrosse, my stupid brother.
Okay. Do you have an ID on you at all here, Ricardo?
Oh, it's in my other one.
You got 2 wallets. I've never seen a man with 2 wallets.
Got robbed in Sparta.
Got robbed, so you got 2 wallets?
Yes.
Doesn't that double the chances of you getting robbed?
There's a chance that I might get the right one.
Oh, so it's like one's a decoy.
Yes.
But they're both attached to your hip.
That's it.
Yeah, the week after that when he took the shopping rack and started beating everybody.
This man is a genius. I mean, if you have both of your wallets attached, you never know if you're going to get the right wallet.
Walmart?
Yeah, that surprised me because he's been so docile. I've talked to him so many times. It's his temper. Because somebody was talking to him in festival parking lot, and he threw a bottle, and he had it cleaned up and apologized. And by the time I got there, I was just like, "You got to work on that, bud." That was one of my first times dealing with him.
Oh, we've got movement. Okay.
Am I bully?
Oh, for the 1 second. I've got to. Where am I? Okay. 1 second. Let me get it. Because they just came back. And. All right. Sorry, I was finishing a sentence. Not really. All right. It looks like there is a question. All right.
But it needs to be cleaned up. In particular, on a quick review of it, photo 52 should say something other than butcher paper.
Yes. And 189?
Also the same term?
No.
What were you calling it? What kind of paper? Bench?
Bench paper.
Bench paper.
That term is used throughout. So what is it that is, that term is used in other numbers? So is it something about that particular photo that is problematic with that description?
Oh, I just was,
I mean,
I just don't like it, but
I know you don't like it, but I'm trying to distinguish between, I think there was one witness who used that term butcher paper as opposed to bench paper. And I don't think it was the witness that was associated with that. This is just the old-fashioned terminology that people often use to describe that paper. I think I used it at the side of the bench one time, not in front of the jury, but just with you. But I think that is there's a more neutral characterization that would be appropriate and more in line with what the witnesses actually testified to. But as to the other language in 189, it seems to me that that's what the witness testified to, right?
that's right. Yes, Your Honor.
Anybody, let's all take a moment to look through the list right now and see if there's anything. I'm going to do that right now. The answer to their question is 97, by the way.
Yes.
Let me just take the time to look through these, and you do the same.
That's, other than that, that's the only.
Who's 189?
Blood clots and.
Oh, that is.
I am not sure what the question is. They haven't clearly articulated what the question is about. I don't know if they're equivocating over the terminology used, but I am going to run and check on dinner in the oven. I will be right back. So I am not sure what this is about. They might be wanting to see exhibits. And I am not sure. So bench paper
Aside from that
is,
one suggestion to change.
Okay.
we are on verdict watch. I think that some of the jury is asking a question. Now, it seems to have to do with some of the exhibits or some of the evidence. And it seems right now that the defense is really upset about calling the paper that they would put out in the sort of trace and DNA lab, calling it butcher paper instead of bench paper. That's all we've gotten thus far. They haven't even told us what the question is.
All right, so I'm going to write back to the jurors and I will give them the name of, or the number of the photo, which is, I'll answer it as exhibit number 97. And here's an exhibit list to assist you.
Thank you, Your Honor.
Now, hopefully she will clarify how long she's going to let the jury deliberate. She has been ending at 4 o'clock daily, but I don't know what her policy is and what the courthouse policy is as far as deliberating into the hour. And Jedi Jess said it sounds like they want an index or how to locate a certain exhibit, so they're giving them an index. That's a good idea. And no, I think it's because they used to use it at butcher counters to wrap up meat and stuff like that.
Here you go, Madam Clerk.
So we might
If
be
you want to look
looking
at it,
at
you're welcome to. It's pretty straightforward.
we might be looking at a
Thank you.
verdict Monday if they're not able to go much past 4. Now, there haven't been any indications. Yes, and I think she did make it bench paper, but I think the term bench and butch paper or butcher paper were used interchangeably. I'm not quite sure, but the judge did make a reference that they were going to change it to bench paper. Okay, so that's where we are right now. Like I said, you guys know about as much as I do, as much as the law and crime chat as they devolve into relitigating the Karen Reed case, which is always fun. Said no one. Yes, I am watching the chat over on Law and Crime, and it has devolved into Karen Reed relitigation. So that's fun.
Hiding in the goddamn truck, and I'm like, that. I ran, literally ran like.
Oh, why'd you run?
Because I don't want to get my.
What do you think we're gonna move?
Not you.
Well, when we up here, I don't think
This guy was somebody else. I don't know what the hell happened. I just kept running like a motherfucker. I didn't even look.
Yeah, you were driving like a maniac.
Of course I was. I was driving. I mean, I was waiting. I swear, I didn't run a red light.
You were close. I would say you ran a yellow light.
Okay, that, I guess.
Yellow usually means slow down.
Well, I was scared he had a gun or something. What am I supposed to do? I don't want to die tonight.
Are you staying clean?
Yeah, I'm clean. I'm not even drinking anymore.
Yeah, I just had him. Pocket, I think I'll grab him here. I mean, identify myself as a police officer, and he said something like, "No, you're not. I'm gonna kill you," something to that effect. Then he got in his truck right like he was just gonna take off. I probably won't go that route, but it was very, very weird. He thought it came out of the woods and it was gonna molest him or something. So he's hanging out working on something outside of his truck.
Had some dinner, and I was like, go in there, jumped in, hopped in, drove like a motherfucker.
What were you gonna have for dinner?
I was gonna have some coleslaw.
Coleslaw in the church parking lot. All right, man. On a Friday night. I'll switch with you again in a minute.
What else are you guys supposed to do? Let me run?
I was just happy you pulled over. I didn't think you were going to.
Lights.
What's that?
So happy to see the flashing lights.
Yeah. Well, I didn't seem very happy about that, but
I wasn't going to be taken by no I'm a fake cop, bullshit.
Yeah, not fake cops. All right, let's go around to that side here. I'm gonna put you in the back of the squad. You're gonna go to jail tonight, dude.
Oh, that's fine.
How many times has this man interacted with not real cops? I mean, let's be honest. I think all of his police interactions are probably very real.
Yeah, well, I don't know.
Drunken and belligerent, I guess.
I don't think you're drunk, but you're kind of acting like a maniac.
It's easier if you step up, boss.
Yeah. Well, I don't know. Maybe just say, this is a situation where you save me from some psychotic guy with a gun.
You do understand that I was the guy that came up to you and talked to you, right? What did you say? You said you were going to...
No, he still doesn't understand that, sir. The understanding and him have never been in the same zip code.
Me or something.
Who was going to say that? You if you might have ran.
Yeah, why'd you say you were going to kill me?
Well, what you? That was not you.
That was me. That was literally
that was
this.
Not
that
you.
was this vehicle.
No
you said, who are you? And I said, I'm the police. And then you like scattered into your truck and took off like a maniac.
That was not you.
Okay. All right. Then you pulled in front of a car. Did you see that?
That was not you. I'm not falling down for this anymore. Oh. Go ahead, throw me in jail.
Well, it was. You
I'm a Chicano! Listen to me, I'm a Chicano!
What?
Come on, man. Let's get this over. Get down,
all right. Sounds good.
Talking shit is not illegal.
I'm not. No, you're right. I don't know what that even was. I don't know what he was yelling. Chicago something?
Completely sober. He is high on life.
Weird. It was really weird. I didn't know it was him right away, of course, and then I kind of was like trying to run the plate, and I was like, oh, I bet I know who this is. It kind of makes sense. So we were hauling. Yeah. It was like he was doing 60 something on Holman Drive. We got to 35. He was doing like 70, and then he was kind of like cutting in and out of lanes, go around cars. Well, we're gonna go to jail for probably reckless driving. He admitted he was reckless driving. He literally flat out told me he was. So we'll do that. We'll do some traffic tickets. I'm gonna probably throw in a DC. We got traffic going by, and he's taking his clothes off. So. Yeah.
At least it's walking distance. If I go to the jail and cross.
Walking distance to where?
Where are we going? Class? Are we going to Lacrosse or are we going to Holman?
We're going to Lacrosse.
I had to chase you 60 miles an hour.
Yeah, you were driving pretty fast there, dude.
I know I was going fast. I was trying to get back to Lacrosse, dude. Well, at least I got a free ride.
Well, they're towing your truck, so.
Been there, done that. Far enough.
Yeah, you've been around the block lately, man. You've had a lot of police contacts.
I talked to my attorney. I got the right to remain silent. Anything I say we're using something.
He is the best third-party intervener, pro se person, and jailhouse lawyer you could find. Something.
That was a fake cop all the fucking way.
I was that cop.
I didn't see your face at all when you were talking to that truck. That was you. So I don't even feel that bit sorry. What can you be to get my truck?
That was an interesting song.
I'm just saying, that's how I feel about this bullshit.
How many times have you been to jail recently?
I don't know. Why don't you go ask your fucking lieutenant, you sucker?
I am the lieutenant.
Oh,
yeah, you're the lieutenant. You kiss me.
That escalated quickly.
Take your time. No rush. All right. Take a left. Sit on the concrete there. Appreciate it. I'm going to have a bunch of tickets in here for you, Ricardo, okay? Just so you're aware. Court date's going to be next Thursday. So, first one's for the reckless driving, the yellow light violation. You said it was red, but I think it was yellow, so I'll give you a break on it. Okay, I don't know what that means, but failed to yield right away. You pulled in front of that car.
Good for you.
And then the unreasonable and imprudent speed, okay?
Yeah, whatever.
You were doing like 60 miles an hour.
I had my name to the judge.
Yep, well, everybody does. So you say you your pants? You just can't be driving like that, dude.
Yeah.
Well, you should care. What if you end up hurting somebody?
That's fine. Let's go. In jail.
I don't think it's fine to hurt somebody. I don't want you to hurt anybody.
While in the booking area of the jail, he suddenly became agitated and began demanding to be tased.
I don't think I understood any of that.
I don't know what we make from this military guy. You can come mask and tase me. Come on, go tase me. Go ahead.
No, have a seat.
Tase me right now, you sucker.
Have a seat. Now you're going to piss these guys off. You don't want to do that.
Perfect. What's going on, man? Not much. You get on my nerves.
We're having a conversation.
Start yelling. All right? Come on, man. Yeah.
He had a bunch of crap in his pockets. He got probably most of it out, but I probably didn't get all of it.
You gonna be alright with us though? I'm fine, yeah. I just want to get in jail so I get over with it. Wait till tomorrow.
He's been like super chill, and then he's been like.
I don't care. I got sick of dealing with I don't deal with your ass.
Thank you, sir.
What's going on?
Oh, it's just been a night. This guy's crazy. I know you guys have dealt with him before, but.
Oh yeah.
He's out there.
As a result, Ricardo was charged with misdemeanor counts of disorderly conduct and bail jumping. He also received over $900 in traffic citations and was released on a $1,000 signature bond, only to be arrested 3 more times in 2023. Nearly a year later, the court considered a total of 6 separate active misdemeanor cases involving Ricardo, in which he was ultimately found guilty. However, the charges related to this incident were dismissed but read in, and all his citations were dropped at the prosecutor's request. In the end, he was sentenced to 78 days in the La Crosse County Jail.
Yeah, that'll...
And again, don't forget to visit our storytelling.
That'll work. I mean, why not? Oh, for goodness sakes. I forget to jump to this screen and then go over here.
February 10th, 2023. Police were dispatched to a residence for a possible physical disturbance in Walshe, Wisconsin. 18-year-old Anna Kostecki became assaultive after discovering her...
Now, if you are at all aware with Code Blue Cam, then Anna is a recurring character in the La Crosse, multiverse.
Sister threw out $100 worth of alleged cocaine enclosed in a prescription bottle. Her sister was...
Don't you hate when someone throws out your illegal drugs that you've stashed in a prescription bottle?
Was aware of her substance abuse and didn't want her to have access to it. After a physical altercation with members of the household, Anna left the residence in a black vehicle. While en route to the residence, an officer observed the black vehicle pass him, so he turned around and initiated a traffic stop.
That's a little black car, wasn't it?
Yep, I would say.
13212, where you at? Over
Units responding to this 1016. So you have the location. They stated that they just turned westbound onto West Bridge towards the highway.
202-212. Are you going with 213 or going to the house?
I'll be with 213, just given the history with Anna.
10-4. I'm going to slow it down, then it goes to the house.
213, we're going to be southbound on on 51 from West Bridge. Going to try and get it stopped here. We're still rolling south on 51 between Bridge and 52 Parkway. Looks like they're going to stop. We're still rolling southbound on the exit ramp to 52 Parkway. 213 still rolling. They're not trying to evade. Stop westbound on 52 Parkway from 51. Negative, they are not actively trying to evade. They're just going about 10 miles an hour, failing to yield.
What in the O.J. Simpson
Turn
Bronco
the car off and
chase?
step out. Driver only. Driver only. Walk back towards me, man.
The driver was identified as 33-year-old Vaughn Lohr.
Keep coming back to my car. Turn around. Turn around. What's going on, man?
Nothing much. I just got she told me to come pick her up, so I just came and pick her up.
Who is that?
That's Anna.
Anna? Okay. Why weren't you stopping then?
Because we were on the highway.
This gentleman just realized that he got pulled into some drama, and he's like, oh, dang, I don't even know this chick's name, really.
was in
You weren't
a
on
red-
the highway that entire road.
It was in a registered car, so I just recently bought the car, so I just took it for a test
Typically,
drive.
red and blue lights mean stop, right?
Right.
Right. And
I
the
just
siren?
I just want to stop right in the middle of traffic, you know.
You weren't in the middle of traffic.
Well,
You
up
were
on
on
the
the
highway.
side, and then you got off the road.
Yeah. I just want to get
You're
out.
gonna talk to Anna.
Yep, I got it.
What's your name, man?
Vaughn.
Hi, Anna. Officer with Walshe Police. Hey, so were you at your mom's place just earlier? No? So why am I getting a report that you bit your mom and stuff? What's going on?
Wait, did he just say bit? This is going to be a fun one.
Okay, so you didn't bite her or fight with her or anything like that? No? Okay. You've been doing good? You've had a lot of bad runs with the police. So your mom's trying to get you put in jail for what?
Because I haven't paid her rent.
Paid her rent? Okay. So you've been living with mom?
Yeah.
For how old are you, Anna, again?
I'm 18.
You're 18? Okay. Alrighty. So I guess so I know you said, I guess, how has the relationship with you and your mom been the last couple days?
It's horrible.
Horrible? You've been drinking a lot?
No, not really.
Not really?
Just a little bit, but
Just a little bit tonight?
yes.
Okay. Were you drinking
Very
at the house?
Yes.
Yeah. Okay. You and your mom argue tonight or something? Okay. What are you guys arguing about? Having drinks? Okay. I mean, you can kind of see where she's getting upset with that. All right. So nothing physical happened at all. You guys didn't fight each other, throw each other. Okay. Did you guys throw anything at each other at all? No. Okay. So who's this guy?
He's my friend.
He's your friend? Okay. I got you.
How do you know Anna?
From friends.
Friends?
Yeah.
Okay. You know her like real well, or?
Sort of. Well, it's kind of.
Okay. So you know Anna through friends. Did she tell you anything that happened there?
No.
Did you know anything that was going on over there?
No.
Alrighty, Anna. So I just want to let you know what's going on moving forward, okay? So we have another officer at your mom's place just talking with her. Says right now you're not free to go, okay? But keep being cool with me, and I'll be cool with you, okay? We're understanding? Yeah. Alright.
Do we think that Anna's going to take option 1, be cool with me, I'll be cool with you? Or are we going to turn this into an unholy, uncontrollable dumpster fire? Well, it's Wisconsin, so I think we know where we're going with this.
Cool. Just hang tight in the car right now, alright? Don't go anywhere. Anna, do you have any open cases right now? No, they're all closed out? Okay. So are you on probation or something then?
Yeah, I'm on probation.
Okay. I'm assuming it's for all the stuff that happened in the last, a few months ago then?
Because of drinking.
Drinking? Okay. Obviously, I think that's where the issue is, and I think you should probably stop then, huh?
It's not because of
It's not because of the drinking? Oh, okay. So what's
my
the...
sister and my mom is the issue.
Okay.
Eventually, dispatch advised that Vong had 2 active warrants.
Simple. Okay. So I just want to clarify. You know nothing about what happened there. You only know Anna through friends.
Yeah.
Okay. Is there anything in the car I should know about?
No, I
Nothing
just,
like that?
I just recently bought it, so I don't know.
Okay.
Yeah.
All right. Go ahead and just turn around for me, okay? Hands behind your back. You have warrants out for your arrest. Did you know that?
No.
Okay. When's the last time you saw your PO?
What's happening with him?
What was that?
What's happening with him?
He's got warrants. So we gotta address that.
What were you on probation for?
Drugs.
What's that?
Drugs.
So Anna, you and your mom were just arguing tonight about just the drinking then?
Yeah.
Okay. You kind of got upset, so that's why you left? Okay. Alright, that makes sense. Are you willing to give me a PBT?
Yeah.
Yeah? Okay. Let me just grab that real quick, okay?
Close our windows.
Yep. We'll get everything taken care of, okay?
Anna agreed to a preliminary breath test, which resulted in .169.
Alright, Anna. You've done this before, right?
Yeah.
Okay. So it's all zeros. Alright, I'm just gonna close this, okay? It's a little cold out here. 169. Hey Anna, would you be willing to sit in my car? We gotta secure your friend's car since he's going to jail. You don't want to? Okay.
I didn't do anything wrong, so.
Well, I'm not saying you are. It's just we just have to secure the car since it's his.
Yeah, so here's the right. He's going to jail because he has a warrant out for his arrest. Okay, so
That's
I have to. You're right. He doesn't have any charges. It's not from us. We didn't decide that.
It's just warrants.
What's up? It's retarded. Okay, well, you don't have to agree with it. Unfortunately, though.
I like that she's giving her legal thoughts. She's like, I opine on the stupidity of this particular thing.
What's gonna happen with me?
Well, we're still trying to figure that out. I just told you that we have an officer talking to your mom.
What's gonna happen with me?
We don't know yet. We don't know yet.
Then I don't want to go if I don't.
You don't have to sit in the back of the car, but you have to get out of this car so I can secure it and give his keys to him, okay?
Okay.
Thank you. I appreciate it.
This keys in. Huh.
Want to detain her or anywhere? Can I go sit in the car? It's kind of cool.
Yes, ma'am. Are you cool if I pat you down real quick for just weapons?
No, I'm good.
Okay, then you can't get in my car, unfortunately. All right.
He's taking it on a test drive. It's new.
Had an argument about.
When can I go back in the car?
What's that?
When can I go back in the car?
We'll have to ask him, okay? Do you have anything in there?
No, there's nothing.
No, like if there's something you needed to get out of there because we have taken the keys for him.
No.
Okay. Do you need to stay warm? Is that what it is?
Yes.
Okay. Well, the option.
It's freezing out here.
She won't let me search her, so pat her down for weapons.
We can let you sit in the car, but this is his car and we got other stuff going on with him now, so if you let us search you, we'll put you in our squad car. But
I'm good, thank you.
Alright. Is it warming up back there, Bong?
Yeah, I was wondering why I'm going to jail. I mean,
I told you you got two. I told you got 2 warrants. That's why you're going to jail.
Did you guys talk to my attorney? I have an attorney for all the case. Why I'm...
No, you have 2 warrants for your arrest, so you're going to jail. This has nothing to do with talking to your attorney.
Yeah, that's how warrants work. But you can talk to your attorney once you get to jail. I mean, probably not at like 11 o'clock at night, but you know.
Because I have nothing to do.
Bong, listen, I have no say in warrants, nothing like that, other than I know that you have one and I have to take you to jail.
Right, because I was driving Anna around, right?
No, you guys left the scene that Anna was involved in, so that's why we stopped the vehicle.
Because she was the one who called me to go get her.
Okay.
And now
well, I guess you're in the wrong place, wrong time, man. I don't know what else to tell you.
But she, the little white girl that, you know, gets to get away because she's drunk. Because why?
No, you had warrants. They didn't say, oh my gosh, it's an Asian guy running through Wisconsin. Get him. Okay, hilarious side tangent. For a lot of my young adult life, like before age 10, I thought the song Secret Agent Man was Secret Asian Man. And so finally at 10 years old, it never made sense to me. So I finally turned around and asked my mom one time how the gentleman didn't know he was Asian and if he had a mirror or if anyone would have told him. And she said it was Agent, and it made much more sense as a song, but I always, he reminded me of that. So thank you for making me remember a funny thing that I did as a child.
Why did you guys even come after Anna for? Why did you guys even pull me over for? Why did you guys even come for Anna when Anna's the problem, not me?
Well, you're driving her, and she left in your vehicle that we were given the description of.
Right.
And I located you on my way. And I located you on my way to the scene.
Yep.
So that gives me reasonable suspicion to pull you over.
Right. So.
And then
Anna,
you also refused to stop.
And then the issue, I didn't refuse to stop.
You did.
But then the issue is, the beginning issue is what? With her, right?
Correct. You're the middleman. You were caught in the wrong place, wrong time.
So I get locked up. I get to go to jail because of her. And
You're going to jail because of your,
she's underage
of your warrants.
She's sitting right there.
You have no idea what else is going on. I'm dealing with you. There are other officers involved in this. So we're going to stop debating about this. Am I clear?
I'm just saying
Thank you.
About how you guys interact with us people.
I don't know what that means.
Minority people. You guys let her walk.
All right.
I get it freaking.
All right. We're done. We're done with this conversation.
Exactly,
we're not going to go there.
You guys know exactly what you guys are doing.
No, I don't. I'm doing my job.
You guys know.
This gentleman will be represented by Daryl Brooks and B. Ivory Lamar.
Exactly what you guys are doing.
According to their in-house records database, Anna is flagged as 10-0 for officer safety. She then made a phone call to her mother and started begging for her to come pick her up.
No, negative. Since we're dealing with so much, I mean, with Anna's 10-0 and then the Hunter's got a guy at 95, so like, he's just sticking around so that...
Oh, this is going to end badly.
No, she's been cool with me, but she's getting kind of passively aggressive now, so...
Pulled me over, but look at her. She's fucking drunk as fuck, and you guys just...
You have no idea what's going on, bud.
Ooh, he's adding bass.
You have no idea what's going on.
She told me she was drunk to go help her out. So I came over to help her out, and this is the help that she gives me, right? She gets to walk. I don't know what else to tell you other than to have better friends, man. Look at her. I need better officers to help me out. I can't do anything. You know, the drunk people make them get in the back of the squad car, but instead you guys arrest them and record them and humiliate them on a YouTube channel, and you guys think that it's fucking funny? I don't have a YouTube channel.
I mean, I do. In fact, hi, I'm one of the people that humiliates idiots on the YouTubes. And it's a teaching opportunity, but you have warrants, and that means that you didn't show up for something the court was asking you to do or show up for, which means there are natural consequences, which means if you do interact with the police, even through no fault of your own, they can take you in because these are the rules we agreed upon in the smart people meeting that you weren't invited to.
Channel where I do Somebody did. Somebody had her fucking drunk, pissed out, humiliating her on the fucking car.
Stop kicking. Anna, stop.
Oh, I forgot that this is her too. Yes, Anna has apparently a whole series.
Doing that.
Yeah, it's a private party that did that, not us.
The private party. It wasn't the police?
Correct.
It wasn't the police that did it.
Correct. Somebody.
Okay, sir, to explain and clarify, body cam footage is or can be, accessed by the public through a Freedom of Information Act. I am sure that you are aware that these, are ostensibly paid by taxpayer dollars and therefore kind of our property. So, yeah, if you act like a jackass, we basically can pay the police to get copies of your recordings. Welcome to America.
Somebody applied for an open records request for that department, and the department released that video.
Yeah, and there was a police department. It was a police department.
It wasn't ours.
You guys are enjoying doing it.
Not really.
Are you guys glad doing your job? You guys glad
Not
being
today,
a police
dude.
officer?
Because I was drinking, and they kicked me. Mom kicked me out of her house because I was drinking, and Ethan pushed me down the stairs. I didn't do anything wrong, Dad. I didn't do anything wrong. Take me home. I didn't do anything wrong, Dad. Dad, I didn't do anything wrong. I'm not on any drugs. I didn't do anything wrong. Please come get me. Please, I'm begging you. Then take me back to Mom. Dad, I'm begging you. Come get me. Please. I'm begging you. It isn't my fault, Dad. I'm being honest.
No. I'm just...
No, she is totally being honest. Nothing has ever been her fault, except that Vong is totally making it her fault. So it depends on who you ask, whose fault it is, because it's either totally not her fault or totally her fault, depending on who you ask.
I'm just asking because
I'm not being sent anywhere. No, fuck that.
Okay.
Look at it right here. This is the prime example of white supremacist and Asian, right?
I don't know what that means.
She's white. I'm Asian. I'm sitting here, and she's sitting out there.
You fail to listen to me when there's other people involved with her and not me. I'm involved with you because I talked to you and found out you had warrants. So I am dealing with you, not her. He is dealing with her, and other people are at the scene dealing with that to figure out what we're going to do with her. So that's none of your business at this point. Are we done with it now?
Well, if you still want to debate with me, I'm still here.
I'm not debating nothing. I'm telling you how it is, and you're the one that keeps complaining.
Must be a new cop, huh?
Nope.
How long have you been doing your job?
None of your business.
You proud of it?
Proud of what?
Proud of the job. Doing your job.
I don't know what you're trying to get out of this conversation.
I'm asking you, are you proud of what you're doing?
It's almost like if you don't respond to him, it will piss him off, but you won't have to debate him. It's almost like if you let him talk to thin air. Now, I know it's hard, believe me. I have done this rodeo with 6 toddlers. I understand. You are tempted because you're like, you know what? The amount of stupid flying out of his mouth hole should be stopped. But if you don't pay attention, they will eventually tire themselves out and take a nap.
I choose not to speak with you right now because of your behavior.
I'm just asking you a question, You must be proud of what you're doing, right? How about you, big man? You proud of what you're doing?
That was rude.
What's your name then, big man?
It's none of your business.
No, I was just trying to be polite here.
You're calling him big man. That's not polite.
Oh, he's a pretty big guy.
Oh my God, cop. No. See, If you are going to stop engaging like you threatened, then you have to stop engaging. We don't negotiate with assholes in the backseat of police cars, and we don't negotiate with toddlers. It seems like the jury was asking for a list, like an itemized list of the exhibits. And the defense was not too happy with some of the, basically some of the pictures from the labs, the bench paper being called butcher paper. Obviously, in the context of this case, might not be the greatest thing to call it butcher paper, but it is what it is. I have checked all over and ChatGPT. I have gotten no clear answer as to whether the judge will allow them to continue deliberating after 4. I plan to stay on until about 5-ish. And then I am going to need to take a break for dinner. And, if we get a verdict, I will go ahead and hop on. But we'll be here till 5-ish at least.
Very observant, I guess.
Thank you much.
Hey, Anna.
No.
Anna, you're still not free to go, okay?
I don't care. I'm going with my dad.
No, you're not, okay? You're still not free to go. You're not free to go,
Okay,
okay?
then when am I free to go?
I'm telling you, we got an officer coming. We got to talk.
Coming?
They're on their way. Can you stop raising your voice at me? They're on their way, okay? Anna, you don't need to be like this, okay? Anna, I'm gonna put my hands on you if you don't stop walking away, okay? I'm not gonna play this game with you, all right? Okay, that's fine. You can call me whatever names you want me. That's fine. That's okay. That's fine. If that's what you think, that's okay.
Because that's what I think. That's the truth.
Okay. Are you Anna's dad? Yes. Okay. All right. So we got into I guess a physical altercation with mom at the apartment, and then her sisters. There's some sort of allegation of some kind of physical altercation. I don't know any specifics about that. But we got an officer over here, coming here to talk to Anna.
Ethan shoved me down a staircase. That's the physical altercation that happened. I was trying to run away because they said they were going to call the police on me because I would leave mom's apartment because I was drinking. So Ethan shoved me down a fucking staircase.
Who is this Ethan? You didn't tell me anything
My
about that?
My sister's boyfriend.
Sister's boyfriend? Okay.
I didn't do anything wrong. I didn't. I swear to God. I swear on Buck's life. I didn't do anything wrong. Where's the police that's gonna talk to me?
And now they're on their way. Okay. I can't tell them to hurry up anymore.
I think Dad drove there.
I understand that. They're right there.
They're. Oh, goddamn phone. You broke my fucking phone.
You know what? You should just really watch your tone.
I can't when all this shit's happening to me.
Vaughn was then transported to the jail while other officers arrived to assist with Anna. Eventually, the officer that spoke with her mother about what happened earlier arrived at the traffic stop.
Where's the police at? Can you go get them?
They're right there.
Then go get them.
Hey,
Anna,
stop.
I'm not going to wait here much longer. I'm freezing my ass off.
Again, y'all, let me just tell you that this little girl must have been raised with gentle parents, because can I explain to you how long I would be in the ICU if I talked to my parents like this? There would be no Mo in the deep end. There would be no 6 feral children. I would still be I'd still be doing, the Jane Fonda workouts unconscious with my mom. Now, I'm not saying that maybe you should be terrified of your mother, but maybe a little healthy fear would stop attitudes like this.
You're still not free to go, so.
Then can you go get them?
Stop being so disrespectful.
They're right there. I literally just told you. No, I don't have to listen to you, okay? You don't make the rules here, Anna. You're 18. You're an adult now.
What's going on?
Hey, Kuchen Rider, you're Anna.
Yeah.
We're gonna take you. So you made some comments earlier.
Who said that?
Your sister and your mother.
Incorrect.
And we have some evidence.
What's the evidence?
How cooperative are you going to be right now?
What's the evidence?
Officer, I'd like to speak as a keen observer of the human condition and behavior. She is not going to be at all cooperative. at all.
Messages that you sent both
Where?
of them on phones.
Let me see.
We have pictures of it.
Then let me see.
You don't have to see that
Then
right
let me see
now.
before you guys sent me there.
You mind giving us a little bit of space here?
When asked for her cooperation, she turned away and attempted to flee, but was quickly decentralized.
I would like to see the messages before you send me there. Please, I'm not, no, I'm begging you, please.
So, Anna.
I did not do anything wrong.
Anna, release your hands, okay?
No.
Release your hands.
No,
Bring
I'm
them
freezing
down
my
at your
ass off.
sides.
I'm not gonna release my hands.
The
Anna,
sooner
please
that
don't
you
fight with us.
cooperate with us, the sooner we can get you in a squad.
We
All we're
really do
doing
not
is
want to do
taking
this.
you
Anna,
down.
If you're gonna run, commit. I mean, and look, I'm not the most athletic person ever, but you telegraphed that a whole hell of a lot.
You take her left. I got her legs. I'm gonna walk her. Legs are bent and flexed. Take her. Yep, stop resisting, Anna. Stop resisting. We don't want to hurt you, okay?
Anna, give me your arm.
Please stop. Enough. Release. Release that left. Yep. Just let it out.
Can I have my vape, please?
No, you're resisting.
Now look, as one addicted person to another person, this would not be the time to ask if you could have your vape.
No, can I have my vape?
Nope, not while you're like this, Anna. There you go, Wade. Good job.
I'll cooperate if you let me have my vape.
Nope.
I'll cooperate.
We're way past this. Is your vape right here in your hand? I'm gonna hold on to this.
Move your arm.
When you relax, I'll let you hit it, okay? Got it out? Yep. Yep. What do we got here? Just the juice?
That's the pod for the...
Part of the reason why we gotta do something about this today. We can't ignore it.
You guys are gonna kill me.
Why would we do that?
Kill you, Anna.
Anna, just breathe for us, okay? We're gonna get you flipped over on your side real quick. Yep. Isn't cool.
You guys are gonna die because
What's
of me.
Dad's name?
I don't know.
Anna, what are you
stop
doing?
resisting.
That is not going to do
Anna,
anything
you are
for
gonna
you.
lose. Just stay with me. Anna, you're gonna lose. Please stop.
Then let me go. Let me hit my vape one more time.
Nope, girl, we're way past that.
Then let me hit my vape one more time.
212 and it's 95.
So Anna, you're gonna have some charges now today because of your behavior, okay?
Please let me talk to my dad real
So
quick.
flex this out.
Oh no, Dad is done with you,
Your dad's
sweetheart.
right there. You can hear, you can
I
see
didn't
us.
do anything wrong. No, you guys are hurting me.
Well, the sooner you stop
Dad, I didn't do
monkeying
anything
around
wrong.
here, the quicker we can get you.
I didn't do shit wrong.
Anna, you literally just resisted arrest.
Because you guys were trying to attack me for no reason.
No, we weren't. We were asking for your
I
cooperation.
directed my electron.
This woman's narrative is brought to you by the same attorney, by Attorney Tipton and Brian Walsh, where you can rewrite the narrative of your crime to whatever you wish it to be. The Choose Your Own Adventure Felony Excuse Book by Brian Walsh.
Electronically controlled device at you. You turned around and ran from us.
Yeah,
I didn't
because
even
you guys
use it
are
on
attacking
you.
me for no reason.
We were not attacking you.
Yes, you are.
No, Anna, you can believe whatever you want, okay? That's not
Let
how
go
it
of your
happened.
hand, miss.
Anna, please stop. Stop. What are you doing?
This
You
is.
guys are taking me for no reason.
Nope,
No,
you were
we're
resisting
not.
arrest.
At this point, you're under arrest now for resisting arrest. You understand that, right?
No, I don't.
Okay, that's okay. So you're on probation for resisting arrest times 4, right?
Okay, I will cooperate
No idea.
if you let
Thank
me
you.
hit my vape. Please just let me hit my vape.
Don't kick at us, okay?
Then please let me hit my vape.
We'll work with you. You work with
Please let
us,
me
all
hit
right?
my vape.
Anna, you work with us. We'll
I
work
will
with
if you let me hit my fucking vape, you
We will.
motherfuckers.
Relax. Sit you up.
Can I hit my vape, please?
All right.
I just want to hit my vape and then I'll cooperate. I'll cooperate if you let me hit my vape. Please just let me hit my vape.
Oh no, sweetheart. See, again, this is why I'm not a cop and why you don't want me to be a cop, because I'd take that vape right in front of you and I'd smash it. But Then again, this is why I never, wanted to be a cop, nor said I should be a cop. This is why I shouldn't be.
It's fucking dead. Oh my god. It's fucking dead.
Coming up 2 feet now, alright?
Once she was placed in the squad car, a protective helmet was placed on Anna's head to prevent her from hurting herself.
Okay, it's bad when they know they have to put the helmet
don't
on
touch
you.
my fucking head, motherfucker! Give me my hat back!
You'll get it back.
She always gets miscongeniality in the beauty pageant. I don't know how that is.
My hat back!
And when you have to wear the hockey helmet of shame.
I didn't do anything.
Everybody good?
Yeah.
Okay. All right. I'll follow you guys up.
Turn the light off, motherfucker!
202 sheriffs.
Turn the fucking light off! Turn the light off!
50.
The power of Christ compels you. What the hell in holy water? I'm expecting her to start, channeling Beelzebub. What the flippin' flapjack?
You motherfuckers. You guys don't know shit. I hope you guys go to hell.
Huh?
Can you turn the heat on?
I'm sorry, I didn't hear you.
Can you turn the heat on? I'm freezing my ass off, please.
Yeah, I'll crank it as much as I can.
Okay,
There's no
thank
control
you.
back here, so I don't know how much will come back here, but I'll turn it up as high as I can. You need water or anything like that?
No. Can you shut the door, please? I'm freezing.
Yeah. Hey, you gotta relax a little bit.
I can't.
You want us to help you walk inside where you'll be warm? And I've got the heat cranked. Are you feeling?
Oh no, see, I'd crack that window just a scotch bit, like you couldn't really tell. Y'all, again, there's a reason I know I would embrace my inner Darth Vader. So this is why I'm not a cop. But again, can we all admit, at least to ourselves, that maybe some people need Darth Mo? Maybe some people need, Sith Lord Mo in their life to teach them the benefit of going to the light side. I would use my dark powers for good, mostly. Okay, good and petty things, not gonna lie. A lot of petty stuff. But against assholes. And I feel like that would probably be the most productive use of my dark side powers.
Feeling anything back there?
Nope.
No? Let me change it a little bit. See if I can make some magic happen for you. All right, they're ready for
No,
us.
I'm
We're gonna
good.
roll.
I'm not ready yet.
What?
Can you please shut the door?
Nope,
I'm
we're going
freezing.
now.
I said I wasn't ready.
Not everything goes at your schedule, okay? Wassa, 1 car, Wassa, 2 cars, 1 female.
Hey, I'm not ready to go yet. Not ready. Can you shut the door, please? I just need 10 more minutes. Please. That's all I ask.
Anna, that's not how this works. We're going up, they're not coming down. The jailers are on their way down to retrieve you.
I don't know what that means.
At the jail, they completed a search of her and located 2 smoking devices commonly used for meth and THC.
My shock. You must imagine it.
The alleged cocaine found in Anna's bedroom was taken in for testing, which resulted positive for 12.92 grams of methamphetamine.
I mean, I'm not a measurologist, but that sounds like a lot of grams when you're not supposed to have any grams.
Vaughn was arrested and taken in on his DOC and failure to appear warrant. He was given a cash bond set at $200. Anna was charged with felony possession of methamphetamine, misdemeanor counts of disorderly conduct, possession of drug paraphernalia, and resisting obstructing an officer. All charges were as a repeater. Lastly, she was released on a $1,000 signature bond.
All right. When you're so drunk, you accidentally pick a fight with a cop. I mean, I have never been that drunk, but I am willing to live vicariously through other people.
truck. Did you see me in the truck?
Come over here.
No, come here, motherfucker. Come here, motherfucker.
Come here.
Come here.
When a deputy gets caught up in a violent argument, it's his word against the other person's. But it would take a long night of...
Why is it that... Why? In the last several videos, there has been a threat of pantslessness from people that we don't need to see pantsless. Why? Why is there always a threat to depants themselves on these videos?
Dealing with the situation before the full story could come out.
Your son will be dying. Curse this family, Lord, in the name of the Lord Jesus Christ.
Again, do we have a priest? Do we have a Methodist? Anyone? We need holy water, a rosary, and a Unitarian.
That's the way you did in the Old Testament.
Around 12:14 a.m. on March 24th, 2024, a Columbia County Sheriff's deputy ends up dragged into an argument he didn't sign up for at a Partyville Quick Trip in Wisconsin. Little does he know, this is just the warm-up act for what's about to be an eventful Sunday morning.
I don't know, you approached me.
No, I'm saying you're not putting gas.
Yeah, I was working on something. I just finished up a report.
You told me you were putting gas.
I was gonna get gas.
All right, let me see you put gas.
Is everything okay?
Are you okay?
I don't know, are you?
Are you okay?
How much you had to drink tonight?
I've been having drink.
3344 Wisconsin truck plate.
Are you chewing 97 sticks of gum? Could it be... If you're not drunk, then why are you chewing with your mouth open? Look, that is a triple felony crime right there in Mo's world. Like, oh! Okay, we've got movement in the court. Let me share this tab, open up, and...
Your Honor, we're back on the record in Commonwealth versus Walshe.
Thank you. As is my custom, at 4 o'clock, I send in a note on every day the jury's deliberating, asking if they want to stay until 4:30. That note will be marked as the next exhibit for identification. And it gives them the option of staying until 4:30 or suspending and coming back on Monday in this instance, and they've elected to do the latter. So we'll bring them in, send them on their way.
All right, so we will be...
R for ID, so marked.
We will be deliberating on Monday.
Thank you.
So what we might do on Monday is we will look at the hearing for the DoorDash woman. And then now we will know going forward if this takes multiple days that...
All rise to the court. Jurors entering.
I'm going to go see Mom, but otherwise I will. Maybe on Monday if we're...
I understand we're probably all disappointed, but we have to remember, and this is something that was really hard to remember, my first case, the Letitia Stout case, you know, when all of us found all the guilty, we've been able to talk about this. We've been able to converse between ourselves at the end of the day or even during this trial and say, dude, what the hell is that? The jury hasn't been able to talk to each other, to confer, to even, you know, debrief at the end of the day and say, that was some effed up BS. Do you remember when Tipton said what? So I do think that it's easier to understand now, after ever having gone, you know, through trials, that with that kind of knowledge that they're not able to do all of that, they might have been just going through and sorting their notes today.
Court is back in session. You may be seated.
Welcome back, jurors, to the courtroom. Again, thank you for your work today. And I'm going to send you on your way for the weekend. I remind you, jurors, that the rules still apply. They will apply until you reach your unanimous verdict. I'll remind you of those rules now, jurors. Don't speak to anyone about this case. Don't do any research about this case. Continue to have open minds as you evaluate the case and as you wait to see if you are going to evaluate the case. Don't access any social media or any news media over the weekend. Hope you have a good weekend, get some rest, and we'll see you back here ready to work on Monday morning. Thank you, jurors.
Thank you.
All right, so the board, please. Jurors, follow me.
All right, so it looks like we will be coming back on Monday, but keep in mind that these are 12 people that are having to, look at each other and really for the first time in their life be responsible for the future of someone's life. I mean, they're not supposed to think about the consequences or the sentence, but I know when I had jury duty and it turned out to be a kind of silly case, I was still extremely nervous because I knew that whatever choice I made, could have an incredible impact on someone's life. This was someone's life on the line. And I remember, even though in Indiana, we are allowed to start deliberating as soon as the trial starts, we don't have to wait to deliberate. We can start debriefing and talking right away, which is not common in any other state. I do remember when it came down to, doing a verdict, we each sat there and, we all agreed, but we wanted to make sure that everyone, had a point. Sorry. I was yelling at the youngest, most feral to put a shirt on because he's always the kid that has no body fat on him and he swears he's freezing, but he doesn't want to wear any clothing. So I basically he's basically the kid from Wild Thornberries. That's my son. That being said, I do think this is a lot to think about. This is an incredibly dense case. I had a full notebook, a full 80-page notebook, double-sided pages, so 180 pages of notes, and I know I didn't catch everything. So I imagine that there's just an incredible amount of detail, and people want to do a good job. So as disappointing as it is, you will get to hang out with me on Monday as we dig out from Snowpocalypse 2. Apparently we're getting another round of snow this weekend. So I will be hanging out with Shizzy this evening. I don't know if I'm going to do Friday night with Expert just because this has already been a super de-duper long day, but we will see there. We will see. I am going to head off of here, make sure that the ferals are, well, just still alive and not super glued anywhere. And thank you guys so much for joining, for hanging out with me. And so on the pipeline for Monday, Mornings with Mo at 8, and then at 10:30, we will go ahead and start. And we will probably do the hearing for the DoorDash girl. And then maybe go into this Ohio case or maybe look at a new case if there's any new ones starting and just go from there. So that's kind of what we'll do while we hang out for Verdict Watch. Unless there's a case or trial that you want me to look at, put it in the comments below or, just reach out to me on the Twitters and all that other stuff. I am going to get off of here, maybe catch a quick nap and then hang out with Shizzy tonight at about 8. Before Friday night, because we are your pre-game source of shenanigans and hilarity. I will be there. Hopefully you'll be there. I'm going to go make sure my ferals haven't tried to burn down my house, which in all fairness is possible. Bye, you guys.